I got a PayPal thing.
Getting up there.
I've asked Commissioner Butler to lead us in a word of prayer right quick.
Lord, we come to you today to do your work, to watch over the citizens of this state, the employees of this agency, and to bolster one another in the work that we have to do today, Lord. Give us a clear mind, impart your wisdom upon us as we make the decisions that make for a better state, a state that you've named that we live in, and we're thankful for that, Lord. The best state in these wonderful United States. We ask you to prepare our minds as we go about our business today. Watch over us and protect us as we go about the work of governing this great agency. And protect us as we go home this afternoon. In your name we pray. Amen.
It is 8:55. I'll call this meeting to order. Ms. Mahon, if you could call roll, please.
Mike Hernandez.
Present.
Tom Butler.
Present.
Helen Collier.
Here.
Rick Figueroa.
Here.
Catherine Roquel.
Here.
Robbie Shaw.
Here.
Deborah Yurko.
Present.
We do have a quorum at this time. Actually, we have a full commission. Let me jump over to the item I. If our internal auditors will come forward, we're going to actually have this presentation done, and then we'll go into executive session.
We're
So
actually going to go on H,
that's the state audit.
and that's the one we're doing?
No, we're doing the internal audit.
That's what we're going to go, that's going into executive session. This is one we need a blessing on that we've already submitted.
Right, but I thought we only get them out.
Item J?
Oh, here it is. Item
There
J.
it
I'm
is.
sorry.
Item J.
I'm glad you said that. I was fixing,
Yes,
okay.
item J.
Scratch item I. We're going to do item J. Thank you for our internal auditors correcting the commissioners. So, proceed.
Yes, Mr. Chair, members of the board, what you have on item J is the fiscal year 2016 annual internal audit report. This report was discussed with the audit work group on October 25th during a conference call. We discussed all the comments and recommendations that we followed up on, because that is what this report is it includes the comments and recommendations that were included in previous years' audits that had not been implemented in previous years. So based on that, we discussed it. We discussed the implementation status, and they accepted it at that meeting. So if you have any question, I'd be happy to answer them at this time.
Any questions?
This is Commissioner Deborah Yurko, and I am basically seeking our blessing. I'm assuming everyone's had a chance to review the annual internal audit report. It was formally submitted by its deadline, which was November 1st. Is that
1st.
correct?
Yes.
So it's more of a kind of reconfirmation of what was submitted to meet with the timeline of the State Auditor's Office.
State Auditor's Office, Governor's Office, LBB, and Sunset, all those agencies.
So, and it is a recommendation by the
By the
Finance
Audit
Audit Committee to
Yes.
do it, and to go ahead and accept it. So, if there's no questions, a motion would be in order.
So moved.
Second.
We have a motion, and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you for your work.
Thank you.
We will now go into executive session. Go back to item C. Executive session consultation with the Commission's attorney pursuant to section 5510711 of the Government Code to receive a briefing from legal counsel concerning pending or contemplated litigation or settlement offers. Item 2, advice from the Commission's attorney on legal matters authorized by 5510712. Number 3, under section 55107 of the Government Code, discussion of personnel matters. And 4, under section 551076 of the Government Code, discuss security audit. So we'll now convene into executive session.
agree. I agree. Mike? You may need to go back and- I think it's this one.
It is 10:05. We are now coming out of executive session. Commissioners, I think probably the only thing coming out of executive session that which would be item D, which actually relates to item I, would be the review and discussion of the internal audit on the information systems. You received a report from our auditors, and also we visited with IT. At this point in time, I guess if we want to go ahead and accept.
I don't recall that there was a need to accept it. I think we just had to.
Commissioners, Mr. Chairman, Commissioners, this is Brad Bowman, General Counsel. There's not a requirement for action by the Commission, but
Okay.
it's there for any discussion.
Okay.
Any discussion that the Commissioners want to have on
Oh,
that.
that's right. It just says review and discuss. Okay. So what I will do, I'm going to move to item I right quick. If you don't have any discussion on item I, then we'll just go ahead and move forward and count that as
Sounds
done.
good.
So, no discussion? Okay, we've taken care of item I. Let's move on to item E, approval of the minutes. Commissioners, you've received the minutes in your packet of information. A motion would be in order.
I move that we accept the minutes as written.
We have a motion.
Second.
Second, all in favor signify by saying aye. Aye. Those opposed, motion carries. Let's move on to the contested cases, F1. Ms. Cox, Karen Cox.
Good morning, Commissioners.
Before we begin that, anyone that is here to discuss their contested case in the agenda item, if you have not filled out one of these forms, make sure that you fill them out. They're sitting on the desk on the side over here on the table, and get it to Ms. Mahon, who's sitting over here in the corner, if you have not filled it out yet. So if you have, we'll call you up and you'll come up at that time. So, Ms. Cox, go forward.
Good morning, Commissioners. The case before you stems from a site investigation conducted by the department investigator on February 10th of 2016. During that investigation, the investigator questioned the respondent about the procedures the respondent used to clean his foot spas. The respondent admitted that his salon does not perform the required every other week cleaning of the foot spas, where they fill the basin, fill it with, put the cleaner in it, run the water in it, and let it soak. The hearing was conducted on June 28th, 2016. The ALJ found in favor of the department and imposed a $2,000 fine for 2 violations of Rule 83.108D. The department recommends adoption of the PFD as written. May I answer any questions?
Any questions for Ms. Cox? Is there anyone here representing Annie's Nail and Spa? Commissioners, the motion be in order.
I move to adopt as issued.
We have a motion. A second will be in order. Second. Second, all in favor signify by saying aye. Aye. Those opposed, motion carries. Item 2, Mr. Sharp. Thank you, Karen. Go right ahead. Did you guys fill one of these out?
Yes, sir.
Fill one over there, but. Thanks, sir. Mr. Sharp, proceed.
Morning, Mr. Chairman, Commissioners. My name is Ken Sharp. I'm an enforcement prosecutor for the Enforcement Division here at the department. The respondent in this case is Staristo Casiano. The department proposes a revocation of the respondent's apprentice electrician license and his registered air conditioning and refrigeration technician license. In September 2014, the department issued the respondent the apprentice electrician license, and that license expired in 2015. The department also issued the registered air conditioning and refrigeration, the ACR, technician license to the respondent in May of 2014. In September 2015, the respondent renewed that license. The renewal application asked the respondent whether he had been convicted or placed on deferred adjudication since his last license had been issued, and the answer given on the application was no. In January of 2012, the respondent pled guilty to a felony hit-and-run accident offense. The court placed him on deferred adjudication community supervision for 5 years. However, 8 months later, in September of 2012, the court revoked that community supervision, found the respondent guilty, and then sentenced him to 2 years in prison. This accident occurred when the respondent ran a red light and struck a car in an intersection. He stopped and asked the other driver if she was okay, and she told him that her arm had been hurt. The respondent testified at the hearing that he then realized it was not yet 5 o'clock, so he decided to drive his truck to a body shop to see about repairs. According to the respondent, no one had ever told him, not even in driver's education classes, that he was supposed to stop and call the police and remain at the scene of an accident to assist the injured or exchange insurance information. The respondent testified that after he left the accident scene and drove some distance away, he thought about it and decided to turn around and go back. He said before he got back, though, a trooper stopped him and arrested him. Excuse me. That was the respondent's testimony. The police report indicated officers located the respondent's unoccupied vehicle in an empty field down the road from where the accident occurred. An officer located the respondent at a taqueria across the road. In stark contrast to his testimony, the respondent told the arresting officer he fled the accident scene because he was afraid. The respondent's next offense involved another hit-and-run accident. In August 2012, 7 months after his court appearance for the first hit-and-run offense, the respondent drove a vehicle while intoxicated. The vehicle crossed the oncoming lane, left the roadway, and struck and damaged a utility pole and a telephone service box alongside the road. At the hearing, the respondent testified that after the collision, his vehicle merely rolled away from the scene, which is why it was found 4 blocks away. He said he was a short distance from his house, so he went home and got another vehicle to tow his damaged car home. When he returned, he saw an officer arrive, so he approached the officer, who eventually arrested him for driving while intoxicated and failure to report the accident. The respondent testified at the hearing that no one ever told him, not even in driver's education classes, that he was supposed to report the accident since he had not hit a person or another car, and according to him, the pole just barely grazed the vehicle that he was driving and was not damaged. However, he admitted at the hearing that initially he did not know whether there was any damage to the pole because he did not look at it until after the officer had arrested him. And finally, the respondent testified that no one ever told him, not even in driver's education classes, that the law prohibits operating a motor vehicle while intoxicated. In contrast to the respondent's testimony, the police report indicated the collision damaged both the utility pole and the telephone service box. In September 2012, the court sentenced the respondent to 20 days in jail for that second hit-and-run accident, and then 180 days for the DWI conviction. In June of 2015, the respondent was convicted of theft of property. Excuse me. He testified that he had been at a hospital visiting his grandmother, who was uncomfortable and needed some assistance when he was there. He said the nurse in the ward was no help, so he walked through the entire hospital and checked all of its offices, even the emergency room, but found no other staff or employees there. He said he then entered a room in which he saw a video projector, a keyboard, and some speakers. The respondent testified that he took those items, put them in the trunk of his car, and then returned to his grandmother's room. He said he thought this would get the attention of someone who could help his grandmother, even though, according to his testimony, there was no other staff or employees in the hospital. He said a short time later, some officers approached him to investigate the theft because they'd seen it as it was captured on surveillance video. The respondent testified at the hearing, under oath, that he fully cooperated with the officers in their investigation when they approached. However, according to the court records and to the respondent's own eventual admission, when the officers approached him, he gave them a false name. The respondent pled guilty to the offense and was sentenced to 1 year in jail, which was suspended for 2 years. The respondent committed that theft offense in December of 2014. One night, while he was out on bond awaiting trial for that offense, he forced his way into the apartment of a woman and her 3 children. The respondent testified that he had gone to the apartment complex with some friends for a party, but when they arrived at the complex, his friends ran away from him and had not told him where the party was going to be held. He said he never made it to the party because a passing police officer asked him if he was cold and would like to sit in his patrol car. When the respondent accepted the invitation, according to his testimony, the officer arrested him for public intoxication. The police and court records indicate the woman whose apartment the respondent entered was in the shower at the time. 2 of her sons discovered the respondent's entry and struggled with him until they managed to force him out the back door where he had come in. The respondent then went to the front door and tried to get back into the apartment. One of the children caught the attention of a passing police officer who stopped and arrested the defendant, or the respondent rather. Now, he was originally charged with burglary of a habitation, but agreed to plead guilty to criminal trespass. The respondent said the judge refused to accept the plea agreement and demanded instead that the respondent plead guilty to burglary of a building. He testified, again under oath, that the judge told him he would have to sign the agreement the judge wrote or remain in jail until he did. Well, he did plead guilty, and the court sentenced him to 6 months in state jail. Now, the ALJ, in this case, acknowledged some of the disparities between the respondent's testimony and the court and police records, as well as some inconsistencies in the respondent's own testimony, some of which she referred to as, and I'll quote, illogical inconsistencies. The ALJ placed more emphasis on the respondent's description of his current employment and personal relationships, as well as the testimony of witnesses who appeared on his behalf. The ALJ gave the respondent's burglary conviction very little weight because the ALJ, in spite of the law, in spite of the respondent's guilty plea, in spite of the conviction, and in spite of the limited authority of the ALJ, she made her own finding, an own independent finding, that the respondent had no intent to commit a crime. Also, the ALJ said that a summary of the victim's description in the police report, a summary of the victim's description did not appear consistent, but ironically, she disregarded the inconsistencies in the respondent's testimony and between his version of events and those of the investigating police officers and witnesses. Instead, the ALJ focused on the respondent's claim that he should retain his license because he's never going to break the law again. But the ALJ did not comment on the fact that he committed his 2 most recent offenses while he was licensed by the department. The ALJ gave significant weight to the respondent's letters of recommendation, which included a letter from his probation officer, which shows apparent progress. But they also included a letter from his defense attorney, who has a duty to say good things about him, letters from co-workers who say he does good work, although his work quality is not an issue here, and even a letter from a friend who attributed all of the respondent's offenses to simply being in the wrong place at the wrong time. And most, if not all of the letters, refer to the respondent's needs, the needs of his family or his employer. Other than the letter from his probation officer and the one from his criminal defense attorney, none of those other letters mention the type of criminal offenses he committed or what, if anything, he has done toward rehabilitation or development of honesty, integrity, and trustworthiness. The respondent himself wrote a letter in which he expressed deep regret for the crimes he committed. That conflicts, however, with his testimony in which he downplayed the criminal aspects of his actions, even to the point of denying that he had done anything wrong or knew that what he did was wrong. The respondent committed 2 crimes that appear in the Commission's guidelines, burglary and theft, which are the 2 most recent. The 2 hit-and-run and the DWI convictions are not guideline crimes, but they do fall within that 5-year time period that makes them applicable to the Commission's determination. More importantly, the respondent's evasion of responsibility for the 2 hit-and-run collisions reflects a lack of trustworthiness. His illogical inconsistencies, as the ALJ referred to them, reveal a lack of honesty and integrity, as does his theft conviction, even if one decides to disregard the burglary conviction. But in spite of his conduct and his record, the ALJ found that he has honesty, integrity, and trustworthiness. The ALJ essentially recommends that you simply disregard the respondent's criminal history and the evidence showing he lacks honesty, integrity, and trustworthiness and allow him to remain licensed. The department asks you to reject the proposal for decision and revoke the respondent's electrician license and his registered ACR license, technician license, consistent with the department's exceptions that were filed in this case. Now, I know that was kind of long, but it was a long hearing, and even a lot has gone on since then, so I thank you for your attention.
Any questions for Mr. Sharp at this time? Mr. Hopkins,
Yes, sir. Good morning, Commissioner.
morning, you're here representing,
My client, Mr. Cassiano.
okay, if you don't mind, just state your name for the record, and is Mr. Cassiano not going to be speaking?
He'll take questions, sir.
Okay, but we need him to fill out one of these
Okay.
two also if he's going to. We can get one for you here
Okay.
afterwards, make sure he gets one filled out.
If I mind, Mr. Chairman, if I can have him to move that box, it's a safety issue. I'm just a pet peeve of mine. The boxes
Right,
that
he
Chip has
will.
it.
Actually, he visited with me earlier. There's a book that's in there he wants to pass out to the commission. Mr. Sharp, my understanding is that you're okay with that? Are you fine with the information that he has in there to get to the commissioners?
Yes, we went through it and what
Okay,
we
so,
agreed on. Thanks.
before you do that, real quickly, I'm sure you're aware, being a former employee of TDLR, the only thing that we can take into consideration is that information that was presented at the SOA hearing. Anything outside of that, I'm sure that Mr. Sharp and our general counsel will step in and say that was not presented in the hearing, or question whether it was presented in the hearing. Have to make a decision on that, but if you can, just keep and confine your comments and anything that you say that was only held at the SOA hearing.
Yes,
So,
sir.
Okay, if you don't mind, just state your name for the record.
Franklin Hopkins, and representing my client, Steristo Cassiano.
Okay, if you don't mind, go ahead and pass it.
Thank you.
Thank you, sir.
Thank you.
Thank you.
Good morning, Commissioners. We appreciate your time today, my client, Mr. Cassiano, and I do. And a lot was just said in the opening by Mr. Sharp. But one thing to keep in mind is, and we'll go through that, is the reason we have SOA hearings is for an evaluation of the evidence. The SOA judge got to not only hear from my client, Mr. Cassiano, who testified openly about everything and was cross-examined extensively by Mr. Sharp, but she got to hear from his family members, some of which here today, his Uncle Joe and his fiancée, Miss Reyes, and she got to evaluate the evidence. One thing that was shown during this case is actually department investigators never talked to my client. They never talked to his employers. They never talked to his families. They never talked to the people at his old college, where when he got out of jail, he went back to school, he pleaded with the dean, and he let him back in. So I ask you to take that in consideration about the evaluation of the evidence, because there's always obviously two sides of the story and things can be presented a certain way. Now, I want to talk about, and it's in there after the index. These index are just to briefly go over, the first 14 are exhibits that were admitted at the hearing. Number 15 is the PFD. 16 is the order number 2 denying Mr. Sharp's motion. And number 17 is the minor findings of facts and conclusions of law the judge changed. I'll talk about 15 a lot and might ask you to look at there when I talk about a page. And you probably already have the PFD as well. But after this index, I printed this out yesterday. It's about the Department and Regulation, Department of Licensing Regulation. It's TDLR's vision and mission. And you can see it right there, and we actually have it up on the board back here. But I think one thing we should ask ourselves is if the mission of the department is to protect the public and to protect customers, and Mr. Cassiano has been shown by an independent SOA judge not to be a threat, then revoking his license protects no one. Staff has really been on punishing Mr. Cassiano, but there was a finding again by the ALJ that he is not a threat. Now, finding of fact, actually number 24 says he's not a threat. And actually, the judge talked about, it's on page 17 of the PFD, so that's page 17 of tab 15, is that Mr. Cassiano has proven his honesty, trustworthiness, and integrity for a license, and Mr. Sharp even admitted that. Now, Mr. Cassiano again provides for his family. One thing we'll keep in mind is those first 2 incidents when he was a teenager. Mr. Cassiano is now 24. Those 2 drinking incidents, one was when he was 18 in high school as a teenager, a senior in high school, and the second one was when he was 19. So I ask you to keep that in mind. The teenage indiscretions there. Now, to tell you a little bit about this case and about Mr. Cassiano. First of all, Norfox, his employer, loves him. They know about this, and they wrote a letter on his behalf. And, I mean, he's in the Norfox gear today. They know he's here. Not one customer complained during his work. And again, he was youthful during these offenses. And they all occurred off the clock, personal issues. And I would argue he's already been punished. He was punished by the state. DA's offices that are licensed, their goal is to regulate that. That's in their jurisdiction there. And one thing he testified is, and it makes the commission feel safer, is he only does commercial work. That's all he does. He works at places like Walmart, big buildings. So who supports him? Who is in his life? Because I think one important thing is we can't look at the past but at the future. How can the commission be assured that this won't happen again? Well, he has a very strong support network, as evidenced by the exhibits 1 through 7. Probation officer says he's a model probationer. His supervisor loves him. They want to keep him around despite all this because he is that good of a worker. Family and friends obviously support him. You saw something from the college he attended supports him, so he has a strong network now. Now, he has some lapses in judgment, yes, but he clearly shows the desire and ethic. And one thing that's also important is rehabilitation potential. It's something that's talked about a lot. The judge even talks about in her PFD that he needs to keep this job because it'll help him continue his rehabilitation. You know, Mr. Cassiano testified, and it's someone in the PFD, he used to hang out with his friends a lot and drink, but now he has responsibilities. He was a young man, now he's a grown man. Now he goes home and plays with his child and his spends time with his fiancée. And so he's not this young teenager anymore doing these crimes. But what all exactly did the judge find? Well, one thing I would like to direct the commission's attention to, besides him not being a threat and that his license should be renewed, is page 15, which is of tab 15. And that's, despite his criminal behavior and untruthfulness on his application, there are strong reasons to support leniency in this case. I'm not going to read them verbatim, but it's that his crimes appear to be ill-advised. He has 7 siblings and his parents, divorced, and he's the first of his whole family, extended family, to attend college. He was 22 when his most recent crime was committed. He's still a very young man. It goes on, but how his former supervisor and expert on page 16 support him. And Mr. Sharp even admitted that. His work quality is not an issue here. And one thing I think the commission should keep, the department, should keep in mind is that, we want to keep, right to work state, want to keep people employed, keep them safe, keep their families safe, but also put them to work, enable fair competition, things like that. And he has that right now. He's doing that in Texas by his current job. And finally, I want to talk about the factors, the occupation code, the 53022A and B factors. Now, the judge talks about these on pages 4 and 5. And you've heard them all before, and I won't go through all of them, but it's the age of when these happens. What he's done afterwards. You know, I think a true test of somebody's character is how do they bounce back. Well, he hasn't let down. I mean, he works 80, 100 hours a week. He works insane hours. So he's kept going. He's provided for his family that he has now. So he showed in that aspect maturity, but also rehabilitation that the judge talks about. He needs to continue that rehabilitation. The best opportunity for that is for him to keep his license. Also, the judge, I believe it was on page 13, says Mr. Cassiano admitted responsibility and accepted fault for all of his crimes. I asked the commission to consider that as well because that's obviously a big testament to his character and what he talked about at the hearing. And finally, a couple more notes to hit on what the ALJ talked about. You know, his work life presents a different perspective. He acknowledged that he needs to stay on the right side of the law. The staff failed to prove that it's proper to revoke his license. That's what the ALJ said. And again, he's proved his honesty, trustworthiness, and integrity. And that, you know, the opportunity to license presents him, again, is good for his rehabilitation to continue. And therefore, we respectfully ask that Mr. Cassiano be able to keep his license, continue to be a benefit to the state of Texas, its economy, and to serve his family. And I guess actually the last thing I would talk about is some of the things staff hit about. Now, one thing to keep in mind is Mr. Cassiano did testify at hearing, so he was cross-examined. The judge asked him questions, if I'm not mistaken. So, you know, and again, the purpose of SOA is for somebody who's never met the person, who has no stake in the game, to evaluate the staff's case and the respondent's case. And again, keep in mind the age he was, but, you know, staff talks about the second hit and run. There was no person involved there. That was a highway fixture, a pole, or something like that. So that's something to keep in mind. The other offenses, you know, he acted irrationally sometimes, but again, he's matured. But just to keep in mind, for those offenses, you know, they were presented a certain way. However, you know, one of them, I think it was his grandmother, wasn't getting the care she needed to in the hospital, so he was trying to get the staff's attention. Was it stupid? Absolutely. But he got their attention. His grandmother got treatment. And the fourth one was, you know, and he doesn't do that anymore, he was partying with some buddies. He couldn't find, he testified he couldn't find the right apartment. He went into the wrong one. Yeah, he had too much to drink. And he testified he doesn't drink anymore. He doesn't do drugs. So, I mean, obviously, you know, he's changed his life. But again, I ask that we look to the future. Is he a threat? No. How do we know that? The judge has said it. She's shown he has rehabilitative potential, and his rehabilitation can continue. And with that, I'll open up for any questions or concerns or anything. Appreciate your time.
Any questions for Mr. Franklin?
I
Go
have
ahead.
some. Okay. In one of your pleadings, you said that he acknowledged 3 of the offenses. It says on page 16, he disclosed his 3 driving-related offenses. I'm confused. What's the third one? I have 2 driving offenses.
There are
And
2.
then I have 2 theft and burglary type offenses.
Yes, ma'am, that's correct. There's 2 driving offenses.
There's 3. There's the 2 hit-and-run accidents and the driving while intoxicated.
So there's,
So is the hit and run part of the DWI?
It was a hit and run and DWI combined, that took place.
Combined,
Two
so it's the
different
same.
incidents.
2 incidents,
Yeah.
okay, gotcha, okay.
there was, if I may, I think you mean he was charged with 2 things for 1 incident. Is that what you're trying to
Right.
say?
I think that's what happened.
Okay.
And I'm trying to understand, I understand your youthful indiscretions at 18 and 19. How old was the respondent in August of 2015?
1 moment, Your Honor. Ma'am, excuse me. I believe he was 22. I think that's what we have it's in the PFD on page 7.
Okay, and then how old is he now?
He's 24.
Okay. Well, you clearly have a large support team, which is a positive thing. Man, you're still young. I mean, 2 years since a year since the last one's not that long ago. Okay.
You made several statements that he's not a threat because the judge said so. I say I'm the best commissioner, but I think they may argue up here also whether that's the case or not. So whether the judge says that he's not a threat, doesn't mean that he's not a threat. And you made also a statement that he does only commercial work, but the license that he has is not just for commercial though, is it?
No, sir, it's not.
So he has the ability to go into residential.
He does, but he testified, I mean, that's what they keep him as, is he does commercial. That's kind of his skill.
I understand what they keep him as, but if times get hard, he could go residential.
He could, but one thing I would.
That's the only thing I'm asking, is he could go residential in the event that times get harder, he does that.
One thing, sir, that TDLR could do, I think it might be a staffing purposes, you could restrict him to commercial. There's nothing that stops y'all from doing that, actually.
You also state that his probation officer said that he's, quote, a model probationer.
Correct.
Does that not disturb anybody else but me, that he's actually on a probation, that he has to be considered a model probationer? He had to get to that point somehow or another, correct?
Correct.
To do that, I mean, to even be labeled as a model probationer.
Right, and that means he's compliant, obviously.
Right, but he got to that point.
Correct, yes, sir.
And that happened because of the incidents that he had. You also stated that one of the hit and runs was simply property.
I did, I just wanted to make sure that, I think sometimes when we think hit and run, we think a person. I just wanted to clarify
Right.
that.
But what caused him to hit the property?
It was a drinking incident.
He was intoxicated.
Correct, yes, sir.
So we got that issue also. He was driving while intoxicated. So it's not just the fact that he was only hit property, because it could have been worse. I mean, we can always say it could have been worse. But the fact of the matter is that he was drunk while he was driving. And then the statements of that he's never heard in driver's education that you're not supposed to be drinking and operating a vehicle. I mean, have we not heard don't drink and drive? I mean, it's plastered everywhere. DPS does a great job plastering that everywhere. So the argument of saying that he's never heard, didn't know anything about it, wasn't taught, I tell you, that, to me, that's just filled with holes. I just don't buy that, period.
And yes, sir, I agree, and the judge didn't either, and Mr. Sharp obviously cross-examined him about that, and the judge noted that in there.
Right.
Question on that. When did you get your driver's license?
I got it when I was 16, man.
Okay.
And I agree. I think that, while he has progressed and is progressing, I would just encourage you to stay on that path. But I tell you that there's been too many things happened that I see that makes it difficult for me to turn around and say, yeah, he can go on and keep going. You've got a lot of incidences. You say it's lapse in judgment, youthful indiscretion, but, if the last incident you had was 2 years ago, I mean, we're showing here that it was in
Consider you.
January of 2015, burglary of a building. And I think the statement was that you were intoxicated at the time when the burglary of the building took place. Is that correct?
Yes.
While I encourage you to continue on, I think that there is still some time that needs to be had before we actually see that you're able to do this work and be able to obtain a license. I've got some serious questions about your ability at this point in time to continue on with a license. That's just my opinion. So, I mean, the lapse in judgment, statement of lapse in judgment, yeah, we've had several lapse in judgments. Not just one, not just two, but several. And I find it difficult to understand why the AOJ would say that you're still fit to carry a license.
If I may, Mr. Chairman?
Yes, go right ahead.
Thanks. Within that 1 year time period, and I believe it was a comment that it's been good, behavior, you have the feedback for referral letters, reference letters, and so on. Has there been any training, workshops, reading books that helps to address the irrational decisions which leads to the drinking and so forth? Has there been anything of that nature?
Yes. No.
Could you elaborate for us?
Yes, well, I took a class that was required through probation that did help me on.
Mr. Frankie, could you pull the mic closer to us?
Yes, sorry, sir.
The class that I took helped me with my decisions and with reasons why, made it clear to me why it's not correct to do all these offenses that I've created against the state, against the people, and I completed it successfully. And since then, it's cleared my mind on just to continue forward and to progress in life and to continue providing for my family.
And that was one class that was a requirement, so any self-initiated since then, or continuing on, anything since that required class, which was dictated to you?
Since then, I've stopped hanging around with the wrong people, bad influences that lead to poor judgment, and I've rehabilitated myself by stop drinking alcohol and just to focus on the bigger things in life, which is family and growing to help out the community.
That's good to hear.
Mr. Cassiano, Mr. Chair, if I may. Speaking of family, how old were the children that you struggled with when you broke into their home?
On file, it said that there were, I believe it was a 3 and a 13-year-old, I believe.
3 and a 13-year-old?
Yes,
And
sir.
you were on bond when you did that?
Yes, sir.
Thank you.
Any further questions for Mr. Frank or Mr. Cassiano?
I have a couple of questions.
Mr. Shaw.
First, the number of years that I've been on this commission, this is probably one of the most fantastic binders that you put together, so I applaud you for that.
I'm sure it probably comes from experience of being.
You know exactly how to get to the commission, so I appreciate that. Couple of items on one of the letters that was written by the individual here indicates that he had 9 siblings and you mentioned 7, so which one is true?
I have 5 brothers, and I'm the 6th brother. So, and I have 3 sisters, and one of my older brothers passed away at birth. So,
Council, we might want to get your facts right when you address the commission the next time.
Yes, sir.
While I'm looking at this, I understand that you may have wanted some attention from the hospital staff, and I believe I'm in good health not to have visited one of those hospitals, but am I not correct that there's always some attendance somewhere in the hospital? So in order to get attention from the medical staff, do you have to burn down the hospital? Do you have to steal equipment? I mean, help me understand that, Counselor. Is that something that's normal?
No, sir. I mean, there could be other ways. He testified he couldn't find anybody. He was really upset. He was emotional. It was his grandmother. I think it was his grandmother, a family member. So he was irrational, and he did that. But you're right. There are other ways. Yes.
So, again, I'm trying to ask you this question. I mean, in the hospital, is there no other staff that you can get attention from?
I believe it was a smaller hospital, but there should be. He claims that he testified he couldn't find anybody.
Got you. Thank you.
Any further questions?
I'd like to make a motion, or try to make a stab at one, see if I can.
Okay, well,
So-
let's make sure we
Yeah.
got all the questions answered. Any other questions?
Yeah, no other questions, but definitely a good job of putting the reference letters together, so that's commendable in that regard, so I do appreciate seeing that.
And I agree. I think that the fact that you had a lot of reference letters will sway in that decision. We don't get that very often, and so to know that he does have a great support group helps out. Great job.
Yeah.
May I make one more comment before a vote?
Real quickly.
So, one thing I asked the commission to consider is, why do we have SOHO? Why does an attorney and their client go before an independent law judge, spend hours, and the judge, Mr. Sharp, testified? It was a long hearing, longer than most. Why do we do that? It's to paint a complete picture. And so I asked the commission to take the full body evidence in, not just maybe 5 minutes of testimony from Mr. Sharp, take the full picture, because I believe legally that our conclusions of law that the judge found are solid. She found those facts. Those were found under record. And obviously, I don't have if y'all have a proposed decision in front of you, I don't have a copy of that either. But I'm just saying, I think the rules of the law are solid, and you look at the factors, Chapter 53 of the Occupations Code, he meets those. His age, what he's done since then, his rehabilitation, that's what the focus is. So the focus, I don't believe, should just be to punish him, it should be, is he a threat? And again, we have a finding of fact that he's not a threat, and we have a finding that he has character and trustworthiness. So I just asked the question, why do we do all that and go through that?
That's the decision of the judge, right?
Yes, sir.
That's the opinion of the judge. The judge puts that forward,
Correct.
while we may have a different opinion.
Correct.
So that's how I answer your question.
Mr. Chairman,
Mr. Sharp.
if I might offer a brief comment in response.
Very brief.
First of all, we're not doing anything punitive here. That's not our job. What we're doing here, as I think has been indicated or acknowledged by Mr. Hopkins, is that we're here for the protection of the public, for the people of the state of Texas, because they don't have a face in these hearings. They don't have a voice. We are the only voice there for them. And that's what we're doing there, not to be punishing people. Mr. Hopkins mentioned that it's important what Mr. Casiano has done since these criminal acts, criminal offenses. And I think it is. One of the things that is very telling is that he testified at the hearing under oath. And you heard me earlier about the inconsistencies in his testimony and the inconsistencies with what the facts were as established by the investigations and so forth. But another thing, of course, that he'd done was testify at the hearing. And it leads me to ask the question, and maybe this will help keep things in perspective a little bit, but just this one thing may answer a lot or may shed a lot of light on this. While he was testifying under oath about his grandmother, who he testified was simply warm, and they wanted to see if they could make her a little cooler, or maybe it was vice versa, but why didn't he take those things and put them in his grandmother's room or outside in the hall next to his grandmother's room instead of in his car trunk? That's the only thing I would bring up to you about that, and I think that helps keep his testimony and all of the attitude I think he had about his testimony in perspective. That's all. Thank you.
Thank you, Mr. Sharp. Commissioners, further discussion? Feel free to have a seat if you need to. Any further discussion or a motion to be in order? I believe, if not, I think Commissioner Yurko did say she wanted to take a stab.
I'll make a stab at one. I know this is going to sound unusual. I don't completely agree with the ALJ just based on some of our discussions here already. I don't see how, like, for example, 19, that you can assume that based on the facts that it would not afford Mr. Casiano the opportunity to engage in a future burglary. I find it hard to agree with the fact that on number 24, Mr. Casiano does not pose a threat for future similar offenses. However, counterbalanced with the volume of support letters that you have from your community and your family to help assist you in staying on that right path for your own, immediate little family. I would move to revise the PFD and put it, could we do it in a suspension, not suspension, a probated type sentence?
Yeah, this is Brad Bowman, General Counsel. Yes, Commissioner Yurko, that would be an option for the commission.
Okay.
It sounds like what you're looking for would be a suspension of the license, and would that be fully probated, partially probated?
How long is the period on air conditioning? Just 1 year, isn't it?
Yes, it's
So I would say fully probated.
Okay,
To make
for 1
sure.
year?
Right, until its renewal.
So we have a motion on the floor to amend the PFD as presented. We probably need some findings of fact.
Well, it would
conclusions
change
of
the
law.
19 and 24.
19 and
I think
24.
conclusion of law number 10 would accompany that change requirement
And Commissioner, may I
to
also
reflect the findings of fact.
suggest that on the condition, the standard conditions of probation, that the respondent comply with the laws and rules of the department.
Correct.
Through
Okay.
So-
that period.
So it'd be, sorry, so it'd be to amend the PFD with the conclusion of law findings of fact as stated by Commissioner Yurko to fully probate the license?
Yes, it would be to
Suspend
suspend
and Sorry.
the license
Suspend and
for 1
fully
year,
pro-
fully
okay.
probated.
Fully probate. Any Any questions or a second will be in order?
I'll second that.
And we now have a second.
Can we have some discussion, Mr. Chair?
Yes, discussion.
Well, I think this is a very difficult case. I'm much about precedents and what we've done in the past. I will be voting against the motion for obvious reasons. I think the time, as the chair eloquently put it earlier, the time hasn't lapsed enough. I think we have looked at even more severe cases before and minor cases before where we've stuck to the integrity portion of the applicant. And so I'm going to be voting against the motion.
Any further comments? All in favor signify by saying aye.
Aye.
Those opposed?
Aye.
Aye.
Mahon, if you would mind calling roll.
Tom Butler,
Against?
Helen Collier,
For.
Rich Figueroa,
Four.
Catherine Rovolt,
Four.
Robert Shaw,
Against.
Deborah Yurko,
Four.
Mike Mendez.
Against, the motion passes 4-3. So if you're not sure what that means, your attorney, I'm sure, can explain it to you since he's read here. He can explain it to you, but essentially what's happened is that you have your license, but there are some restrictions that you need to follow. So let me just kind of tell you in a parting way, I think you have your attorney to thank. He did a great job presentation that he gave us. Also, you begin a second chance on our part. So I would hope that you wouldn't squander that opportunity and that you go forth and do exactly as you said, continue to be a productive citizen in your work that you've started on and embarked on in your future. So that's kind of where I would leave it at. Ms. Franklin, make sure he fills out one of these forms and get it right back to Kay so we can make sure we have it for the record.
Yes, sir.
All right? Thank you,
Sure.
appreciate it. Yes.
Could I say something?
Sure, please.
Do you want
Mr. Cassiano, I can't make an assumption on things in a 20-minute hearing. What you do, I'm familiar with a lot of the background, but not on a generic basis. What you do affects many people. You've been given permission to get a seat at a table that people from your neighborhood probably don't get a seat at. So your kids, and there's a ripple effect. I want you to understand the gravity of that. It's not about you and your behavior. It's about people that come behind you and stand on your shoulders. Your failure to stand up under that weight collapses many lives. I just want you to know that. And the behavior and the habit that has been performed prior to this, it's going to take a lot of soul searching that an attorney or a book or us cannot fix. I hope you understand that. If
Yes, sir.
you don't, your ignorance won't be an excuse because you've been told. You understand?
Yes, sir.
That's the reason I voted for it. Hope you don't make me regret it.
Thank you, sir.
If I may, Vice Chair Tom Butler, I clearly, an opportunity, and echo the comments by my colleague on the commission here. This is an opportunity to thank your supporters and your group that are behind you, because it's not a matter of letting yourself down, which is huge enough, but you'll be letting them down as well as the community, and that carries a lot of weight as well. And secondly, the training that you mentioned was a requirement. I would like to think that within this time period that you'll be doing some self-initiative and look for some training that will help you in that particular area, because otherwise we may be seeing you again. Thanks.
Thank you, ma'am.
Thank you.
For your time, appreciate it.
The next item on the agenda is item F3, Tyler McGinty, and Mr. Ken Sharp. Is anybody here with Mr. Tyler McGinty? No? Okay. Mr. Sharp, continue, please.
Thank you. My name is Ken Sharp. I'm an enforcement prosecutor with the department. And this next case involves Respondent Tyler Dean McGinty. The department proposes the revocation of his air conditioning and refrigeration or ACR contractor license and the revocation of his registered ACR technician license. The administrative law judge recommends that you revoke those licenses. In November 2013, the department issued an ACR contractor license to the respondent. He applied to renew it in October of 2015. His renewal application had a question that asked him whether he'd been placed on deferred adjudication for a criminal offense since his most recent license was issued, and he answered that he had not. The department's criminal history check revealed that, in spite of his answer, the respondent had 2 new criminal offenses on his record. Also in 2010, the department had issued a registered ACR technician license to the respondent. That license expired on June 26, 2013, but at the time of the notice of alleged violation, that license was still eligible for renewal, or late renewal, so it was included in this. As far as his criminal history, in 2009, the respondent was placed on deferred adjudication community supervision for 10 years for felony possession of a controlled substance. In March of 2015, he pled no contest to felony possession of a controlled substance and was placed on deferred adjudication community supervision for 3 years. In August of 2015, the respondent pled guilty to theft from the person. As with the other cases, the court deferred adjudicating him and instead placed him on community supervision, and in this case for 3 years. The latest offense occurred when Walmart loss prevention officers saw the respondent place 3 packages of eye drops and a package of razor blades in his pants pocket and then leave the store without paying. The officers confronted him in the parking lot, and when they did, he shoved them and tried to run away. They caught up to him and they tried to restrain him, but the respondent physically fought with them until the officers finally managed to subdue him. The respondent testified that he had merely put some eye drops in his pocket but had forgotten to pay for them before he left the store. In later testimony, however, he said he had been taking Xanax, and that drug had the side effect of making him steal. Although he was physically resisted and attacked the loss prevention officers while he said he was under the influence of Xanax, he acknowledged that Xanax is prescribed for its calming effect, which is inconsistent with his behavior when confronted with a theft. And there was no evidence that Xanax actually produces the effects the respondent attributed to it. Finally, the respondent admitted he deliberately falsified his application in an effort to avoid losing his license. The ALJ concluded the respondent's criminal history and his falsification of his application for renewal render him unfit for a license. The ALJ also concluded the respondent demonstrated that he lacks honesty, integrity, and trustworthiness. The ALJ recommends that you revoke the respondent's air conditioning and refrigerator contractor license and revoke his registered ACR technician license. The department asks you to adopt the PFD as written and amended by the ALJ after the department's exceptions. Thank you.
Are there any questions of Mr. Sharp?
Mr. Chair, I'm ready to make a motion.
I have actually a question I want to, or not really a statement. Mr. Sharp, I have a little bit of an issue because this case is almost identical to the previous case. Being he had 2 previous convictions of a controlled substance, whereas the previous gentleman had issues with alcohol. Both had deferred adjudications for theft. And I just wanted to point that out. I have a real strong issue with both these cases, but I did want to ask you, were there any letters of support submitted for this person?
I don't recall as there were. I can tell you here in just a moment.
And I think the other gentleman had already completed his time with the probation officer. Is this gentleman serving any supervised time?
He would still be on probation even from the first one back in 2009. And as far as those letters, he offered 3 exhibits. One was from Allied Air, Texas. That's the respondent's Exhibit 1. And that just verifies that he works at the company and that he's done numerous jobs and has always been timely, polite, and honest and efficient in his workmanship. The second is from Keller Williams Realty. That's Exhibit 2, respondent's Exhibit 2. And this is someone who finds him respectful, prompt, and reasonably priced. And Exhibit 3 is from someone named Desi Clark from Hot Springs Village, Arkansas, who believes that Mr. McGinty is courteous and honest and hard worker and tries to treat his customers with respect.
And how old is this respondent?
He was born in 1987, and he was 21 when he committed his first offense and 27 when he committed his most recent in 2015, so he'd probably be about 28 now.
No, no more questions.
Any further questions? I believe Commissioner Shaw has a motion.
I do have a motion to adopt the PFD as issued by the ALJ.
We have a motion.
Second.
Second, all in favor signify by saying aye.
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 Those opposed, motion carries. Ms. Mahon, if you would make note that I was not present, so I did not vote for this until the very end. So, let's move on to item number 4. Mr. Sharp, you're still up to bat. Mr. Kelly. I believe that we have Troy Kelly available. If you don't mind just having a seat up here. Mr. Sharp, proceed.
Thank you, Mr. Chairman. For the record, my name is Ken Sharp, Enforcement Prosecutor. And in this next case, the Department proposes the revocation of the journeyman electrician license issued to the respondent, Troy W. Kelly. The Administrative Law Judge recommends that you revoke that license. The Department issued the journeyman electrician license to Mr. Kelly in June 15th of 2004. He renewed that license most recently on December 31st of 2015. On his renewal application, he answered no to the question that asked whether he had been convicted of a crime since his last license renewal, but that answer was not true. Beginning back in March of 2010, he was convicted for assault of a family member and sentenced to 3 days in the Harris County Jail. The indictment, to which he pled guilty, said he injured a member of his family by throwing her down a flight of stairs. He was 33 years old when he committed that offense. In February of 2012, he was convicted of trespass to a property, a building, with no forcible entry, and sentenced to 4 days in the Harris County Jail. In September 2015, he was convicted of the theft of metal and spent 9 days in the Travis County Jail. In that case, he had stolen approximately 60 feet of heavy-gauge copper wire from an air conditioning unit on the roof of a commercial building. Police had viewed the security video at that building and recognized Mr. Kelly from surveillance photos that they had previously seen depicting him selling stolen batteries at a recycling facility. Mr. Kelly was 39 years old when he stole the copper wire. And the last conviction was the one that Mr. Kelly failed to reveal on his application for renewal. However, he committed all 3 of these offenses while he was licensed by the department as an electrician. The ALJ recognized that Mr. Kelly was making efforts toward rehabilitation, but concluded that not enough time has passed since his last criminal offense and his untruthful answer to the criminal history question on the renewal application. The ALJ recommends that you revoke Mr. Kelly's license. The department asks you to adopt the proposal for a decision. Thank you.
Any questions for Mr. Sharp? Mr. Kelly?
Yes, sir.
Sure, you probably heard my statement earlier that you can only confine your comments to what was presented at the SOA hearing.
Yes,
So if you
sir.
don't mind, confine your comments to that. If you don't mind, state your name for the record.
Troy Kelly.
Go right ahead.
All I have to say, my root cause was alcohol and drug addiction I fell into. Today, I have over 8 months clean and sober. I self-initiated checking myself into rehab. I actually called the police after this happened. After, I believe it was 11 days. I stayed in jail for that theft of metal. All for drugs. I mean, I plainly admitted it. I made poor choices, and you know, I'm here today because of those poor choices. And I checked myself into a 30-day inpatient, successfully passed that, and then I did 2 months of outpatient services, and I also checked myself into a sober living facility for 2 months. This is all in Houston, Texas. And before I could never say I love myself. Today I do, and I found God. I turned my will and life over to the power of God, and I'm just trying to do the right thing. I've done electrical work since actually 1994. I worked for the same company for 21 years until I was laid off in Houston, Texas, due to lack of work. And I fell in depression after that, and then of course started drinking and doing drugs. And I'm a father and a husband, and that's all I have to say. I wish I could afford an attorney, and I can't. I'm just a simple, I'd like to say, simple boy from the country. And
Join the club. We can
but today I'm just trying to live life right. That's all I have to say. I mean, I did everything on there. I did, and I'm not proud of it. I lay my head down every night and I think about those things I've done, and I have a lot of guilt, but I'm just trying to do the right thing today. I do Bible study every week, and actually with the people I work for is Cabela's family. I do ranch work for them now. You know, electrical is my life. It was my passion. My father, my grandfather, I have 3 cousins and 2 uncles, all electricians. It's all I've ever known. I have a passion for it. I actually wanted to go for my master's one day. You know, I'm the sole provider of my family, and the license is my life. I do go to weekly AA and NA meetings. And that's all I really have to say.
Any questions for Mr. Kelly?
Mr. Kelly, what is the name of the program that you checked yourself into
Cheyenne Center and Phoenix House.
in Houston?
Yes, sir.
Okay. And when you renewed your application in December last year, you stated that you'd not been arrested or were on deferred or
Yes, sir.
anything like that. Why did you say no?
And actually at the hearing, I had mentioned what I did, and I always renew it on the computer. I've done it every time, and I've always marked, no, I've never had a felony, because I never have. And when I realized I marked it, I tried to go back, and I couldn't. And then at the hearing, I forgot the woman that was there. She said you could go back, but the computer locked me out. I couldn't. I even called to the city of Austin saying, hey, I made a mistake on here. That it would not let me go back to
the city of Austin?
Yes, I called up to the TDLR up there.
Okay. You called the agency?
Yes,
Okay.
yes, sir. And it wouldn't let me go back to change that I had a felony on there. I was just so used to marking I have not had a felony. And
Was it notated that there was a call from Mr. Kelly? Do we know? No notation?
It would have just gone to customer service, and
Yes.
if there had been one. And nobody ever asked the customer service people's names when they do that.
Are they allowed to change them when they call?
Yes. Well, I think they just say, we'll send in a criminal history question. I'm not exactly sure about their process. I wish I was a little more familiar
But we
with
need
it.
to
but-
know, what is the process?
Brian, do you know what the process is?
Do we have anything on the record in the hearing to talk about
Was this
all of
mentioned in the
this?
SOA hearing?
No, okay.
No, well, it was, I take that back. It was to a certain extent, but I think the investigator said that she wasn't exactly sure, other than to know that it was possible to change.
But it was brought up at the SOA hearing?
It was.
Okay, let's go forward. Brian, what's the process? Can they change it?
Yeah, if a person called us, and they could amend their application. That's possible of happening. We also have the ability to check and see if there was a phone call that day, because we can look at the phone numbers, if we want to go that far back. If it's within the 90 days, and I don't know what the time period is, we'd also have a recording of that phone call.
So either way, you've admitted, do you own all of this? I mean, this is you? This is,
Yeah, like the first one, was 2009 or 10, got in an argument with my wife, and I pushed her down the front steps of our house. I sure did, and drinking that day as well. And I did, you know. My wife is here actually today, and, you know, I do therapy. We've done family therapy, and I'm a changed man today.
did you trust her enough to go to sleep in her presence after that?
Yeah, she's a little tougher than I did that. I'm ashamed of it, but I have to live with that every day. You know, every meetings I go to, I talk about that. You know, and I'm not proud of that.
Well, I don't know what the decision the commission will make here, but I'd encourage you to stay on the path that you're on.
Sir.
I'm glad to hear that you've changed your life and given it over to a power higher than yourself. I think
Yes, sir.
that's the first step.
Yes, sir.
And so, congratulations to you.
Thank you.
Mr. Figueroa.
You were laid off from your job, right?
Yes, sir.
You were there 21 years?
Yes, sir.
When did you get laid off?
I think it was 2010 or 11.
Okay.
Actually, yeah, go ahead. I'm sorry.
Go ahead, I'm sorry.
I started in '94, but actually I started in '92. But this was, I think I dropped out of high school. I was 16. I was doing co-op, working for the company. I had a family there, and so they received my check because I was too young to do the commercial work. So it was my cousin who got my check and who gave it to me. I don't know how they did work that out until I turned 18. But yeah, it was until I think it was late 2010, I was laid off.
Is that when you got into drugs and alcohol?
Yes, sir. I drank a little bit, just sociably, but after I was laid off, that was my life. That company was my life. I loved what I did, and I was just depressed after I got laid off. And,
Did you have any criminal history in those 21 years?
just the 2009 where I got in an argument with my wife. That's it. No,
You have a job now?
I work for the Cabela's family. I'm a ranch hand. The Cabela's been a long time friends of mine. So, up in Dripping Springs where I live now.
Are you doing
I
electricity?
take care of exotic wildlife animals.
Any other questions?
Are you
Oh, I'm sorry.
still living in a sober living facility?
Oh,
or-
no ma'am.
Okay.
I purchased a home in Dripping Springs. I live out there on 12 acres. Right
And-
next.
And was it just the one offense, or was it more than one offense during the time he had his license for clarification?
They all three were.
All
While he
three
was
were.
licensed.
Okay.
Mr. Shaw.
Mr. Kelly, I understand the economy is doing very well and electricians are high in demand right now
Sure.
in the state of Texas. Convince me a little bit more that you have been rehabilitated. I'm probably more tougher commissioner here on
Yes,
this.
sir.
On this.
Yes, sir.
on this commission, so I want to better understand before I.
Yes, sir.
I vote or make a motion.
Yes, sir.
To give me the assurance that you have been rehabilitated and that we won't see you here again.
Yes, sir.
Should the commission decide to vote one way or another.
Yes, sir. I'm going to jump back to the hearing. I don't know a lot about the law and how, just excuse my ignorance in this, but I didn't realize I needed an attorney at the hearing. Mr. Sharp was saying I had to exhibit all of this paperwork from my drug and alcohol treatments. I didn't realize I needed to do all that. And he said, you have to, exhibit and label him, and I didn't know that, and I was just kind of thrown in the hearing and say, here you go, and I couldn't exhibit any of this stuff. I didn't have time to do that, and it's my fault. I should have followed up and learned about the process, how to do that. I just didn't.
Did you answer my question?
I'm sorry, but I have like 300 pages of everything. I have hair follicle tests I've even done, and all my rehab information, all in here. I just didn't, I can't issue that to y'all unless I exhibit them. Am I correct?
That's correct.
I just don't know if I can file for an appeal to then come back and issue all this as exhibits, or
All right, thank you, sir.
that's all I have.
Any further questions?
Sorry.
Mr. Kelly, any parting words from you?
No, sir.
Okay.
I don't want to leave you with a, thank you, I don't want to leave you with a misconception possibly that we did something to preclude Mr. Kelly from introducing some evidence, because we didn't do that.
I don't
No,
think that's.
I think
no,
it's-
I don't think that is at all.
Okay, but, and I was also going to say that we even include instructions in our notice of the hearing that, you can present these things.
Well,
so forth.
and I completely understand, and I know
Yeah.
that all the information was provided to Mr. Keller as everyone else that we have. I think that when you're kind of on the non-legal side, it can be pretty overwhelming. I understand exactly what he's talking about.
Right, and I have helped on a number of.
I don't feel that this commission believes that you did anything to hamper his ability to be able to present his case. I don't think that's the issue here.
Okay, I think even if you look at the last case, you'll find it's my handwriting on the respondent's exhibits because I helped him
He
put those
did.
together. so.
Yeah, well, yeah, no, I think we're fine. We're
Okay.
fine. So,
I'm ready to make a motion. Mr. Kelly, I'd like to first say I find your forthrightness, your humility, is probably going to carry the day for you here. I appreciate your honesty, willing to turn your life around and to prove it to us. So I'm
Thanks.
going to make a motion that we probate the PFD, not revoke Mr. Kelly's license.
I'll second that, and I would like to make a comment.
So we're looking at, I guess, kind of what we did in this last case to.
Previous.
Yeah, the previous case is to suspend and fully probate the revocation of his license.
And that would be conclusion of law number 7.
Conclusion law number 7. Okay, so we do have a motion. Yeah, we got a second from Commissioner Yurko. Commissioner Shaw, comment.
I'm still struggling with this, so.
Yes, sir.
Mr. Kelly, help me again. I'm going to ask, I'm pleading to you to reiterate again, a little bit more explicit without going to the file.
Yes, sir.
What assurances do I have if I voted one way or another on this case? Convince me that this probated suspension is the appropriate way to go.
I can tell you one word: do not get complacent in my recovery. Keep going to meetings. Keep associating with my family. Not put them out of my life. Put other people's needs besides my own. Not to be selfish. keep coming back is what they say, and I do that, and I get involved with the community, and I'm truly a different person today. I could actually say I love myself, and I don't. I can say it out loud. I'm proud about that. Before I never could. I always ducked my head down. And
Thank you. I think having your own self-recommendation rather than having the book that we were previously given.
Yes, sir.
I think weighs a lot on my.
Yes, sir. Thank you.
Mr. Chair.
Any further comments?
You're a rich man. The reason you're a rich man is because the woman at the end of that aisle, I wouldn't underestimate the wealth that is established in that relationship.
Yes, sir.
If nothing else, I think that should empower you to walk a little further and straighter.
Yes, sir.
You would carry yourself on your own volition.
Yes, sir.
I think that's a belief that you need to know and be reminded of. It's sometimes overlooked because the world tells us the opposite, that maybe you're a beaten man that's been kicked around, but you are a rich man because of that.
Yes, sir.
I wouldn't underestimate it. I think that it's important.
Thank you. Thank you for those words.
Any further statements, comments? All in favor
Mis-
signify by
Mr.
saying aye.
Chairman, I'm sorry to.
Oh, I'm sorry.
Interject, but just a technical matter. Is this a one-year probated suspension?
Yes, I think that's what he stated.
Okay.
Sure.
Or, is that
Sure,
correct?
we'll probate it for 1 year. I'll amend that motion.
You okay with 1 year?
Yes, sir.
Okay. Yes, it would be for 1 year.
Okay, thank you.
So, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Someone from staff will get with you, but
Yes, sir.
essentially what happens is that you receive your license.
Yes, sir.
It is suspended.
Yes, sir.
But probated, which means that you can work for 1 year.
Yes.
Basically, what we said is that you will have to make sure that you comply with all of the rules and regs and not get in more trouble.
Yes, sir.
It will be immediately revoked.
Yes, sir.
So, kind of like we did earlier, you got a second chance here.
Yes, sir.
And so you need to go forward. I tell you, the next step that you said that you could stand out loud and say that you love yourself, the next one would be to forgive yourself.
Yes, sir.
All right?
Thank you all so much.
Thank you. Appreciate it. Let's move on to item number 5. And feel free to go ahead and leave if you need to. We don't expect you to have to endure all this.
Thank you, sir.
Leroy Mosley. Mr. Sharp, you're still up to bat.
Yes, sir, and the stack is getting smaller. Mr. Leroy Mosley applied for an apprentice electrician license on September 24, 2015. Based on his criminal history, the department proposed a denial of his application. The administrative law judge also recommends that you deny the application. Between 1993 and 2015, the applicant was convicted of 19 different offenses. 3 were drug-related offenses. 3 convictions were for evading arrest or detention, and some of those were felonies. And then there were 13 convictions for theft. I'll be glad to go through all those and list them for you. I just gave you a summary, but if
I don't
you...
think it's necessary.
Okay, I want to
We
give you that
have it.
option. I wouldn't want to listen to me either. In all, Mr. Mosley received 8 county jail sentences. He served 9 different prison sentences. He was most recently released from prison on September 4th of 2015. 3 weeks later, he applied for an apprentice electrician license. At the hearing, Mr. Mosley said he had a drug and alcohol addiction, but that he had finished a residential rehabilitation program in June and no longer has those problems. Among the legislative standards that guide the department is the requirement for an applicant to demonstrate that he has the honesty, trustworthiness, and integrity to hold the license. The ALJ concluded Mr. Mosley has not yet demonstrated that. For now, the ALJ recommends that you deny Mr. Mosley's application for an apprentice electrician license, and the department asks that you adopt that proposal for a decision.
Any questions for Mr. Sharp?
I just have one question. Did he didn't get his electrician's training in prison, did he? Or was that before? I know there's been past problems with the prison system, you know, providing training but not explaining that there's going to require a period of time after you get out of prison.
I don't recall that, I don't recall any evidence that he had, where he had gotten his training.
Okay.
Let me just look at my notes right quick and maybe
Was it an
there's-
apprentice license?
Apprentice.
He would not need any training to get that license.
Okay,
Oh, okay.
great.
All right
Okay,
then.
never mind. Thank you.
Mr. Chairman, I'm ready to make a motion.
Please do.
Make a motion to adopt the PFD if there's no other questions.
We have a motion.
I second it.
2 seconds. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 6, Carlos Foster. I failed to ask, was there anybody here representing Mr. Mosley or Mr. Mosley himself? Mr. Foster? Anyone here for Mr. Foster? Go ahead, Mr. Sharp.
And finally, we get to Mr. Carlos A. Foster's case. He applied for a consent tow operator license. The department proposed a denial of that application, and after hearing, the administrative law judge agreed and recommends that you deny Mr. Foster's application. This starts in 1997 when Mr. Foster pled guilty to burglary of a motor vehicle. He was 18 at that time, when he committed the offense, that is. The court deferred the adjudication and placed him on community supervision for 1 year. The community supervision was terminated because Mr. Foster did not satisfactorily comply with the terms of his probation. In 2001, he was convicted of assault of a family member and sentenced to 15 days in the Harris County Jail. In 2003, he was convicted of burglary of a motor vehicle and sentenced to 20 days in the county jail. In 2009, he pled guilty to felony possession of a controlled substance. The court deferred adjudication in that case and placed him on community supervision for 2 years. In 2012, he pled guilty to possession with intent to deliver cocaine. And once again, the court deferred adjudication and placed the applicant on community supervision, but this time for 8 years. However, 14 months after that, in June of 2013, the court revoked the community supervision, found Mr. Foster guilty, and sentenced him to 5 years in prison. It was at that same time, in June of 2013, that the court also convicted him of felony assault by intentionally impeding breathing or circulation. And for that, the court sentenced him to 2 years in prison. Mr. Foster was 34 years old when he committed that most recent offense. He was released from prison in December of 2014 and is scheduled to remain on parole until October of 2017. Assault, possession of controlled substance with intent to deliver, and in this case cocaine, and burglary of a motor vehicle are all guideline crimes for tow truck operators. Mr. Foster is not licensed as a tow operator. He has never held a tow operator license. At the hearing, he testified he works for a towing company as a tow truck operator. He held that job for about a year before he went to prison, and he said he did not know that he needed a tow operator's license in order to do that. He testified that when he was released from prison, he came back to that same company and resumed his job as a tow operator. But at that time, he learned that he needed a tow operator's license in order to drive a tow truck. Nevertheless, he said he continued to operate tow trucks without a license because his employer allowed him to. The ALJ found Mr. Foster had not demonstrated that he has honesty, integrity, and trustworthiness required to hold a tow operator's license. The ALJ concluded that Mr. Foster is not presently fit to hold a tow operator's license and recommended the Commission deny the application. The Department asks that you adopt the PFD as written.
Any questions for Mr. Sharp? Motion be in order.
So moved.
We have a motion?
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, Mr. Sharp. Item number
Thank you.
7, Black Bull Towing. I believe we do have Seth Lightfoot. Mr. Shirk, feel free to proceed at any time.
Members of the Commission, good morning. These cases are interesting. Mr. Hopkins, when he was here earlier today, talked about the case needing an evaluation of evidence. None of these cases require an evaluation of evidence. They're pure questions of law, which of course are in your province exclusively. These two cases come before the Commission on a proposal for decision issued by Administrative Law Judge Gary Elkins on March 31st, 2016. After hearing the cases in Fort Worth on December 1st, 2015, Judge Elkins found that the Department failed to carry its burden of proof in both cases and recommended no action against the respondents. In the first case, TDLR Tow 2015 0009122, the parties have agreed to all the facts. It was wonderful to work with Mr. Lightfoot in honing the case down to what exactly it was about. I've never enjoyed working with an opposing counsel, but so much disagreed with his reasoning. The facts are simple. On January 31st, 2015, Black Bull Towing performed a non-consent tow of an apartment resident's car. The tow was merely because she had backed into a parking space at her apartment complex. The parties agreed that there were signs posted at the parking facility entry which prohibited back-in parking, and that the language of the tenant's lease prohibited back-in parking. Taken to its germ, the administrative law judge based his recommendation on the startling and erroneous legal conclusion that this case did not even involve the Texas Towing and Booting Act, but rather the landlord-tenant provisions of the Texas Property Code. Staff argued in its exceptions to the proposal for decision that the property code was irrelevant in deciding whether this private property non-consent tow was legally authorized, and argued that the controlling law in this case was the Texas Towing and Booting Act. Specifically, and I think I've got a slide, it'll go up. Specifically, the proper resolution of this case is governed by section 2308.253 of the Act. This section, as you may see up there and on your monitor, is titled very clearly, Unattended Vehicles on Parking Facility of Apartment Complex, Removal and Storage of Vehicles. It lists in plain language the circumstances when a resident may be towed from the parking facility of an apartment complex. B1 through 6 lay out if the vehicle obstructs a gate or a dumpster, or is in a restricted parking area, a tow zone, or is an unauthorized tractor trailer, or is leaking fluids, the vehicle may be towed. However, there was no evidence whatsoever of any of these reasons which would have authorized towing. And in fact, as noted, the parties already agreed that the only reason the vehicle was towed was because the resident had backed into her parking space. Black Bull argued, and the administrative law judge agreed, that because the lease and the entry sign said no back-in parking, the car could be parked. This is an error of law and a deviation from the plain language of the statute, which the Commission must not adopt. The legislature said in the statute what it meant, and it means what it says. The owners of an apartment complex may prohibit any sort of parking desired. The lease language and the posted signs may prohibit back-in parking, Fords, vehicles displaying support for the Oakland Raiders, double parking, even unwashed cars. The signs can say that. The lease can say that those cars cannot park there. I mean, this is an essential part of private property ownership. However, residents' cars may not be towed for those reasons. The only reason that a resident's car may be towed from a parking space are for the reasons that the legislature has told us in B1 through 6 on the board. Further down in the statute, in subsection G, the legislature hammered this point home. It said that any lease language which is in conflict or inconsistent with B1 through 6 is void and unenforceable. Therefore, the administrative law judge erred in the first instance by finding that a resident may be towed for a reason other than those 6 specific reasons contained in the statute, and erred again, compounding the problem in finding that the use of signs or lease language permits a owner to tow for any reason it wants to. Lots of attention was spent by Black Bull and the administrative law judge seeking to justify the tow under the landlord-tenant provisions of the Texas Property Code. The administrative law judge's analysis is found in Conclusion of Law 13, which states that the apartment lease provision prohibiting back-in parking is consistent with Property Code 92.0131, and it neither conflicts with nor is inconsistent with the Towing Act. I'm going to have the Property Code displayed so we can see that, in fact, the Property Code is fully inconsistent with the law, with the Towing Act. So hopefully by now I've made my point that a lease permits the towing of residents' vehicles from the tenant's apartment only for one of the reasons in the Tow Act. And if a tow is made for a reason outside the Tow Act, it is unauthorized. In many instances, and I think this is interesting, in many instances, the legislature has delegated to the commission the authority to promulgate rules to implement statutory language. In the instance of defining when a tow may occur, however, there's been no delegation of authority to the commission. There are no, if you look in your rules, there are no rules saying when a tow may happen. Certainly, the legislature did not intend to delegate this authority to apartment complexes to define outside the statute when a tow may happen. Any argument that a parking facility owner may authorize non-consent tows of residents' vehicles which are not authorized by the express terms of the Towing Act itself must fail. And this is true even if the property code is brought into analysis. Section 92.0131 of the property code is titled Notice Regarding Vehicle Towing or Parking Rules or Procedures. Nowhere in the property code does the legislature expand upon the grounds which authorize the non-consent tow of a resident beyond those contained in the towing law. The property code simply requires a landlord to give notice of its, quote, vehicle towing or parking rules. I would think that the legislature assumed that those vehicle parking or towing rules would be in compliance with the Tow Act. The property code, you also note, is a procedural, it contains a procedural requirement only that the landlord must give notice of the parking rules to the tenant, and it contains no substantive grant of authority. So I go back to the original point, which is a private property owner, an apartment complex owner, may prohibit back-in parking, Fords, people who have Oakland Raiders stickers on their cars, double parking, or even unwashed cars. They may not ever tow those cars. And make no mistake about this, that the landlord, the property owner, is not left without a remedy or a way of discouraging this conduct. They can impose a fine under the terms of their lease. They can make it a $1,000 fine and collect it out of the security deposit. They can evict the tenant. They can take away parking privileges. So that the owner of the apartment complex is not left with no remedy. And of course, the same responses can be taken against the tenant if one of their tenants, one of their guests violates the rules. Because this tow, which the facts are stipulated, was based solely on a resident backing into her parking space, was performed without the legal authority of the Tow Act, and because no authority for the tow can be found by looking to the lease language or the property code, the department requests that the commission not adopt the proposal for decision as it's written. This is respondent's third Class F violation. As such, the department seeks an administrative penalty of $4,000 and the revocation of respondent's towing license as permitted under your enforcement plan. This penalty and sanction is especially warranted in light of an agreed order that respondent's attorney signed on January 2nd, 2015 in TDLR case 1954, and I have copies of it for all the commissioners if you wish to see it. In that case, the department brought an enforcement action against Black Bull Towing for towing a vehicle merely because it had backed into a parking space. The agreed order issued by the director and assented to by Black Bull Towing stated that towing a vehicle merely because it backs into an authorized parking space is not a legally sufficient reason to tow a vehicle, and issued a Class F violation. That would have been respondent's second. That was January 2nd, 2015. Yet on March 30th, March 2015, less than 2 months after entering the agreed order, respondent once again towed a vehicle for backing into the resident's parking space at an apartment complex. Clearly, lower levels of punishment and sanction in order to encourage right behavior and compliance with the law have not worked with this respondent. I also wish to point out that on January 6, 2016, a unanimous commission, apart from the votes of Commissioner Rodewald and Moses, adopted a PFD issued by Administrative Law Judge Arnold and I have a copy of this also if the commissioner wants to see it. The administrative law judge stated in the proposal for decision, quote, "The legislature intended the 6 restrictions of 2308.253B to be exhaustive, and property owners can only impose parking restrictions consistent with the statutory restrictions." Judge Arnold, in that proposal for decision, which was fully adopted by the commission, also noted the language in the Tow Act, which was displayed earlier, stating that any lease agreement which contains conflicting or inconsistent terms is void and unenforceable. The legislature said what it means, and it means what it said in the specific language of the Towing Act. Respondent violated the law and violated when it was on notice of the commission's interpretation of the law. Therefore, we believe that a third Class F penalty should be imposed, which in this case is $4,000, and the revocation of respondent's tow company license. And I know that there's a lot there. I can move on to the next case, or if you'd like to hear rebuttal to that one. I'll move on to the next one.
Please do.
The second case, tow 2015-0012-986, involves respondents towing of a vehicle from a large shopping plaza when there was neither a written agreement with the property owner and Black Bull to tow from the property, nor a specific request by the property owner to have Black Bull tow a vehicle from the property. The Towing Act is very clear that one of these preconditions must always exist before a non-consent private property tow may occur. That's Section 2308.255D of the Tow Act. And this makes sense. After all, it's only the property owner who can authorize a tow. If a towing company is not acting under the authority of the property owner, it has no authority to enter upon, much less tow a vehicle from the land. The facts establish that on March 30th, 2015, Black Bull Towing performed a non-consent private property tow from a large shopping mall. The only written agreement in existence was entered into in 2012 between Black Bull and the prior property owner. The property had been sold on in August of 2014, and again it is undisputed that the new owner neither knew about, much less entered into, a written agreement with Black Bull to tow from the property. The owner of the property since August of 2014, and of course also at the time of the tow on March 30th, 2016, was a limited liability company, and it testified through one of its partners, Benjamin Sumner. He testified that Black Bull was never authorized to tow from the property after its purchase in August 2014. There's really no dispute about that. The senior property manager also testified. He testified that as soon as he learned that Black Bull had performed the tow at issue in this case on March 30th, he contacted Black Bull on April 1st and instructed them to cease further towing activity. However, his testimony was that on April 2nd, he learned that Black Bull had put up brand new signs around the perimeter of the property. In response to this, he faxed Black Bull a formal cease and desist letter on April the 7th, advising it that the property owner was never aware of any agreement with Black Bull and that all towing from the property must immediately cease. The facts were, therefore, uncontested that Black Bull, at the time it towed the vehicle on March 30th, did not have a written standing agreement to tow from the property, nor had it been asked by the property owner to perform the specific tow. Therefore, the respondent's towing of the vehicle was unauthorized by law because the property owner had not given authority to enter upon and remove the vehicle. The administrative law judge ignored the statutory language and directive and characterized the department's argument as, quote, little more than a straw man argument that the ALJ rejects. Black Bull's defense was that the agreement which it signed with the earlier property owner back in 2012 was self-renewing and it had never been notified that the property was sold. It disclaims any responsibility to stay informed and keep in touch to ascertain whether a years-old towing agreement remains vital after the passage of time. Staff believes that this promotes commercially unreasonable behavior and is a self-serving excuse to maintain ignorance, since it permits and incentivizes companies such as Black Bull to continue towing and collecting tow and storage fees as long as they just simply stay uninformed. Black Bull also argued that somehow the new property owner assumed or undertook the terms of the 2012 towing agreement. That's impossible, however. The property owner who purchased in August 2014 did not know that there was a tow agreement, had never entered into a tow agreement, did not ratify a tow agreement, and acted promptly once it knew that towing was being done to cease any towing from the property. As in any contract or agreement, you have to know about the agreement and you have to accept it before it can be effective. Simply put, if Mr. A and Mrs. B have an agreement and Mr. A moves, dies, or sells his property, you can't then take Mr. C and tell him he's entered into that contract when he never knew about it, endorsed it, or acted under it. The evidence was clear that the owners of the shopping plaza did not know about or enter into a written contract with Black Bull. There was no evidence that the owners could have, upon reasonable inquiry, learned about the contract, as might have been the case if it had been recorded in the deed records with the property records, or if the contract had been made part of the conveyance documents. The administrative law judge erred and wholly ignored the requirements of law, which require a property owner to authorize the tow of vehicles. Accordingly, the department requests that respondent be assessed an administrative penalty for this third Class F violation. Again, within the scope of your enforcement plan, that would be $4,000 and the revocation of its towing license. And I'll conclude by saying, as Commissioner Shaw noted earlier, these are issues of precedent. These are issues of whether or not the Tow Act will be enforced by its terms, or whether interpretations 5 or 6 degrees removed will now become the law. Thank you for your time.
Any questions, Mr. Shirk?
I have a couple.
Yes. Mr. Roboy, go ahead.
Did you review the contract, the tow contract with the previous property owner?
Yes, ma'am.
And it did not inure to the benefit of the buyer? It did not go on, because a lot of those contracts for apartments do go on.
It was a self-renewing contract.
But did it, was the new owner of the property, did that contract transfer? Because a lot of them do.
No, I saw nothing in it that would have caused it to be imposed on the purchaser without knowledge.
Okay, because it would not have been conveyed in a deed. That's kind of not the way commercial real estate conveys.
Well, it's not a matter of conveyance, it's a matter of putting a purchaser on reasonable notice of its existence.
But I think you said earlier conveyed in the deed.
Right, and that would have put the purchaser of the property on notice of the existence of the contract.
Okay, and then the other thing is, do you know why they don't want cars to back in apartment complexes? It's not merely or compared to an Oakland Raiders bumper sticker. Do you understand why? Just as
No, ma'am, I don't. And matter of fact, I'll tell you, when we go to our State Office of Risk Management driver training, we're told to back in or to pull through a parking space.
That's the reason they don't do that, and that's in the Texas Apartment Association lease, which is used across the whole state, is because it's dangerous. It blocks the line of sight for people with pickup trucks and SUVs. When they walk out their doors, it blocks their line of sight, so it's a safety reason that they do it, just as a point of contention, that I don't want to act like it's a frivolous rule, because it's so people can see when they walk out of their apartments if there's anybody there.
Commissioner, I understand your point, and that's fascinating, because that was part of my initial briefing, was that public policy supports back-in parking. It's been shown to be a safer means, because backing out of a parking space and having to crook one's neck where there's moving traffic is arguably, but the judge.
This is Brad Bowman. Is this on the record? Is there
Yes,
discussion
it is,
of this?
Mr. Bowman.
Okay.
This is part of my briefing,
Okay.
and there were materials admitted in support of the idea that, but I don't think that the judge, so yes, that's, it's good to know that.
Any further questions, Mr. Shirk?
And was there, on the apartment side, a contract in place with the tow truck company?
Yes. You
Right.
mean on the first case?
First case, correct. 122.
Yes, ma'am.
Mr. Lightfoot?
Thank you. Seth Lightfoot for the respondent.
And as you heard me before, if we can just confine our comments to what was at the SOA hearing.
Yes, Commissioner.
So that way we can just make sure to stay in line.
Absolutely.
Thank you. Proceed.
These are two really interesting cases because they can be summed up in the proposition that these are cases about petitioner's failure, right? They're cases about petitioner's failure to provide sufficient evidence. They're cases about petitioner's failure to provide sufficient legal support. They're cases about petitioner's failure to meet its burden of proof. Let's go back to the most recent case we talked about. That's the case that we affectionately call the Kroger case. The vehicle was towed out of a Kroger's grocery store parking lot. You've heard a lot about the contract. We'll deal with that contract first. That contract absolutely benefited the new owner, and here's why. At the SOA hearing, we heard testimony that the previous owner signed a contract with Black Bull Towing because the city of Fort Worth was fining that prior owner. Why was it fining that prior owner? Because the Kroger's located on that parking facility had closed. Criminals were using that parking facility as a staging ground for crime. City of Fort Worth doesn't like that. It told the prior owner, hey, you need to take affirmative action to remove trespassers, to remove unauthorized vehicles from your premises. We don't tolerate criminals. We don't tolerate staging grounds for crime. That contract benefited the prior owner because it ceased the citations. Mission accomplished. And it benefited the new owner in the exact same way. In fact, if you go and look now, that same property does have towing signs, not with Black Bull Towing, of course. But it is benefited by a tow company now, just as it was before. You've heard the petitioner give his conclusions of law, the petitioner's conclusions of law, that the contract could not possibly have been valid. But of course it is. In fact, when you look at the ALJ's analysis of this section, this wasn't conclusory analysis. Look at page 18 of that proposal for decision. Staff failed to prove and provided no meaningful authority to support the contention, just as it provided no support for the assertion that Black Bull bore an ongoing affirmative duty. In the absence of any accompanying legal support for that assertion, it amounts to little more than a straw man argument that the ALJ rejects. You see, the ALJ rejected petitioner's argument because the petitioner failed to provide sufficient legal support. It's the reason we have hearings to begin with, so that two parties can provide their evidence, provide their arguments, provide their legal support. Respondent did provide legal support. You look at that proposal for decision, you look at our numerous briefs, you'll see respondent provided legal cites from the Supreme Court of Texas that shows that contracts don't merely die with the death of a party, right, unless they're a special services contract. Contracts that benefit that new owner, they do carry forward, and this one did. Interesting also is the fact that the petitioner is no longer challenging the evidentiary conclusions of the ALJ. You see, the petitioner brought forth witnesses in this case, multiple witnesses, which the ALJ found to be not credible. Their arguments, or their testimony rather, unpersuasive. Why? Because they gave vague reasons for why they didn't satisfy basic requirements. They gave vague explanations for why they didn't maintain evidence that supposedly they had taken. The ALJ did not err. The ALJ took the evidence provided by the parties and the legal support provided by the parties and made the correct determination in this case. If there's a failure, it was a failure on petitioner, not a failure on the ALJ. Let's move second to what we call the apartment tow. Now, as petitioner mentioned, there are stipulated facts. All of those stipulated facts will tell you that respondent has completely complied with the law, right? There was a valid contract between the property and the towing company. There are valid tow signs. So, tow signs had all of the required language, required height, required size of lettering. The respondent complied in every single way, except the petitioner argues that it towed a vehicle because it was backed in. There was a great deal of argument about the Texas Occupations Code, the Texas Towing and Booting Act, and the application of the Texas Property Code. Let's deal with first the Texas Occupations Code and the Texas Towing Act. What the petition didn't show you was 252 and 255 with all 2308.252 and 255, sorry, of the Texas Occupations Code, which provide that a vehicle, an unauthorized vehicle, can be towed so long as proper valid tow signs in compliance with 2308.301 et cetera have been in place for at least 24 hours. Well, that's stipulated to. We already know that's a fact. It was respondent's contention throughout the entire process that this was a valid tow precisely because it had met every single requirement per the stipulations. Valid tow signs existed. There was a rule prohibiting back-in parking. That rule was embodied in a lease contract and placed on the towing signs. The complainant, the individual towed, knew about that rule. She signed a contract agreeing to abide by the rules, and then she violated the rules. Unsurprisingly, she was towed. Now, petitioner wants to tell you that there are so many other remedies. There may be other remedies. This is one of them. If you sign a towing agreement saying, I will be towed if I don't follow the rules, and then you break the rules, of course, you're subject to being towed. There are procedural requirements you have to meet 2308. There are procedural requirements you have to meet in Chapter 92. But remember, those stipulations, we've already agreed those were met. Those were met. When you look at how to construe, how to interpret the Texas Occupations Code, you're given a very handy tool. The Texas legislature gave you that tool. It's called the Code Construction Act, and it's codified in the Texas Government Code. It tells you how to construe a statute. Now, petitioner argued incorrectly that the Code Construction Act doesn't apply, but of course it does apply. It applies pursuant to its own terms. And the Code Construction Act tells you that you are allowed to view any materials that help you construe that particular statute, including the object that's sought to be attained, so it's the goal. What are we trying to accomplish here? And what does a particular interpretation lead to? Right? What are the results of a particular interpretation? The ALJ quite wisely looked at the results that the petitioner's interpretation of the law produced. They were absurd. The results were absurd. And we know, pursuant to the Texas Code Construction Act, that if an interpretation produces absurd results, guess what? It's not the correct interpretation. Because our legislature, the Texas legislature, does not intentionally pass statutes to produce absurd results. The absurd result in this particular case is pretty clear. This is what petitioner will tell you. Landlord can agree to towing rules with the tenant. They can do that. But then they just can't enforce them by towing. Well, then what kind of rules are they? Impotent rules? A rule without enforcement is not a rule. It's a suggestion. This is a case where petitioner never got around that absurd result, never explained away the Code Construction Act. They want to point you to other remedies. If petitioner truly believes you can deduct $1,000 out of a tenant's security deposit because they back in part, I would suggest petitioner go read Chapter 92 again. There's even a specific subsection on security deposits. The other underlying factor is the overall framework through which you view penal laws. What do I mean by that? We know that penal laws are always construed in favor of the accused. In that case, that's respondent. We're accused. Penal laws are construed against or in favor of those accused for a very clear constitutional reason, right? You have to be on notice of a particular rule before you can be penalized for it. It just makes sense. It's common sense, right? We don't have secret laws in the United States. We don't have secret laws in the state of Texas. Petitioner cannot point you to a specific section and could not point the ALJ to a specific section that prohibits a towing company from towing a vehicle because it's backed in. It wants to bend and misinterpret 2308.253. It wants to hide 252 and 255. It wants you to ignore the Code Construction Act. It wants you to ignore centuries of common law with regard to how penal laws are interpreted. And because of all that, the ALJ correctly and wisely held that petitioner did not meet its burden of proof. Because petitioner has to provide proper legal support for its contentions. It cannot say, you're not allowed to tow a vehicle merely because it's backed in because I say so. And that's exactly what happened. When you review petitioner's briefings, that's exactly what you see. You see an ipse dixit, take my word for it, because I said so, argument. The same hammering on 253 over and over and over again. Now I've told you about petitioners and respondents' position. Let me tell you about the ALJs. The ALJ looked at the Texas Towing Act, looked at the particular facts that the parties had stipulated to and said, I don't see an application here. But I do see an application of Chapter 92 of the Texas Property Code, which makes sense because we stipulated that this is a landlord-tenant problem. We stipulated that. We stipulated that this was a tow of a tenant because she broke the rules that she agreed to with her landlord. There's just a specific section in Chapter 92 that deals with this exact scenario. As petitioner showed you, it's 92.013. And it's antecedent 92.013. Those require you to provide sufficient notice, which makes sense, right? You can't enforce rules without providing sufficient notice. Except we stipulated that notice was provided. The big debate between petitioner and ALJ and the ALJ revolved around one particular section, the Code Construction Act. It embodies a phrase called in pari materia. That basically says if you have two statutes that seem to govern the same conduct and are irreconcilable, you're going to have to pick one. So which ones do you pick? Well, pretty simply, pick the most recent one and the more specific one. In this case, we know Section 92.0131 is both the most recent and the more specific. Now, petitioner wants to argue that 92.0131 is not the most recent. Again, look to the briefings filed by the parties. It's very clear that the reason petitioner believes that, the reason it asserts it, is because it does not correctly view the age of the statutory provisions. 2308, the Texas Towing and Booting Act, has been around for a very long time. It just hasn't always been codified in Chapter 2308 of the Texas Occupations Code. Right? It was previously codified in Texas Transportation Code. Previously, a numbered Texas Civil Revised Statute. But it's contained very similar. And for more years than 92.0131 has existed identical language, meaning 92.0131 is more recent. More specific, the ALJ found was obvious. right? The Texas Property Code deals with landlord-tenant matters. That particular section, 92.01 through 1, specifically dealt with towing in the landlord-tenant context. Whereas even if you took petitioner's interpretation of the Texas Towing Act, it only generally deals with Texas towing. Now, petitioner will tell you it only deals with it generally because it deals with all of it. But then petitioner doesn't provide any legal support for its attacks. One of the interesting things, and I'm glad it was brought up by the commission, is the public policy. Right, there is a strong, valid public policy against back-end parking. Petitioner argues there's a strong, valid public policy for back-end parking. Great, but that's not petitioner's prerogative, right? Petitioner does not have the prerogative to tell every single landlord, you must follow the public policy I deem. That's not petitioner's prerogative. Each landlord, each real property owner has the prerogative within the confines of the Texas Property Code to exercise its dominion over its property. We value property ownership, property rights. Real property rights are among the most fundamental in our society. We can go back and forth, and I'm sure we will, as to particular interpretations. In fact, we've dissected, statutory analysis, legislative history, comments by legislators. But the vast greater weight of the evidence and the legal support weighed in favor of respondent. That's why the ALJ made the correct determination in holding respondent did not violate the Texas Towing Act at all in either case. And accordingly, respondent moves you to adopt the ALJ's PFD in its entirety. Thank you.
Any questions for Mr. Lightfoot? I do have one question. I think the issue that that I have is, where I think that we kind of went awry, was bring the property code into this. If this were not a towing act issue, then why is it before the TDLR?
Because TDLR brought it, Commissioner, and that's exactly what the ALJ said. You should never have brought this action. This wasn't within your jurisdiction. This is petitioner
But-
exercising jurisdiction that it
Right,
doesn't
but
have.
the ALJ referenced the property code extensively and kind
Correct.
of brushed across the towing act.
I would disagree as to that characterization, especially.
Well, that's your job.
It is. But when you look at the proposal for decision, it's not simply 20 pages of 92.01 through 1. Right. When you look at the actual statutory analysis on 2308 and just 2308, you find that the ALJ looked at petitioner's interpretation and said, look, this violates fundamental, truly fundamental methods of interpreting statutes. And we know they're fundamental because they're embodied in the Texas Government Code, in the Texas Co-Construction Act, right? They produce absurd results. They unnecessarily limit the rights of real property owners. And accordingly, that's not the correct interpretation of 2308. Because respondent will argue, and it has argued extensively, that even if you were to reject the ALJ's Chapter 92 analysis, you should still find in favor of respondent's 2308 analysis, because the ALJ agrees with it. It does produce absurd results. Thank you.
Thank you. Any questions for Mr. Lightfoot, or even at that, Mr. Shirk?
Did you mention earlier the property owner contacted Black Bull and told him to cease and desist? Is that correct?
Yes, that's correct, on
And
April
then,
the 1st.
I want to make sure, did you say that they put up signs after that?
Yes, they did, but we don't know of any tows after March the 30th.
But after they were called and notified to cease and desist their towing relationship with the
Yes,
property?
that's the evidence in the record.
And then post that conversation, there were signs put up
flood, right?
Yes, sir.
Okay. And I just refresh my memory again. In the statute, it was stated that, and this is a legislature statute, that no vehicle can be towed except for these 6 reasons? Was that your interpretation? Is that what you were saying?
Yes, and that was the holding of the commission in an earlier decision, as well as the holding of an agreed order. That under B6, and I don't know if we can get that slide put back up.
But it was 6, and why under that real estate in the property?
Under the Texas Occupations Code, there are 6 reasons. And it's an interesting question because Mr. Lightfoot referred to the vehicle as unauthorized, and it wasn't unauthorized, it was unattended. It was an unattended vehicle at a parking facility. It was thoroughly authorized. The other interesting aspect is this whole thing about absurd results. If we are to let an apartment complex tow for any lease violation, then this is going to be a cheap self-help mechanism to enforce hanging of laundry or prohibiting pets or late payment of rent, because what's to keep an apartment complex from putting that provision in? And I say it's a cheap self-help mechanism because it's the tow companies that collect the money and pay the fine. So do we really want to open that door? I'm not trying to hide any law, and in fact the Code Construction Act says that the public interest must always prevail over the private interest. That's a canon of interpretation. If I were trying to hide any law, I wouldn't broadcast it up there. And I'm shocked at the administrative law judge's language that I misinterpreted the law, because I'd ask any of you, or that I didn't have citations for my law, because I'd ask any of you, may a tow company tow from property which it does not have authorization to tow from? The whole issue of it benefited the prior property owner, I don't know if it did or didn't. Certainly there was no evidence from the new property owner that they got any benefit out of it. I also would challenge any of you to look at the very specific provision that says unattended vehicles on apartment complex. The legislature is trying to address something there with laser-like precision. And where is your authority to tow an authorized vehicle? So my citations were the 2 statutes I relied upon.
Mr. Lightfoot, looked like you were chomping at the bit.
Yes, thank you. First, let's talk about that prior decision by the commission. The ALJ took note of it. It said nothing in the Atlas proposal for decision indicates that the parties considered the existence of other applicable statutes and presented them to the ALJ in that case. I'll go over that really quick. There was no evidence that the ALJ ever considered other arguments. My client is not bound by some actions of other attorneys, right? If other attorneys chose to take a different strategic decision, and probably very wisely so, they took that strategic decision for the benefit of their client. I'm here arguing the law as it exists right now. Atlas towing decision is not binding, and it certainly did not list any reasons or any evidence to show that the ALJ considered any other statutes. Second, let's look at that false slippery slope. Dishner calls it a cheap self-help. It ignores a basic principle of commerce, right? If you're that punitive to your tenants, guess where they go? Somewhere else. It's a false slippery slope. And keep in mind the context. These are towing rules agreed to by a tenant that the tenant violated. She didn't violate the laundry rule. She didn't fail to pay rent. It's a false slippery slope.
Any further questions, comments?
I do. Go ahead. Somebody else have one? I have a couple of questions.
Yeah.
We're
Please.
Yeah, thanks. You mentioned that there was a second incident at the apartment for back-in parking.
Yeah, what was second was that roughly 3 months prior to that tow, an agreed order had been issued, which was assented to by Black Bull Towing, in which it was stated that towing a vehicle because it has backed into a parking space is not legal grounds for a non-consent tow. And just very quickly, Mr. Lightfoot brought up a good point, which is about the tow signs and towing in the absence of a sign. The judge found that staff did not prove inadequate signs. That was based on a weighing of the evidence. Staff has abandoned that claim. We're not seeking any change to the PFD, that there was no violation of properly posted signs. And that's the only reason that these nebulous witnesses weren't referred to. Because we had originally brought the PFD saying that the tow from the shopping plaza was done in the absence of legitimate signs and also in the absence of authority of the property owner.
So the towing company was notified that prior to that, not to tow based on parking? Is that what you're saying?
That's correct. That's what the agreed order with respondent said.
And that was 3 months prior to this incident that was cited here?
Correct.
Okay.
So, Mr. Lightfoot, do we not run the risk of overstepping the power given to the TDLR by the legislature by allowing tows to take place that do not fall within the categories enumerated there?
Absolutely not, for a number of reasons. 253 is not an exhaustive list. I'll repeat again. 253 is not an exhaustive list. That's a false premise promulgated by a petitioner for petitioner's benefit. It's an absolute false premise. Look at 252, look at 255. Like I said, you can tow an unauthorized vehicle as long as there are signs in place, which we've already stipulated to. We do not run that risk because 253 is not an exhaustive list. Absolutely not. I just wanted to address one point that the commission had recently picked up on. And I'm glad they picked up on it. The quote-unquote agreed order, right? Agreed orders, there's a funny thing about them. They're not passed by the legislature. They're not signed by the governor. So what does that mean? They're not laws. That agreed order was not signed by me, signed by a different attorney. That attorney is not representing Black Bull in this case. I am. Now, full disclosure, that attorney is my boss, and he's not a litigator. He's not a litigator. He's a transactional attorney. He makes deals. That's why he's not litigating today. He signed an agreed order. So what? That's not passed by the legislature. It's not signed by the governor. It is absolutely not law.
Did he do it on behalf of the towing company?
Yes.
And so the towing company agreed to it?
They agreed to settle the case. It was a settlement agreement.
They agreed on the agreed order?
Sure, and they've absolutely changed their position.
So if they agreed to it, how are you telling us that, how are you forced now telling us that it wasn't you? I understand that.
Sure.
But we as a commission, when we have a motion second and we vote on it, while we may not all agree, it's still the decision of the commission.
Sure, and respectfully, Commissioner, we're not here today. Petitioner did not bring an action against respondent for violating an agreed order, right? Petitioner did not bring an action today that saying respondent violated an agreed order. Petitioner brought an action today saying respondent violated law signed by the legislature or passed by the legislature and signed by the governor. That's petitioner's action.
Mr. Lightfoot, I hope I never need you because you're a hell of a litigator. I'm going to give you that.
I agree with that.
But the question in my simplistic mind, right, is we're guardians of public and their vehicles. That's a very important part of my vision, is that how I see things. When you find somebody, you can still go to work. If you take somebody's car, it's a little more difficult, more punitive action, in my opinion. And so I understand that there are other, and so the implications are dire, and for a lot of reasons, but I think that's important so I want to make sure that's the case. And I guess the good faith approach is important to me, that Black Bull would be in good faith saying, hey, we got a problem here, we need to figure this out. If it occurred prior to those 3 months, prior to this whole incident being continued, agreed upon that he is not bringing that, but I still want to see, because he represents us when he's out there towing vehicles, because we are the guardians of that industry. So I want you to address that a little bit, because I think your employer has a response, other than legal, that you just enumerated here, to say, hey, look, I want to be a good company, and I want to deal in good faith, beyond the legalism of it. So if there's a notification prior to this incident that could have been addressed quickly, and we could be save an hour and a half of our time here, I want to know why they didn't take heart in that.
Absolutely. And I'm glad you brought up that contention, because it shows part of the problem with petitioner's underlying argument. We've already stated today that public interest should take precedent over private interest. I know we kind of took that out of context. It is a basic tenet in the Code Construction Act, but look at this particular case. Petitioner wants you to believe that respondent should be sanctioned because of the private interest of complainant who violated the rules that she agreed to. Right? She gave her word, reduced that word to writing, signed it, broke her word. That's the person petitioner is advocating on behalf of today. As far as the fines, it's such a bizarre false dilemma. And I say it's bizarre because I spend the majority of my time advocating on behalf of apartment owners, multifamily residential real property. I go to eviction hearings and eviction appeals. I meet those tenants face to face. And I don't know if, maybe this isn't public knowledge, but the TAA lease is one of the more common leases in the state of Texas.
Mr. Chairman, we're getting outside the record at this point.
Isn't that contract in the record?
The people he meets at hearings and what happens at his eviction cases is outside the record.
The petitioner called for public policy. The commission called for an explanation as to why the respondent has acted in good faith. And petitioner advanced a logical fallacy, a false dilemma, a false slippery slope. I want to address that logical fallacy. I think I'm entitled to once petitioner advances it. The point is, landlords can take punitive actions against tenants. That fine, what's to limit that fine? $1,000 fine? Really? Guess what happens when the tenant goes to pay rent? It's applied against that fine, and they get a notice to vacate saying, sir, or madam, kindly vacate. You failed to pay rent today. You think taking a horse, a car, the modern equivalent of a horse, is terrible? Think about taking a home. Their real property.
So why didn't Black Bull address this issue 3 months prior to this? You gave me the petitioners, you gave me advice. Tell me why Black Bull didn't see this coming and say, I need to get this and address this because this is going to be a problem.
I believe it, respectfully, as far as acting in good faith, my client absolutely acted in good faith. It had an apartment complex. Tell it. We believe in the protection of our children. We believe in having our fences not run over. We believe in enforcing our parking rules. Please enforce them. We don't hire you to only enforce the ones that you feel like enforcing. We hire you to enforce our parking rules. That's why we put them on the signs, that's why we put them in our addendums and our lease contracts. As far as back-end parking, that agreed order is absolutely irrelevant. It's absolutely irrelevant. It's absolutely irrelevant because petitioner's action is based on the law, and it's absolutely irrelevant because it in no way changed the law. Upon a litigator's review of the law, it became apparent that back-end parking is a valid reason to tow a vehicle pursuant to the Texas Towing and Booting Act.
I have a question for Councilor. I'm going to cut through all the chase. I'm a little more common sense. I want to apply a little bit of common sense in here. Two questions that didn't kind of glean from the report here. Number one, how long was the car parked there? Do you know?
No, I don't. It was less than a day.
And do we know the reason why the car was backed in?
That's where she always parks.
And we would object, those facts are not in the record.
Yeah, we don't know.
quick. Two separate incidents. One is the general, Dollar General, and one is the apartment complex. We've been talking about the apartment complex for the most part. And the Dollar General tow, did the family get their money back for the tow, or did they have to pay for the tow?
They paid for the tow and they filed a lawsuit and were actually sanctioned by the court.
The family was?
Yes. Amount of $525.
For a tow that they're contending your client had no right to tow their vehicle. They got fined $500?
They contended that and lost, yes, upon a review by that justice of the peace of the evidence and arguments.
Which is in
Absolutely.
the record in this case, I'm assuming?
Is it in the record?
It's
I'm
in the
sorry.
post-record briefing, and it was objected to by petitioner, and the judge never made a ruling on that objection in the post-briefing. It
No,
was
that's-
also offered, but I'll get to it, Michael. It was also offered at the hearing itself. Petitioner did make an objection. That objection was ruled upon. In the post-briefing, it was again submitted in closing arguments. Petitioner again made an objection. That objection was not ruled upon.
An objection was made at trial when Mr. Lightfoot sought to introduce evidence from the JP hearing. The administrative law judge found a JP ruling was irrelevant to a enforcement action. That ruling did not disappear because then we submitted our argument in post-trial briefing. And the reason a JP ruling is irrelevant is because the only thing a tow company has to show to justify a tow in front of a JP is that there was probable cause. You know, probable cause is very, very low standard of evidence. Mr. Lightfoot talks about the tenant signed an agreement and then broke the agreement. I'll flip it over to you. The landlord gave her a lease with an illegal term in it, you know, because the law says void and unenforceable. I'd also point out that the idea that 253 addressing unattended vehicles is not exhaustive has already been ruled upon by the commission. The administrative law judge, Judge Arnold, said 253B 1 through 6 is exhaustive. The commission adopted that proposal for decision.
Can we pull up the slide for the void? The next slide.
Provision G.
Any further questions?
I have another question on the
Yes, sir.
Bridgewood Plaza case. Was there any, and again, I think this may have been provided to the ALJ, but was there any evidence provided that there were no signs, or were there any was there evidence showing that there were signs posted?
The parties presented their evidence. The administrative law judge found, as a matter of fact, that proper signs were posted, and staff chooses not to challenge that factual finding because judges are in a unique position to assess the credibility of the witnesses. And so staff is not going forward with the tow in the absence of the sign.
I make one final remark. A lot of it's been made of G and absolutely out of context. When you look at 2308.253 G, right, it's trying to enforce the terms of its own provisions, right? Look at E. When you look at 2308.253, you see that there's a requirement that there be some type of notice. You can't contract around notice. You see that in various statutes, saying you can't, if we're going to pass a law, you can't just contract around it. Sorry, it's the law of the state of Texas.
So this agreement on or after January 1 of 2004?
Yes.
So it is in conflict? or
No,
inconsistent?
it's not. In order to, the only
I'm
way
reading
it could
says
possibly.
The provision of an apartment lease or rental agreement entered into or renewed on or after January 1 of 2004 that is in conflict or inconsistent with this section is void and may not be enforced.
Except that the contract absolutely is not in conflict because the incorrect interpretation advanced by petitioner is the only way that contract could be in conflict.
Yeah, I don't read that there. Any further questions?
Mr.
Mr. Chairman, I
Shaw.
don't have a question, I have more of a comment and a suggestion. I think, and somebody correct me if I'm wrong on the commission, but we are bounded by the Texas Occupation Code 25253. Am I correct? We're not really bounded by the property code.
We don't do anything with the property code.
Second, the rules specifically state what they state. I mean, I'm reading G like you did, and it says that the provisions of an apartment lease or rental agreement is entered into or renewed on or after January 12th that is conflict or inconsistent with the sections is void and may not be enforced. So does that mean that any, based on what the opposing counsel is stating, does that mean that an apartment complex could go in there and say, if your vehicle tires were on the white strap line 1 inch in and 1/4 inches out, then you could be towed? I mean, somebody help me on the commission understand, is that something that could be possible? I mean, if you back up a vehicle and then
That would
you're.
be, that would be based on the property code itself,
Correct, and nothing to do with the occupation code.
which has nothing to do with us.
It has nothing to do with us, which the occupation code does not state that a vehicle that is backed in can be towed. Neither does the occupation code state that if a vehicle was on the white stripe lines and didn't quite fit into those white stripe lines, it was 1/2 inch in and 1/2 inch over, that it could be towed. So I make the argument that I think we're bounded by the Texas Occupation Code, and that's about it.
And again, if I can make a brief response. 2308.253 is not an exhaustive list. In fact, there's a 252, there's a 255, and when you look at the Texas Towing and Booting Act, you see that you can tow a vehicle so long as proper notice is given by having the proper signs placed for at least 24 hours in advance, which the parties have already stipulated to.
Those sections address unauthorized vehicles.
Yeah, and I think that's the question, whether it's unauthorized or unattended. And that is where 252 and 255 come in.
Sure, and when you look at the ALJ's analysis, you see if the vehicle is unauthorized, right, if the vehicle is unauthorized, respondent wins because respondent's interpretation allows for a vehicle to be towed.
And if it's unattended?
And if it's authorized, respondent still wins.
So if it's unattended?
Right, so it can either be authorized or unauthorized, right? If it's unauthorized, then respondent wins. Respondent wins because 2308.252 and 255, right? If the vehicle is authorized, respondent still wins because TDLR does not any longer have jurisdiction over this case. You've correctly stated, Chapter 92 is none of your business. That was the ALJ's point. The ALJ looked at petitioner and said, petitioner, Chapter 92 is none of your business. What are you doing here? Don't bring this case before me. At least not strategically fashioned in this manner, right? Who forced petitioner to sign those stipulations? Nobody. Petitioner did that. Petitioner took that strategic decision to present this very narrow case before you. The ALJ looked at those very narrow facts and said, you brought me the wrong case.
Mr. Lightfoot, what concerns me is twofold. Consumers aren't concerned with the minutia of this, in my opinion. I think this could have been done and solved by good faith efforts between the property owners, tow truck company, and we could have discussed session, because there's a precedent. I mean, there was an incident prior to this, and that's the concerning part for me. And I may agree that there's a collision of two codes here. It's going to cause a lot, and so, but my concern is ultimately, as a commissioner, is to be given latitude to be able to say, is good faith being processed here? And I feel like that wasn't the case. And because again, nobody wants to have their vehicle towed, period. And it's just a conflict. Nobody wants that to occur. And that's important for the tow truck company to understand and take that with the gravity of that comment in their actions. So to avoid that, I think they could have picked up on something. That's what I keep coming back to. And then it's important for you, I just want you to, in my mindset, in the collision of these two codes, I don't think we're gonna solve that today, and I wanna respect the statutes and the legislature's authority. But but as the authority we have here, to the consumer, he's not concerned with this. He's saying my car got towed because I got parked backwards. And there's probably more incidences that could be severe to that cost.
In direct response, there is a substantial public policy in favor of non-consent towing, right? Because the same consumer doesn't want to drive to his own apartment complex and see someone parked in 3 spaces, or some drunken fool park diagonally and block all the handicap
But that was
spaces so
the
he can't
case.
get his...
The case was it was back. But I
Correct.
don't know how offensive that is compared to 3 spaces or a drunken fool driving through a fence.
And again, there's public policy favoring back end, there's public policy favoring no back end, and it's simply not the prerogative
And
of
that one's a
petitioner.
that one is a complex one, but the Dollar General one is the one that bugs me a little bit more. The property one is complex because, you know, I understand the issues at play there. And they're competing statutes, I understand that. And so that's something we'll have to wrestle with and make the best decision we can. The Dollar General one, though, I mean, they no longer own the property, and the tow truck company is still towing unauthorized vehicles from that property when there's nobody there to unauthorize it.
Except there is. So, to go back, there was a fundamental dispute, just as you stated, between petitioner and respondent, and petitioner advanced that very argument, except that petitioner didn't provide any legal support for it until its final response and its exceptions. The one case, mind you, the one case of legal support, the Hathaway case, was an employment law case that the Texas Supreme Court has cited multiple times in the sole context of employment. A salesman had agreed to a commission rate, he got in a dispute with his employer over the rate. Hathaway had absolutely nothing to do with the contract in this case. In stark contrast, from the very beginning, respondent advanced cases, cited cases from the Texas Supreme Court for a number of propositions. Those propositions are actually stated in the proposal for decision. But for example, that a contract that pursuant to its own terms renews unless there's some type of termination,
Even
still
if
renews.
One of the parties to that contract is no longer.
Absolutely, even if the party dies. Absolutely, that is Texas common law.
This is the problem, is that I'm a simple son of a construction worker. And if I park on a property that's no longer owned by one of the participants in that contract, and I get my car towed, I'm gonna be kind of angry. That seems wholly unfair to me. And I don't care what the law says, that seems unfair. You know, I understand the law, and we all have to live with it. But that doesn't mean that it's not unfair.
Mr. Chairman, I think I've exhausted myself with this case, and I am beginning to believe that should the commission inject this collision of 2 different codes into our deliberation, then we're opening up a Pandora's box for the future cases that we'll see. So, with that, if there's no other questions.
Do we have any other questions for either Mr. Shirk or Mr. Lightfoot?
No, but I'd like to respond to that comment.
Okay.
And
Hang on, do we have any questions? Because if not, I can excuse them and have them go.
Okay.
Thank you very much. You did a great job.
Thank you.
So,
So my comment is, and I think I've
You
made
did
this
too,
once
sorry.
before, I am not a lawyer. And when Mary Frazier asked me to move from the accounting board to this commission, one of the things I said, you understand I'm not a lawyer, and her answer was, we want you over there to exercise good business judgment. So I was told precisely not to focus on trying to interpret a code, because I'm not a lawyer, I'm not trying to do it. I was told to come exercise good business judgment, and I don't want us to lose sight of that. And maybe I'm the only one that's ever been told that, other than Fred.
Your motion, sir.
And so, Commissioner, if you could elaborate a little bit more, I'm kind of lost with those words. Are you stating that?
I'm saying that to arbitrarily decide that we're only going to look at the occupational code is in direct opposition to what I was told to do when I was brought on this commission. That's all I'm saying. That's all I'm saying, is to look at it as a lawyer is what I was told not to do.
And that's exactly where I'm going with this, and that is, I don't want to look at it from that perspective of a lawyer where the two codes begin to collide and we're trying to figure out which code applies, which code doesn't apply, and which parts of it apply. So with that, I'm ready to make a motion to overturn the PFD by applying section 2308.253 related to unattended vehicles to this case and not the property code, chapter 92, landlord tenant, as recommended by the ALJ.
So we have a motion.
I don't know what the motion is.
Yeah, I'm not, yeah.
It's to overturn the PFD,
So,
to reject the PFD.
In its entirety?
No, just for, and I thought we were.
Are we gonna split
no, we're gonna do
them?
both cases, we do both of them at the same
You want
time.
to do them both at a time?
Yeah.
I apologize, I'll withdraw my motion. I was
Yeah, because
hoping
we
to
have that
split it.
PFD that's been brought before us, and they both have both of them, but you're saying that to reject the PFD, that is for which tow again? Or which tow case?
I was looking at
Is that 9122?
9122.
That's the apartment case.
That's the apartment case, right? Okay.
And
I'll be happy to withdraw my motion and let somebody else make.
Well, I didn't know if you, well, I think we leave that on the table right now. If someone's going to second, we can probably amend it, have a friendly amendment to address the,
Can we make
the
a
parking.
motion to, Mr. Chick, and I offer, can we make a motion to maybe split the two items?
well, I think the issue that we have is only one PFD.
Can we vote on it in part and then join the motion, join the order together? Because I think it's gonna get real confusing if you keep, if, not you, but if we address them in
Brad,
total.
I might suggest that you discuss them separately.
Okay.
Because if, there is going to ultimately be one order from the commission. And it might get tricky if they're split votes on the two issues and how that plays out in terms of the final order.
Because we
But
only
you
have
could
one
break them
PFD.
up in terms of discussing them and trying to resolve the issues, would be my
So the
thought.
discussion on, well, okay, so we have currently have a motion on the floor.
I thought he rescinded it, did he not?
I did.
Did you?
I did rescind
Okay.
it.
I wish Ann had done that.
Well,
Okay,
it seems
so,
like I can start again, and maybe I'd like to see if we can combine both.
well, and if you have an idea on the second case and want to put a motion with that, then we can discuss it, and if nothing else, we can always amend it.
Would that be okay, Mr. Bowe?
Yes?
Okay. Then I'd like to also,
So we go back with the original motion,
yeah,
okay?
and then I'd also like to reject the PFD as presented.
Which would be for the towing case
Okay.
of Dollar General, for lack of a better word. Based on,
The conclusions of law, which I can get into that motion if you want me to go further.
yeah, we probably need to have that on the record as to why we're rejecting the PFD.
Well, let me start with the first one. The first one is to overturn the PFD by, as I said, applying section 2308.253 to this case and not the property code, which is chapter 92. Specifically applying conclusions of law 5, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, and 20, and apply the amount of $4,000 in penalty fees.
And no revocation, or is it only the penalty?
I would like the revocation included in there as well.
And revocate the license.
And
Okay.
revocate the license.
And the second part?
The second part would be similar to overturn the ALJ's findings of the fact, with the exception that this issue should be, is overruled based on the conclusion of law 21 through 23, and conclusion of law 24 that could be modified to impose a $4,000 penalty fee and revoke the license.
So basically, what we're talking about is an $8,000 fee and revocation of license, and rejecting the PFD as presented to us.
It's based on the conclusion of law that I mentioned.
That you mentioned, right. So we have a motion on the floor. Is there a second? No second. Motion dies for lack of a second. Commissioners, any other motion be brought forward?
Chairman, I'd like to make a motion to accept the
$4,000 fine, cut the fine in half, and not for revocation of licensing.
So
I'll
the-
second that motion.
Okay, and just a point of clarification, the $4,000 fine would be,
For both, because instead of 8.
2,000.
so it'd be $2,000 for each
Right. Cut it in half,
And no revocation.
and no revocation.
no revocation.
Okay, so that would, so you still want to modify the PFD though?
Right, correct.
In the ways that.
We just
that
mentioned.
Okay, Commissioner Shaw's motion.
So, based on the conclusions of the law, findings of fact that were previously mentioned in the previous motion, your motion is to reject the PFD, have a fine of $2,000, but no revocation.
Right.
And that was the second also.
$2,000 each
Case.
incident.
Right. Okay. So now we have a PFD for $4,000 fine, no revocation, and to reject, or modify the PFD. Now, is that correct, Brad? Okay.
Correct.
So a motion and a second. Any further discussion? Yes, sir.
I think that may be a good proposition as a motion, but I will be voting against this motion, and for obvious reasons that have been, I think, cited by our counselor. And I truly appreciate the opposing counselor making his arguments the way he did, but I think I want to make sure that we don't get too mesmerized with all the minutia of the legalese that was brought up. I think I would urge the commission to look at the facts, and look at the facts that we are bounded by as a commission. So with that, I'll let you call the order.
Okay.
Mr. Chairman, may I
yes.
ask a further point of clarification here?
If we can clarify it.
Okay. On the motion, is the rationale for the motion basically accepting the Enforcement Division's arguments in their exceptions and that they've urged here on the two cases? In other words, when in crafting this order, is that the
The
underlying?
rationale is two parts. One is to accept the arguments on our side. And not only that, but to also to allow us leeway for the fact that this isn't ambiguous by nature.
Thank you.
There's still a confused look on your face. Did it
I
clarify?
always have that.
Okay. I just want to make sure we clarified your
Yes, sir,
question.
thank you.
Okay.
This is for suspension, I mean.
No revocation.
No revocation.
No
Got it.
revocation.
Got it.
Just a fine.
Got it,
Yeah.
okay.
So it's just the fine, basically, is what it
Yeah,
is, $4,000 fine.
Yeah, it's still contract,
And I can tell you on my part, again, I have an issue with the property code being brought in. I don't want to muddy the water, so I'm for that part. The second one, I think that it's difficult because of the previous ownership and the transfer of that. So I have an issue with that personally, also in my decision making. So anyway, let's go ahead and move to a vote. All in favor signify. We don't need clarification on the motion, right? We have it. Let's, all in favor signify by saying aye.
Aye.
Those opposed?
No.
Let's
No.
go ahead and take a vote.
Carl Butler,
Aye.
Helen Collier,
I'd like to ask for a clarification again, because what we're voting on.
The clarification would be to amend the PFD to decrease the fine of each violation of $2,000, no revocation. And basically, we're amending the PFD because of the fact that we still have the $2,000 fine, but based on the conclusions of law that were brought forth by Commissioner Shaw, in the fact that we did not agree with the ALJ on the decision made concerning the property code and the fact that there was a previous agreement with the property owner prior to.
And we're not able to separate the two. So-
Well, if we had had two different PFDs, it'd be easier, but with one PFD, we had to have one order going forward.
Mr. Chairman, we have a motion in order.
We do, we're just simply clarifying the PFD, I mean, the motion that's in order. So, Commissioner
We already
Collier.
called the
sorry.
answer, so.
Commissioner Collier.
Aye.
Chris Figueroa,
Aye.
Catherine Rohwald,
No.
Bobby Shaw,
No.
Deborah Yurko,
No.
Mike Smith.
No. So, Commissioners, the motion fails. A new motion would be in order for those that voted no.
Want me to tackle it? I'll
Go
tackle
ahead.
it.
Know what's the story.
Okay, I'm going to move to adopt the PFD on the first portion of that. What would that be? Case number 9122. And then I would move to adopt the PFD in 12986. Is that what you were thinking? That's what, I mean.
So you're saying to adopt the PSD as presented to adopt the PLG?
Right, ALJ's one on the second one, not on the first one.
So reject the first portion of the PFD and accept the second PFD.
Right, and to not include a revocation of the license.
So the motion is to amend the PFD to reject the ALJ's decision concerning the property code that we have before us.
As it was
As
enumerated
presented.
before, the conclusions of
before.
law 5, 8, 9, 10, 11.
And then
12.
to adopt the PFD, or again, in the amendment portion, is to accept the ALJ's recommendation of the $4,000 fine, but no revocation. Is that what you're saying? Because the second piece of that was also a $4,000 fine.
Can we get back to where we're at with my original motion?
Well, I think the difference is that based on the first part, we are rejecting the ALJ statement that the property code should have been included. So this is an effort to separate the property code from the occupations code. I think your motion took into account the property code. I think this motion is to separate the property code. So
Same
is that-
punitive damage.
Is that correct?
Yeah.
Yeah, I think the monetary is still the same.
Now, I think the monetary comes out to be the same, correct?
It is.
Yeah.
So, just again, clarify. This PFD, there were basically two decisions made by the ALJ. So your motion is to reject the first portion of the PFD, which had to do with the towing order of 9122. And that's based on the conclusions of law 5, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. And then to accept the PFD on 12986 and assess a $4,000 fine and no revocation.
Correct.
Does that sound correct?
I think we understand.
Okay. So we have a motion on the floor.
Now, what are we doing about the $4,000 fine on the first one?
That's all been rejected.
Great, okay.
That'll be rejected.
That's what I'm making, okay.
Would you say that would not be applied, right?
$4,000 would not be applied. So we have a motion on the floor?
I can make a, I can't make a friend until I get
Is there a second on it or not?
Not yet.
I'll second
We have a
that.
second
I'll
by
second.
Commissioner Butler. Commissioner Shaw.
If I can make a friendly amendment and see if the motion maker wants to accept that, which is fine if she doesn't. I feel like the punitive penalty that was applied on, and again, this may be semantics, but the punitive fines that were applied should be applied on the first rejection of the PFD and not on the second.
Oh, I see what you're saying. I think the statement that I made was
You
that
still
the
come up with
$4,000 was
$4,000.
applied towards the second.
Yeah.
So, that's a good,
Okay.
that's a good point.
Mm-hmm, okay.
I don't understand that, I'm sorry.
Let me rephrase. I think everybody is in favor of the PFD. I'm assuming this, but everybody appears that the motion maker is in favor of the PFD being adopted as presented, which includes a $4,000 fee. But we all agree that the PFD for that, applies. All I'm saying is that if we are rejecting the first PFD with the conclusion of law that have been stated, we should then apply
A $4,000
the
fine.
4,000 to that first PFD that we are rejecting, which is what TDLR proposed, an $8,000 fee. We're just saying we'll split that one and apply the 4,000 to that. And then on the second PFD, adopt the PFD as presented with no fine to it and no revocation.
You're talking about splitting them up. You're talking about
We
one.
have to split 'em up.
When you say the first one, are you saying to the, and let me make sure I understand, are you saying to the apartment complex?
Yes.
And the Dollar General?
Yes,
You're
the
saying
apartment
so
complex.
applying the $4,000 fine or penalty to the apartment complex case and nothing to the Dollar General case?
Correct.
And that's, this is Brad Bowman, that's what I understood the motion to be, because the ALJ assessed no fine, found no violation for either one of your case.
the
So-
opposite.
I agree. I think it really is the
I
opposite,
think-
because
I
I don't
understood
think
it
there
to be
should
the
be a
opposite.
fine on the first one. I think it's just very
That's what
yes,
I
agree.
seconded. I
Yeah.
seconded the accepting a penalty for the Dollar General non-consent tow.
I agree.
Is that
Yes,
correct?
yes,
Okay.
I agree with you.
We're copacetic.
So basically, we're rejecting the PFD as a whole.
That's wrong.
Robbie thinks we're crazy.
Yeah, I think you are.
Brad, is that correct?
Mr.
Basically,
Lightfoot, this is your fault.
yeah.
Don't ever come here again.
So
I
basically-
must have misunderstood the motion. I thought that the commission was rejecting the judge's reasoning on the property code issue regarding the apartment complex tow, and that if there was going to be a fine assessed, it would be associated with that case.
So,
Because if you accept the judge's findings on the Dollar General case, there would be no fine associated with that because the judge
Okay.
didn't find a violation.
So
Is
they
that-
want the,
so did you get that?
end game is to want the fund
So-
for and separate the property code. That's our end
Robbie
game.
really is Solomon and not Gilligan, is what it comes down to.
So,
understand?
did you understand basically, by rejecting the PFD, the first portion of the PFD is to assess that $4,000 fine that the enforcement division had sought, which had to do with the property code.
Right.
To accept the second portion, then you basically find that the towing company did nothing wrong.
On the first one or the second?
Second.
The second one.
Okay.
I accept it.
Is that what you're after, or you're saying they did something wrong in the Dollar General case and not in the property code case?
I'm really extremely confused. I thought I knew what I was doing, and I have
That's
no
okay.
clue
Robbie,
now.
make your motion.
Okay, hang on a sec. So we do have a motion and a second. If you're willing to withdraw, we can try this again.
I'm happy to
Yes,
withdraw.
let's
Okay,
withdraw it.
and who seconded? You did. So
Yes.
let's take another stab at this because
I'm
we are
gonna take
definitely
a
all
stab at this
confused.
thing if it's okay, Mr. Bowen, maybe if you wanna help me, you can in between, but,
I'll do my-
I make a motion to, in the first part with the 9122, reject the PFD using the conclusions law as I stated, and I'll repeat them again, 5, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, and 20, and apply the $4,000 penalty. In the 2986 case, adopt the PFD as presented with no penalty fee and no revocation of the license in
Okay.
either one.
Okay. So we're back to the $4,000.
Right.
But we accept the PFD. Yeah, monetarily was still there. We're back to accepting the ALJ's decision on the Dollar General case, that the towing company did nothing wrong.
Based on the vacancy.
Does that sound like we're on the right track? Or, I mean, does it sound,
It sounds like
it's not convoluted or anything?
a good, a motion that's,
Well, it may,
Makes sense.
it may be convoluted. So we have a motion on the floor. A second will be in order.
I can second Robbie's.
Okay. I was hoping that wouldn't die for a second. Let's go ahead and vote. We have a motion, second. All in favor signify by saying aye.
Aye.
Those opposed?
No.
No.
Okay, just for clarification, can we take a roll call, please?
Tom Butler,
Aye.
Helen Kellier,
Aye.
Rick Figueroa,
Aye.
Catherine Rodwald,
No.
Bobby Shaw,
Aye.
Deborah Yurko,
No.
Mike Rosati.
Aye. Okay, so the motion passes 5-2. So, Mr. Lightfoot, appreciate your time. I'm sure if, you may not be confused, we're confused, but the staff will be with you and kind of talk about the different things. Commissioners, real quickly, is lunch here? No? Okay. What my plan is we have to go back in executive session. We've had something come up that we need to talk about. So the plan is to go into executive session and discuss the executive session item, also eat lunch. So what I want to do, if you allow, let's go ahead and trudge through the items that we have witnesses here that have come to speak, which means that we may start jumping through this agenda. And if you're okay with that, let's go ahead and jump to F9. Mr. Ariano? Okay.
Okay, what's the next one?
Yeah, let's jump to item 14, Wesley Parker. Mr. Thielen, if you don't mind coming up. Mr. Parker, go ahead and have a seat up here.
What item?
We're on item 14, F14. Let's take a, yeah, we've got quite a few people having, I think.
Seeing yellow?
So, stay there. Let's take about a 2-minute break, and then that way it allows the people to go and take care of some business. 2-minute break, 2-minute break.
function, resulting in 1, less efficient function with higher consumption of electricity, 2, violation of the UL listing for the furnace, and 3, an inability to perform its heating mode when the cooler months arrived. Respondent admitted to installing this incorrect part, but claimed that he only did so because the correct part was not immediately available and cooling was needed quickly. Respondent claimed that he would have come back out to install the proper part later on, but for miscommunication from the homeowner. In response to that, the homeowner testified that the respondent never mentioned the fact that the part was incorrect, the offer to come back out, or that the furnace would not function or heat as designed. The ALJ found that the respondent committed the alleged violation and considered the appropriate penalty. The ALJ accepted respondent's explanation, but also noted that when the homeowner contacted respondent about the lack of heating operation, the respondent failed to take advantage of that opportunity to correct the problem despite his ability to do so. The ALJ found that the minimum penalty of $1,000 and a 1-year probated license suspension was appropriate. The department recommends you adopt the PFD as written. Do you have any questions that I can answer?
Any question for Mr. Thielen? Yes, sir, Mr. Shaw.
I didn't read anywhere in the brief when this repair occurred. Was it in the summer months?
Yes, June. No.
Hang on a second.
Yes, the PFD, yes, it was June 1st, 2013 is when we alleged the violation occurred.
So usually during that time period in Texas is pretty hot.
It is.
Thank you, sir.
Any questions for Mr. Thielen? Or additional questions? Mr. Parker, if you don't mind, state your name for the record, but as you heard before, you can only confine your comments to what was presented at the SOA hearing. Anything outside that, I'm sure someone will stop you.
Okay.
So, state your name for the record.
Marvin Wesley Parker.
Proceed.
Guilty. I did put a different motor in, but there's reason for that. On Tuesday, 28th, 2013, Mr. Wong called my company to come out, check why his AC wasn't working. Found out that the blower motor, which had the furnace, which had an ECM blower motor, was not functioning, need to be replaced. Okay, so nobody stocks ECM motors on a truck, so we have to go find one. And when you call around, there's several companies you can call about getting one. Well, Wednesday and Thursday go by. I'm calling every company I know. I'm having my supplier check. He even checks with the manufacturer. And the manufacturer tells him that it's going to be probably 3 to 4 weeks before they can get a blower motor, okay? This is very unusual. This is the beginning of the summer months, and for them not to have something in stock is just mind-boggling to me. But anyway, so Friday I attempt to do a repair on the motor itself. There's a little current sensor inside the motor, and it's about 80% problems with them while they go out. So I sit at the dining room table with the Mr. Wong's grandfather attempting to repair this motor. You have to solder one out, solder the wafer out, and put the new one in. Well, and I put it back inside the attic. And keep you in mind, I'm doing this all on my own. I mean, I'm trying to help this guy out, fix his motor, give him some AC. And if they had an ECM motor, we wouldn't be here right now. If one was available, believe me, I didn't want to have to get in his attic and do all this alterations, modifications to make the motor work. So anyway, so I explained to Mr. Wong, when we find out that the repair doesn't work, I explained to him that he's only got 3 options. 1, be without air conditioning for 3 or 4 weeks. Number 2, put a new furnace in, which is going to cost him about $3,500. Or the 4th one is or 3rd one is I can put a regular motor in, one that used to, we used to put them in all the furnaces before the ECM motors came out. It's a new technology. And so I told him I could do that. He asked me how much. I said $400. He tells me, he says, okay, well, you know, we've been without air conditioning for a week. I gotta have air conditioning for my family. So I have to determine there, you know, I mean, first of all, he has an elderly grandfather, an elderly grandmother, and a young daughter, probably 3-4 years old, along with his wife and himself, living at this house. It's a nice house in Capel. And, you know, and I know I can do this. I've got the experience to do it, where a lot of people wouldn't know how to do it. But I put a motor in, a regular PSC motor in. The man pays me. One thing I want to back up and tell you that I did tell him that this is a temporary fix. This is not permanent. I even disabled the heat so that the furnace wouldn't run. Because if by doing that, you would go bypass a lot of safety controls. So I disabled his heat so it wouldn't run in the winter time when he turned the furnace on. But it ran all summer long, didn't have any problem. And when I told him how much it's going to cost, $400, which is really cheap, but he said, okay, well, when the new motor comes in, will that 400 be because he asked me how much the ECM motor costs. I told him $800. He goes, well, will that 400 be applied towards the 800? And I said, no, this is just for this motor here, this PSC motor. It's to get you by during the hot summer months for the 3 or 4 weeks. So, and then the next thing I know, I'm getting a complaint filed against me. He doesn't call me in the wintertime. He called another company. And that's when they discovered, you know, this situation.
In the testimony, did he agree, the complainant agree that, you know where I'm going with this?
I can answer the question.
Go ahead.
The complainant disagreed entirely with the respondent's version of the events. The complainant said that it was never explained to him that this was a temporary fix, that this was the wrong part, that he would have to call him later on. Furthermore, the complainant, the homeowner, testified that he did call and couldn't get the respondent's company to respond when he tried to turn the furnace on in the winter months. Now, what the ALJ did is the ALJ took the respondent's version of the events except for the part where the ALJ did accept the complainant's statement that he called when it got cold and he tried to turn the furnace on heat mode and didn't get any response from the respondent.
So the ALJ believed that there was an agreement between the two to install that blower motor.
The ALJ believed there was a miscommunication due to language difficulties.
So there was a conversation that took place, though.
That's what the ALJ concluded. The complainant vigorously testified that they never had all of the discussions that Mr. Parker's putting forth. But given the ALJ's acceptance of his defense, we're not seeking the $2,000 penalty that we were. We
You're
urge
seeking
you to
$1,000.
take the $1,000, which is the minimum of the range for this Class C violation.
What are you hoping to get out of this?
No fine. $1,000 is a lot of money.
See that?
And I've also, can I say, I've had my license for 33 years, and not one complaint has ever been filed.
I have a question for you. Okay, and there may have been a communication issue, I don't know.
There
but-
was.
Okay, but assuming when you did the $400 fix, and you explained to him it wasn't gonna fix the problem, did he order the $800 motor for the future?
No, we were just gonna go with it until, you know, later on down the road. We didn't really specify a time, just later. But I think there's even some paperwork in there that shows, that says he acknowledged it was a temporary fix.
Well, I would disagree with that characterization. This is the invoice from Mr. Parker's company. It talks about replacing the blower motor and the capacitor in the furnace. It has the $400 down here. It doesn't talk about anything that was supposed to happen in the future. It doesn't talk about the kind of motor
Doesn't
that
say
was
anything about
installed.
temporary fix, anything like that.
No, it doesn't give any of that detail. It's, you know, like most invoices, it's just the bare bones of what their agreement was.
But is there a separate estimate sheet or anything?
Not that was ever a part of the evidence or
It sa-
in the case
it-
file.
It says in this complaint here, to make the blower motor work temporarily, Weston Company AC and Heat altered my system and rewired the control board to accommodate the incorrect motor.
And I believe that's based off of the complainant's understanding of what happened after he hired this second company to figure out, why is my furnace not working?
Wait,
Is that
wait, can you read it
speculation, or-
again? 'Cause that's not what it, can you read it again?
Says, to make the blower motor work temporarily, Weston Company AC and Heat altered my system and rewired the control board to accommodate the incorrect motor.
So the complainant stated it was temporary.
Yep.
Is that correct?
In his complaint, after he hired another company to come out and figure out what was going on,
I understand that, but what I'm
And then
saying
made a
is the
complaint to
complaint he
us.
wrote to you or to our agency, the
He said
wording
temporary.
he used.
the wording, we called another AC technician to check out our heater. He found out that the work did by Weston Company AC and Heat Incorporated was not professional, with the problems listed below, inspection report attached, incorrect blower motor, which does not match my furnace. So I believe he's referring to
No,
the
look
invoice
at
from
number
the second
three.
company.
Look at number 3.
Right.
What does number 3 say?
It says to make the blower motor work temporarily.
There you go.
And
So that's the
again,
complainant's
Yep.
word.
Could we see that, Mr. Parker, from you? This is all part of the record, correct?
Yep.
these are exhibits.
Thank you so much.
Mr. Chairman, while that's being passed, can I ask a couple of questions?
Sure, go right ahead.
Okay,
And what he's referring to is this invoice from another company called First Call, which says, system has been altered by another company outside of manufacturer specs and recommendations. He's
Right, I understand that, but what we're talking about is that the complainant said in the complaint to the department that it was a temporary.
Sure, he
That's what
found
we're-
out what happened.
He found out, or the complainant says it was a temporary fix?
The complainant is giving all the facts that he has when he makes the complaint, which is after, based off his testimony that was at the hearing, he knew nothing about what was going on. He got other companies to take a look at it, found out what happened, that this other part was put in there as a temporary fix to get the thing working, and described that conclusion in his complaint. I think you're coming to the wrong
Mr. Shaw.
conclusion from
Shaw,
cherry
go
picking
right ahead.
words.
Yeah, I have a couple of things. First of all, I think this is a case of, and having read this thing very thoroughly twice, looks like no deed goes unpunished. And I think, is that a correct statement?
No good-
No good
No
deed.
good deed
No
goes
good
unpunished.
I get my metaphors mixed up, so, yeah, but this is one of those cases where no good deed goes unpunished. And back to the issue of the International Residential Code and the PSC motor. If I can ask, Mr. Westwood, Parker, were the PSCs not acceptable at any time in the code, or have they
No, just, they used to be used all the time until 2000. And they come up with this electronic motor. And the only difference is that it's more efficient than a PSC motor. That's the only difference.
And my line of questioning is that the change in code occurred in 2000 or 2006, stopping the PSCs from being installed versus the ECM.
No, they're still being used.
So PCSs are still being used?
Oh, yeah.
In existing
Yes,
HVAC
yes.
units? So, for the commission, and again, I'm just bringing that up, the reason that the newer HVAC units have the ECMs is for one reason only, is for efficiency.
Right.
Can I?
Yep.
33 years, not your first rodeo.
No.
Right? You saw this train coming. You knew there was a miscommunication, this guy was probably right, and there was no documentation. and you knew the heat was gone. So sooner or later, he wanted to turn the heat on. I mean, other than that, I mean, the heat had to come on.
And he was supposed to, in our conversation, he was gonna call me.
Right, right. I got you. I'm just saying, there was a train coming down, because the guy was gonna get cold one way or the
Yeah,
other.
but when he called me, I was gonna go out there and fix the problem, charge him $800. Instead, another company went out there and charged him $1,200. So now he's ticked off.
So, is there any evidence of him calling, Ms. Parker? Or does he have any
The
phone calls?
testimony of
Testimony?
the homeowner
Okay.
is his
And you're saying
evidence.
you didn't receive a phone
No,
call?
he called me after the repair was done and complained about, he
You're saying
wanted
he
four.
didn't call you prior to?
No, he did not. Matter of fact, I think it's in the minutes that I asked him why he didn't call me. He did not have a response for that.
I'm not sure what minutes he's
Well, when I
referring
talked to
to.
him over the phone, remember when I talked to him over the phone?
During the,
I
SOA
believe he's
hearing?
been
Yeah.
referring to,
SOA hearing.
Yeah.
talking during
Yep.
the SOA hearing.
Yep.
I think he's mischaracterizing what the evidence was in the testimony.
But 33 years, you saw this. I mean, this was, you gotta have seen this coming, because it wasn't like that you had a different motor and he was just gonna have an inefficient system. You had a different motor, and you also said that you disabled the heat.
Yes.
For safety purposes.
Yes.
So that motor could have, if the heat was on, it could have done some serious damage.
I wasn't going to because I disabled it.
I know, but that's
Had you.
why, sooner or later, you basically, the HVA system didn't have any H in it, basically.
Yeah.
Correct?
Yeah.
Okay, okay. That's all I mean.
I'd like
Reading
a,
here this complaint.
I'm sorry?
I'm reading here off of this complaint.
Yes.
I'm led to believe that he said that he noticed that the heater was not working, which is several weeks ago, end of October, when he says, I noticed the heater was not working properly. We called another AC technician to check our heater. So
Right.
there was never reference to him calling to get it fixed.
In his original complaint, he didn't refer to every single thing that he did to try and get it
Well, don't you
fixed.
think he should have? I mean, shouldn't he have not put in here that he attempted to contact, he didn't respond? I mean, there's, there's too many
I think-
holes
I
in this
understand,
thing.
if I may, I understand why you did what you did, and I understand why you have to bring this forward. And
you go.
I think both of y'all are doing the best that you can. I think both of y'all are doing what you feel to be right, and I
Thank you,
know
sir.
you're doing what the law says, okay? And so, 33 years, good on you, I'm glad. Let's just let's move
Yeah.
on.
Mr. Chairman, I'm a homeowner just like everybody else, and we know how the summer months are. They do get hot, and there are certain provisions. I've had the misfortune of having my HVAC unit go out sometimes, and we've had to do some repairs to it, and those repairs could be, something that may not exactly be correct, where you may not have gotten a permit for it or something like that, because it's an emergency situation. In this scenario, I believe that the PSC that was added in there may have been in violation with the city of Coppell's, the International Residential Code. Understanding that part, I also understand that Mr. Parker probably did this out of good faith and went out and did what he needed to do as a temporary fix, hoping that the homeowner would have come back in again. Again, I'm just going by what was given to us, and making an assumption that the homeowner would have come back and said, okay, I want to now get a permanent fix to it. But instead, the homeowner went out there and found somebody else to do the fix, ended up spending the same amount of money as he would have, in fact, more. Now that homeowner is upset.
Trying to recoup costs.
And he wants to recoup his cost by getting the $400 back that were made as a temporary fix. What he forgets is that his child, his parents, and himself were provided the comforts of the HVAC system temporarily
Yep.
for those 3 weeks. So,
Ran all winter long.
Assuming
all summer
everything
long.
that you're saying is correct, it's still a violation. The IRC says you've got to use the parts that it's designed to work with, and it was not designed to
And I
work with the
understand that, but
PSC.
you know, there's some common sense in here, because no one wants to live in the summer months in June in Dallas with no air conditioning. Or Texas, yeah. I mean,
Dallas
and
in
I
particular.
understand that's correct, but you know, as was mentioned earlier,
Business
there's gotta
judgment.
be some common sense put to this, some public policy,
Business judgment.
protection. You know, I'm sorry, I'm just not buying this case.
Well, and I understand.
Yeah, I
You
understand
are-
where
you-
you're coming from. You have to.
You're, I mean, at least you didn't try to get penalties greater than the minimum. I mean, so, kudos.
And Mr. Parker, was all the communications in regards to the workaround, they were all verbal? Nothing written at all
As the,
to the homeowner?
yeah, pretty much. In the summertime, we don't have much time to write everything down.
Understand. And was there, knowing that you did the workaround, did you leave any type of notations or anything on the system itself?
On the system, no. I gotta tell you, the week before I go before the judge, the administrator here, he calls me and offers to withdraw his complaint if I pay $400.
I'll make a motion.
Okay. I guess we're done asking questions?
I'm done.
Okay. I don't know if you want to make any further statements, but I think, you kind of get some idea.
I am not obligated to bring a case just because a complaint was made. I presented the evidence that I thought was true and correct, and that was the testimony from the complainant, not as Mr. Parker is presenting the facts.
Well, and I tell you that from my perspective, you've done your job by presenting this case to us, because you're right, there was a violation that occurred. So you're absolutely correct in that. I can tell you that, again, on my part. But as Commissioner Shaw said, no deed goes unpunished. No good deed. No good deed goes unpunished.
That deed should be punished.
Yeah. So I think you now understand that you probably have to take a second look next time you do something like this. So, Commissioner Butler's right. You both put your case forward because good deed, the law. I understand that, it's a violation, so. But we'll go ahead and entertain a motion at this time.
I would move to adopt the PFD as written and to keep the license suspended for a period of 1 year, but with the suspension probated in reference to the errors done here. But I would move to reduce the penalty to $250.
So we have a motion to basically amend the PFD.
I'm sorry, amend the PFD.
So it will be a suspension probated for a year, no revocation, and the fine to go down to $250. So there's a motion on the floor. Any second?
Okay.
I can tell you, I will second that because I'm not opposed to that motion. So I would second that. All in favor signify by saying aye.
Aye.
Aye. Those opposed?
No.
Oh, wow, okay.
I don't think we have to take a roll on that one.
Nope.
Okay, then let's go ahead and move forward with another motion.
I want to try this. It's clear, and Counselor, you made your point, it's clear that the installation of the PSC motor in the furnace that was designed to not accept an ECM motor, we all agree with that, is a violation of the Texas Administrative Code and especially the IRC. We all know that, and that's a fact. There was a violation. We also know that this was done as an emergency fix, if you will, because and I'm not privy to this, but I don't know if the ECM was readily available or not. So let's assume that it wasn't readily available for the next 3 weeks, and a violation occurred, which I would agree that if you were working in any other jurisdiction, you've been cited for that. So with that, I think I would like to make a motion to adopt the ALJ's findings, reduce the penalty fee to $100, just because I think there was a clerical error made here, more so than an error in good faith, and impose a 1-year probated suspension, just to make sure that this doesn't happen again.
Probated 1 year suspension?
For 1 year.
We could have just simply amended the last
Yeah,
motion.
that's just the amount, are you kidding?
Okay, so we've got a motion to accept the PFD, but with a $100 fine and have a suspended license probated for 1 year. So we're basically back to where we're at, it's less than $150.
Yeah.
Yeah, that's where I am.
Yeah, but that was the same thing as what I did.
No.
You just amended the amount.
No, we're in a different place.
Oh, okay. So we have a motion on the floor.
Suspension.
Is anyone willing to second? We have a motion on the floor? It dies for lack of a second. Anyone else want to take a stab at it?
Is that one?
That one died.
Okay, died. So I move that, that we have a penalty, we have a fine of some order of magnitude that had come to me before I finish this, and that we do not suspend the license.
If that's a motion,
So the question would be, yeah, the order of magnitude for the penalty, which,
okay, let's talk about that, can we? I'd like to fine him $34, because you've been at it for 33 years, and you've learned something new. Okay? That'll be your 34th year. And so, I understand the kindness, but I also understand that you need to watch your backside, because you brought us here, and you knew you circumvented the law. I think you've been working hard for 33 years. I don't want to suspend your license.
I don't either.
I think a $34 fine and no suspension, and goodbye.
So would that be in the form of motion, or would you accept that motion?
I will accept that motion, because I can appreciate what you did. And I know that we're not in the discussion portion, but I
I'll
come
take-
from a mechanical, background, and you see the challenges, and you know what to do, and you know what to do. I would have put a notation on that, just in case somebody else came, to doing it.
Oh, it won't be done again.
Well, yeah.
So
okay.
is that your second? Would that be a second to the motion?
Did I second it? Do I second my
made
own
the
motion?
She made the motion, Tom.
Well,
Second,
okay.
I thought Tom seconded.
I'll second.
Okay, so we got
With the
motion.
$34, sorry.
Okay, perfect. So we have a motion and a second. There's a method to our madness, folks. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Oh, we have it's actually 6-1. So the motion carries. So you have to pay us $34.
You want cash?
It's accepted.
We'll get with Mr.
People have
Thielen on
cash
that.
still?
Mr. Thielen will get with you, so we appreciate your time.
Okay, thank you.
Yeah. Let's go back up to number 9.
Definitely be heads up.
Yeah, exactly.
Definitely be heads up.
Number 9,
It's a risk.
Gregory Ariano.
Okay.
Who are we?
What numbers is it?
Number 9, we're at number 9. Again, I'm gonna try to get everyone that's here to testify, we've gotta get them out of the way, and so that they can go ahead and go about their business and not have to wait for us. So let's go on to number 9, Mr. Rennick.
Commissioners, Robert Rennick, Enforcement Division.
Proceed.
Yes, sir. This applicant seeks a Class A barber license. In 1985, he was issued a barber license by the Barber Commission. It expired in 2008. Then in June of 2015, he filed another application with us. In February of 2002, the applicant pled guilty to the offense of aggravated sexual assault of a child. The court found that the evidence substantiated the applicant's guilt, but deferred adjudicating him and instead placed him on community supervision for a period of 8 years. Only 7 months later, in September of 2002, the court revoked the applicant's community supervision, found him guilty, and sentenced him to 14 years in prison. He was revoked because he violated his terms and conditions of community supervision by going within 100 yards of where children gathered and making contact with a minor. The sexual assault occurred in 2001. The applicant was the uncle of one of the victim's friends. The victim was a 12-year-old girl. The applicant was approximately 37 years old. The victim was at the applicant's home on the day of the offense. The applicant dragged her into a bedroom and had sexual intercourse with her after taking her clothes off and his. While the victim was present, the applicant placed a knife on the dresser.
I would ask that during the prosecutor presenting the case, no comments, no laughing, no anything, just simply sit there if you don't mind.
No, sir, we're doing
Okay,
it.
I just want you to be aware.
Thank you.
Thank you.
Yes, sir.
While the victim was present in the bedroom, the applicant placed a knife on the dresser. He told the victim not to tell anyone. The victim said the applicant sexually assaulted her on 4 other occasions. The applicant was released from prison on September 12th of 2014. He filed the application that is before you only 9 months after he was released from prison. His parole ended on June 11th of 2016. The ALJ recommends that the commission deny this application because of the seriousness of the crime and insufficient evidence of rehabilitation. I'll mention that no exhibits were admitted by the applicant, including no evidence of sex offender counseling. There's testimony in this case that barbers do cut the hair of females, including female children, and the department recommends that the commission adopt the PFD.
Any questions for Mr. Rennick? I do have 2 public comment forms, one from Gregory and one from Christina.
Yes.
Okay? So again, you've heard me before. If you can confine your statements only to what was presented in the case, and then that's, if you go outside that, they'll probably stop you and let you know. So if you don't mind, state your name for the record.
Gregory Frank Ariano.
Christina Ariano.
Okay, proceed.
I would like to mention, that I do realize you have to review what they say is a case or to get the order to get the license, like my license renewal back, because that's my only career occupation. And a matter of fact, for 2 years, 4 months, I've been asking to receive my license back after I've had it 17 years and worked with my dad, my sister, my nephew, and my brother, which they view me on constant occasion. I plan to not work nowhere else. And can I correct incorrection on this case and matter? I say that this was not 8 years. I signed for 8 years, but it wasn't. The facts on this case is not correct. It's very inconclusive. It's really not. It wasn't presented right because the girl wasn't 12 years old. She was 11 years old, and doctors had viewed her. I'm just saying, and may I speak, and please, doctors find factual facts. She had never been penetrated, so I don't know where this came from. Like again, I said, it's September 15th, I believe I was here, and I had mentioned that, I forgot, that these things, this matter, this case, I signed guilty, that's where I was going, for my wife, not considering the case, how serious it was towards me. I signed guilty to get 8 years probation, for adjudication, which I should have went regular, or even asked for a jury, which I didn't do. I signed 8 years for her, be guilty just to be with my wife of 2 years and a half months, because we were so in love and so real in togetherness, and she was always watching me, and was 4 years older than me, and was always with me everywhere. And I never discluded my wife in any occasions or any matters at my mom's house where they say this case occurred.
Your community supervision was revoked in September.
Yes. Now
Was it
that
brought forth in the case as to why?
Yes, because
What was that?
I asked my sister to bring my truck back to me because she was moving my grandfather's pool table, which she claimed to be hers after my grandfather was deceased in 2001 of June. And I told her.
This is Brad Bowman, General Counsel. I just want to make sure we're sticking to the facts in the
Was this
record.
presented in the case, Mr. Rennick?
I'm not sure those details were, but I can't say they weren't, but I don't remember the details that he's providing on the probation.
What were the violations of the terms?
He was revoked for violating the term of going within 100 yards of where children gathered, and for the term of making contact with a minor. He violated his conditions in those ways.
So at that point in time, you went to TDCJ for 14 years?
Yeah, they took the 8 years and threw me 14, so I did 12 years, 9 months. Trying to get out, paid thousands of dollars to my attorneys. which I vow to pay my family back, but I can't do it through part-time work, $35 for 4 days, or 38. This is, like I said, my career, it's oriented, my career, which I was considered it highly because it pays a whole lot more. Yeah, my niece had came to, I told my sister back to the case not to bring no children when she comes to deliver my truck, because I had her vehicle. We traded because she had you can't stick a pool table on top of a car. I mean, a heavy one at that. And so she ends up bringing her, but she didn't have no contact with me because we were barbecuing July the 4th, 2002. And it was the 4th of July, and I stated, and I even have on record.
Again, I'm sorry, are these details really in the, 'cause in looking at the PFD, there's really not much discussion about all this. I just want to make sure that we're sticking to
It's
those.
just limited to the fact that it was
those
revoked.
facts.
May I just say at the hearing, he just said that he was quickly revoked and he was railroaded.
Okay.
That's what I remember from the hearing.
He was what?
Railroaded by the judge.
A 12-minute session.
So is there anything else that you want to tell the commission?
Yeah, to my license, and well, the public will be real well protected by my president, and is today. 'Cause I've proved myself trustworthy, and when during my parole, I was clean free. I have it noted on file that I did no alcohol and drugs because they check me every month.
Did you present that in the hearing?
I'm presenting it verbally because
No,
I
did
don't
you
have the
present
paperwork.
Any documentation, anything to that?
No, because I hadn't got, I've been off parole since June 11th.
Okay, so there was no documentation about you being drug-free or clean-free or anything like that?
It's on file on the
No,
computer.
but there was no documentation
Oh, no,
presented at the
sir.
SOA hearing?
No, I don't have
Okay.
it on me right now.
Is there anything that you wanted to
Apologize.
say?
Yes, sir. I've been in the business for 27 years now. We have a business in Houston. It's my father's business. He's had it for over 50 years. Gregory and my other brother basically from high school started cutting hair.
Again,
I just want to make
sure
sure
we
that
confine it to the hearing. Was this
Okay.
presented in
she
the
was
hearing?
not present at the hearing. She did not testify.
Okay.
No, I
This
was
is
not.
outside.
No,
Okay,
I
then
was
I'm sorry,
trying.
we can't take anything from you. If you were not present at the hearing, we can't take anything from you. So, I'm sorry. All right?
Okay.
Anything else?
I'm just saying if she signed a
I'm
documentation.
sorry, it doesn't matter. She had to be present at the hearing in order to testify.
Oh, okay.
So,
Well, she wouldn't be my witness, but it was too late. I didn't know.
yeah, that's fine.
Oh, yes, I'd like to add that I've been to A&A 4 times, and I've stopped drinking. I was a depressed individual, and I've been through 25 years of violence. And of course, that don't stop when you go to prison, and just fights. And I don't like to fight people. I'm more not the aggressor, but I will have to back myself up because who wants to be a punching bag? And I'm sorry I have to mention that. I studied criminology.
Again, was this presented at the hearing? Confine your comments only to what was at the hearing, not what took place in prison.
Yes.
Anything like that. You had to have presented at the hearing, at the SOA
Ye-
hearing. in order
Yes,
to
I
bring
do
it before
recall
us.
what I presented at the hearing, which was this year, September 15th. And I'm presenting what I had mentioned there. It's on recording. I don't know about viewing monitor, but I know it was on recording.
He
as,
did
re-
testify that he
resident.
was drug-free and alcohol-free. He testified to that at the hearing.
But there was no documentation.
There's no
presented.
documentation.
I am a changed man, and I know the Holy Spirit indwelling, thanks to God Almighty. And He has helped me tremendously, and there is no lie to my facts or what I'm saying today, because I'm a minister of God also, but I don't have the documentation work for that as to, unless I go to school, but my Father in heaven told me that. So and I have struggled with part-time jobs, and I'm nearly homeless. I've been 5 months without a job, and I'm relying on my family to support me, and it hurts them, because anyway, so.
Are there any questions for Mr. Adiano?
It's a struggle, man. I don't want to be homeless. I slept on the bus stop the other night, slept 20 minutes thinking somebody's going to come approach me and stab me to death.
Okay,
Because
just a second.
it's a world
Hang
of
on a second.
violence out there in
Hold on.
Houston.
Are you a
Believe
registered
that.
sex offender, Mr. Ariano?
Yeah, I'm all for that. I've talked to numerous police officers, and they said they became my allies, and they agree, we talk about God and everything, and they vow to see me make it.
Mr. Adair, can you answer the question, please?
Are you a registered sex offender, sir?
At this time, yes, I don't have $3,000 to pay a lawyer to get me off, because he will.
You are a registered sex offender?
Yes.
Okay.
He said he's gonna get me off, my new lawyer, when I get $3,000. Pretty cheap right there.
Is
Of
that
course I don't
consonant to
have
what
it.
was presented,
That he has a lawyer who's going to get him off?
or registered sex offender?
He is a registered sex
Got it.
offender.
Yep.
Okay.
I
Chairman, if
did
could
say
ask
yes.
Yes. Mr. Shaw.
Maybe a little bit more control on the meeting. I mean, we need to stick to the facts and stick to the
I
facts
agree.
that have been presented. Maybe move from there.
I agree. Any further comments or questions to Mr. Ariano? Any questions for Mr. Rennick?
I just have a few corrections. He says he's almost on the street in the hearing. He said he lives with his mother. He's on
Yeah.
welfare, good pay compared to other minimum wage jobs. He works cleaning a shop.
Any further questions or comments? Thank you. Feel free to have a seat. Commissioners, motion will be in order or additional discussion?
I make a motion that we adopt the PFD as recommended.
I second that.
We have a motion and a second to adopt the PFD. Any further discussion? All in favor signify by saying aye.
Aye.
Those opposed? Motion carries. The staff will be with you and talk to you kind of what happened. Essentially, you're not giving your license back. Okay, so but the staff will discuss it with you. All right?
Oh,
Thank
can
you.
I say just one thing,
No,
please?
we're done. Thank you. Appreciate it. Okay, let's move on to our motions for rehearing. Let's go to G1. Again, we're trying to get everyone out so that that's here to testify. And we'll come back to the cases that we have left. Motion for rehearing, G1. We have General Counsel. Brad, are you gonna be doing this?
Charles is going to be, Charles and I are dividing those up, so he's coming up there.
Oh, Charles is coming up? Okay.
Which one are we starting with?
We're gonna be at G1, Commissioners.
When was this case heard? Was this August? Let me ask Kate.
Well, we can, no, here it is. July.
I was here.
For the record, Commissioners, Charles Johnson, Assistant General Counsel. Excuse the voice, it's been used a lot lately. You have in front of you a motion for rehearing in Atlas Towing. You may recall recently this case was before you. There was a motion for continuance filed, and you denied that motion for continuance and entered an order assessing penalties against Atlas Towing. They have filed a motion for rehearing alleging in the rehearing motion that your order denies them due process in the sense that they were denied counsel representation at that hearing. And so for purposes of this rehearing motion, we take no position on whether or not to grant or deny the motion, but we do acknowledge that it's within your discretion to determine whether or not you believe that there's basis for a rehearing in the sense that they allege that by not allowing them to have counsel at the hearing, the due process was prejudiced. That's a determination, I think, within your purview, and we take no position on how to dispose of this case other than to acknowledge that you have discretion in this area.
And let me, as a point of clarification, kind of expand a little bit. The motion was originally scheduled for the July 27th hearing, and there was a continuance filed.
Yes, sir.
The commission granted the motion
The
for
first
hearing.
one. Yes, sir.
And then at the August 24th hearing, we get another continuance request.
Correct.
And it was at that particular continuance request that we denied the continuance and ruled on the PFD that was before us.
Yes, sir.
Okay. If I'm not mistaken, there was a request to be able to have information or dates of the attorneys.
Yeah, there's an issue about his vacation schedule. and how to interpret what was submitted. I believe that there was some confusion around whether or not he said he was available for a set period of time, and it was not clear. And so that was the issue you were wrestling with at the last commission meeting, or the August commission meeting.
And then there was, okay, well, I'm sure you can probably speak to that. Any questions for Mr. Johnson?
Yeah, with the August 24th date was never mentioned anywhere, as if I remember correctly, as to not being available. Is that correct?
Yeah, that was a confusion, and
Okay.
I don't want to speak
Fair enough.
for him, but
We can
that was the
probably let him
confusion.
speak.
Fair
Yes,
enough.
ma'am.
David, is it Fritchie?
Fritchie.
Fritchie, that's right.
Yes.
I think I butchered it the last time.
Well, that's, everybody does. I had a judge in Bear County called me Mr. Frisky, and I never corrected her.
Mr.
Thank you.
Fritchie, again, on the motion for hearing, we can only take in consideration where the department erred in coming to our decision.
I would like
Which
to
I'm sure
address
you're
that.
probably going to point that out to us. If you don't
Well-
mind, state your name for the record, and you can proceed.
It is David Fritchie. I am a sole practitioner and have been practicing almost 30 years. In my practice doing litigation, I regularly prepare vacation letters, which local rules of Tarrant and Bear and Travis and other counties require be submitted so that they won't set a hearing on a date you are on vacation. And in this particular matter, the dates are somewhat correct. On July the 8th, the commission set the hearing before these commissioners for July 27. I had a conflict. I filed a motion for continuance. Commission staff did not object to that motion for continuance. That continuance was granted. Now, in my motion for continuance, I attached my vacation letter. That is all I attached, was my vacation letter, the one that I use regularly throughout the state in other jurisdictions. The commission, in granting my motion for continuance, reset it for August 24th. I filed a second motion for continuance because on August 24th and 25th, since January, I was scheduled to present to the San Antonio Housing Authority a fair housing seminar on the 24th and the 25th for 2 full days. There was nothing in my vacation letter about an August 24 and 25 seminar because it's not a vacation. Commission staff objected to my motion for continuance and advised my office that the motion for continuance would be taken up at the August 24th hearing, which I could not attend. So my client appeared pro se. The commission, to my understanding, at that point, rejected or denied my motion for continuance and proceeded with the hearing on the proposal for decision that was then before the commission. Obviously, I was not present for that hearing. But I want to point out that in the objection to the second motion, I don't think there was any confusion because this is what the prosecutor placed in the objection. Mr. Fritchie, Atlas Towing's attorney, represented to the commission in support of delay that he was not scheduled for any activity on August 24, amended vacation letter attached. Now that he wants another delay, the earlier representations are disregarded. I never represented I was available August 24th. I didn't attach my entire calendar for August or September. And so I think that there, and I'm not going to get into anything that's outside the record, but I was not afforded the opportunity to represent my client at that hearing. It proceeded, and my understanding is, and staff can correct me if I'm wrong, but there was beyond, I mean, the discussion on the record included a City of San Antonio policeman that appeared and then reiterated testimony, and he was allowed to appear, and the reason the commission granted or denied my motion for continuance was because there was a representation to the commission that there's all this taxpayer money that's going to be wasted because the policeman was here. Well, that could have been avoided if there had not been an objection to my motion for continuance.
Mr. Ritchie, when you first submitted your first continuance, you did that ahead of time, right?
I did.
And I remember discussing this with general counsel, and I think we went ahead and let you know that we would probably recommend to the commission to go ahead and provide you a continuance. Did they inform you of our next date?
At some point they did. I don't have no, they did. I didn't know what the next date was.
You weren't informed by our staff what the next date was?
Correct. And if I'd have known that, I would have
Does that seem to
immediately.
be correct? Do we know?
I cannot respond to that, Mr. Chairman.
Brad, do you remember? I know that we had provided this information, because we had discussed this, if I'm not mistaken.
I think at some point we provided a tentative date for the meeting, the August 24th meeting.
Well, the
I
August
can't-
24th meeting would have already been set, because that was our meeting after July, so that meeting was already set. It was not a question of whether we were going to meet or not. We were going to meet on that date. So are we confident that we relayed that information to Mr. Fritchie?
I would probably have to go back and look and see when it was relayed. I think it was relayed at some point, but I don't know.
Well, it was relayed at the time we got the notice of the setting.
It definitely at the time of the notice, but
And that's what I responded to.
Yeah, I think there might have been an email exchange prior to that, but I'd have to go back and confirm that.
I would like
can't-
to see that email exchange if there was, because I have no recollection, and the prosecutor on this case regularly copies my legal assistant, and she is the person who tells me where to be and when, and I would be very surprised if we had known at the time of the initial motion for continuance being granted or thereabouts that there was a specific date. Now, obviously, I could have checked probably the commission's calendar for the year and made an assumption that it would be in August. I didn't do that. I probably should have done that. I didn't realize that the next meeting would be the date when it would be heard. So that's my error. That's my error.
Mr. Chairman, if I may, council made representation to my comment about confusion. And just to clarify the record, I think I just want to say that in the letter that in his first motion for continuance, he indicated that during the remainder of the year, he gave dates he would be unavailable. The dates were August 17 through 19 were marked vacation. There was no entry indicating his unavailability for August 24th, which is the date of the commission's meeting. Although Respondents' Counsel never affirmatively stated he would be available for August 24th, the absence of the entry on the vacation letter implies his availability for the 24th. And that was the basis for my comment about confusion. It was the implication of this letter.
And that says that it is a vacation letter. I mean, that's the subject line on that.
I don't have the actual letter in front of me, but the memo specifically says he was marked vacation.
Yeah, that's right.
Yeah, it was marked vacation.
Right.
Yes, ma'am.
Fritchie, in knowing that we're trying to get these scheduled, why did you not reveal all the dates that you're unavailable? And not
Well-
just the vacation? Why
well-
did you not reveal all the dates?
I wouldn't have minded doing that, but you're asking, and basically what I would need to do is attach a PDF of my entire calendar
No,
for.
we just need to know what dates you're not available.
I would have been happy to do that.
Well,
I would have
obviously you
been,
didn't.
but I never represented affirmatively that I was available on August the 24th. What I represented was, these are the dates that I know I'm on vacation.
Those are the dates that you're unavailable.
For sure. That's correct. And it's a request not to please not set the hearing. The second
Which wasn't set then.
well, I didn't know about the August 24th setting until we got the notice. And then we filed a motion for continuance when it was set for the 24th.
Mr. Shaw, did you have a question?
Well, I have a comment more so than a question. We've already continued the case once, we deliberated it. if we afford this attorney the privilege of telling us when and how we should accommodate him, then I think we should do that with anybody that comes forward with us and have them provide us with their entire calendar as to when they're gonna be at a seminar, when they're gonna be at home, when they're gonna be everywhere else. I think we've already decided on what we need to do with this case. I don't see a need for a rehearing. I apologize that you are not available. There are people that make provisions to send somebody in their place, and that could have been made, so.
He's a
that would
solo
be-
practitioner, he's already said that.
I understand that, but there are a lot of solo practitioners, and we don't provide those accommodations to them either, so, anyway. that
I
was-
would just like to get on the record one more time. I remember when this incident happened, I disagreed with it. We have granted numerous attorneys the courtesy of continuing because it's a professional matter. It is not a negligent, random decision to just not be available at the last minute. We have always extended that courtesy on numerous occasions. And it's not like we don't have plenty of cases to be heard on our docket. So I'm gonna make a motion once again to grant the rehearing.
And I'm gonna second it once again.
We have a motion, a second, to grant the rehearing. All in favor signify by saying aye.
Aye.
Those opposed?
Aye.
No.
I-
Can you do a roll call, please, Ms. Mahon?
Tom Butler,
No.
Helen Collier,
No.
Rick Figueroa,
No.
Catherine Rosenwald,
Yes.
Robbie Shaw,
No.
Deborah Yurko,
Yes.
Marjorie Hernandez.
No. Motion fails 2-5, which leads us to believe that no motion for rehearing will be granted. So, thank you for your time.
Mr. Chairman, I would like to put on the record, I was not afforded the opportunity to finish my comments.
So noted.
Thank you.
Thank you.
The second aspect of this that I believe is a due process violation is the fact that there was a witness that appeared at the original SOA, State Office of Administrative Hearing, that apparently appeared before this commission on August the 24th. And if that person did appear and I did not have an opportunity to further cross-examine or to challenge whatever testimony was elicited by the prosecutor at that time, I think that is even more of a due process violation because this is a quasi-judicial body. Now, I realize you've already acted on the, to deny the commissioner's motion to grant, but I just want on the record that if there had not been another witness or a witness appear before this commission, I wouldn't have a second ground that would be a due process violation because I don't know, my client, pro se, was not able to cross-examine or to challenge anything that Officer McCulloch may have said.
It's duly noted.
If I may, Mr. Chairman, also to come to the record. The representations that council just made, I do not believe are due process violations. The process he was due was notice of the hearing. He was given that notice. He failed to attend. So the due process that is required by APA and any law in the state of Texas has been fully fulfilled and met. There's no right to continuance, and he was notified of the hearing and failed to attend.
Thank you. Let's move on to item G3, which is Emilio Gutierrez. I believe that you are present. Let's see. Brian Walter, are you present? Yes. That's you. Okay. Thank you, Mr. Fritz. You appreciate your time.
Thank you.
Commissioners, we are in G3. Go ahead, Charles.
For the record, Commissioners, Charles Johnson, Assistant General Counsel. This is a motion for rehearing in a case, it's a default from the decision of the Executive Director wherein a penalty of $5,000 was assessed for the respondent's failure to ensure employees were drug tested and for operating a tow truck without a license. In this motion for rehearing, he alleges essentially that the business is now closed and he never received notices of the hearing. The record shows that notice was sent to the proper address that's in the Commission's records, and even after the notice was sent, someone from the company contacted the agency to try to settle the case. Reasons unknown to me, the settlement did not occur, and so we find no error in providing notice of the hearing. I recommend that the motion for hearing be denied.
Any questions for Mr. Johnson? Mr. Walters or Walter?
Walters. Plural,
Walters.
but it's just me.
Okay. Mr. Walter, you probably heard what I said before. You can only bring forth where the commission erred in coming to the decision of the PFD. Okay? So if you don't mind, state your name for the record.
Brian Walters, representing Evidel Gutierrez.
Please proceed.
Thank you, Commissioners. This case is quite clear from the department's standpoint. They're correct. They did send out notices. They have evidence of that in the form of the certified mail return receipts. They've got those numbers. I checked them myself and went through the confirmation of delivery except for the first one. The reason that we're requesting a rehearing in this matter is because of the fact that this is simply a case of a default going to a default because of procedural missed deadline. The courts are very clear on the fact that these sorts of procedural misses, especially in the case of a pro se litigant, in this case a pro se respondent, should not be favored by any judicial body. The courts favor an adjudication of the dispute. They favor adverse parties' chances to go back and forth and present evidence. That's actually spelled out in Section 2001 of the Texas Government Code, which deals with the procedures in these sorts of hearings. All that we are asking in this matter is that the court, I'm sorry, old habits die hard, the commission grant this motion for rehearing so that we may go back and present the defenses that we believe we can prove should this matter go to a full hearing. The alternative in this case would be to deny the motion for rehearing. Unfortunately, that doesn't end the situation for anyone. My client will have to pursue an appeal. It will still be drawn out. It will be in a more formal body in the form of a court upstairs. So we'll be having more expensive filing fees. We won't have the ability to work with the department directly and the prosecutors who we've worked with so many times. I believe that equity and public policy favors sending this back down, vacating this order, and allowing my client to present the evidence in his defense. He's elderly. He's slowly becoming more and more disabled. To impose a $5,000 fine on this person will not net this commission or the department any fines. He's much too concerned with his health right now, and I've seen this many, many times. So, did they miss the procedural deadlines? Yes, they did. Just like a defendant or in a case in the Justice Court, County Court of Law, District Court, might miss their answer deadline. But how many times have I been in a courtroom where we've seen a judge say, yeah, you missed it. We're not going to give you a default if we're here, if they're prepared. That's not what the courts are for. And we don't believe that's what this commission is for either. So again, we would urge that the commission vacate the order, allow us to go back and deal with the prosecutors directly on this matter. Thank you, Commissioners.
Any questions for Mr. Walter? Mr. Walter, you're stating that there was no way that the commission erred in coming to their decision.
I'm saying that from a procedural standpoint, the deadlines were missed except for this motion for rehearing.
Mrs. Gutierrez states that she's not going to pay the amount. I'm not agreeing to pay amount. I did not operate everything about that.
I'm sorry, who was it who stated that?
Evidel Gutierrez.
It was Mr. Gutierrez?
Is it Mr.?
Mr.
Okay.
Gutierrez. Leslie Gutierrez is his daughter.
Okay.
And she's
Well,
not a licensee.
Yeah, he stated that he's not going to pay the fine.
Did he state it in English? Because he doesn't speak it.
That's what I have here. It's comes from Leslie, and it's signed in his name.
Well,
I guess
all
you
I
don't
can
have
say,
his email?
all I can say in response to that is no, I do not have that email. And
You
I've
need to
had,
get with your clients to make sure they get the email to you.
I've had stubborn clients before, and I've worked through much tougher situations than this. One way or another, this case will either continue upstairs or it will continue here. I think that the fastest and most efficient use of the state's money favors a resolution down here.
Any questions for Mr. Johnson or Mr. Walter? Commissioners, a motion to be in order at this time? Thank you, sir. Appreciate it.
Thank you.
Any,
Motion, we deny the motion for rehearing.
we have a motion to deny. Motion on the floor. Motion dies for lack of a second. Somebody make a motion to grant, because that's the only option we have left.
I'll move that we grant the motion for rehearing.
Second that.
We have a motion and second. All in favor signify by saying aye.
Aye.
Those opposed?
Right.
No.
No.
Ms. Fletcher, I'm sorry. I was about to say Ms. Mahon. Ms. Fletcher, if you don't mind, doing roll call.
Chairman Harris Mendez,
No.
Mr. Butler,
No.
Collier,
Yes.
Figueroa,
Yes.
Rodwall,
Yes.
Shaw,
No.
Yurko.
Yes.
Motion is granted, so you'll get your motion for hearing. Staff will be with you and tell you what you need to do.
Thank you very much, Commissioners.
Thank you. All right, item G4, Edward Arredondo A&R Towing. I think we have Vanessa Arredondo. Let's see her. Yeah, that'd be nice. Trust me. No one wants to go to lunch more than we do.
That'd be me, Mr. Chairman. I want to go,
Okay.
I want to go worse than you.
I'm sorry.
Are you afraid we'll be grumpy if we don't? Is that it?
I was thinking maybe you'd be in a better mood. No.
Mr. Johnson, proceed.
For the record,
Which one is this?
Charles Johnson, Assistant General
G6.
Counsel.
Commissioners, we're on G6.
Jeez.
This is a default from the Executive Director assessing a penalty of $4,100 for the respondent's failure to comply with the drug testing policy, for having information missing on these required signage, and for failing to provide documents to the department for inspection and copying. The respondent alleges in the motion for hearing that there was some factual findings, I'm sorry, challenges some of the factual findings, but does not allege there was a error in sending the notice of hearing to the address on file with the department. And so since notices were sent to the correct address, we recommend, and we find no error, and recommend that the rehearing motion be denied.
Any questions for Mr. Johnson? Ms. Arredondo, if you don't mind, you've heard what I stated before. We can only take into consideration where the commission erred in coming to the decision. So nothing else. We can't retry the case. That's what I'm trying to tell you. So if you mind, state your name for the record.
Vanessa Arredondo.
Go right ahead.
Okay. Basically, from the paperwork that was given to us, and then as it was explained to me about what I could or couldn't file that I did, the motion for, I'm trying to understand, hoping that I'm understanding it right, that what I entered in number 6 is the only thing that I can talk about today. Is that correct?
Basically, a decision was made, and so now the only thing you can talk to us is about where we made a mistake in coming to our decision.
Right. Well, the 3 things that he mentioned were the ones that I didn't follow on, and the one that I did is not what he mentioned. So I'm just making sure that this is the first one on me. So the 3 things that he stated that it was about was not actually what I was in concern for today. It was another violation. That,
So it's not concerning tow 8044, Indian 8044, or
no.
VSF 21963?
1693. It's number 6.
Oh, I'm sorry, I'm on the wrong one.
And
We're not on 6?
No, that is, that,
You just had the numbers.
Oh, I'm for 4.
Transfers.
I'm sorry. Commissioners, we're on 4. I think I said 6.
so anything that was,
So in
What did,
G4,
hang on just a second. Did you do 4, Charles?
Yes, so we're on.
Okay, we are on 4. Okay, good.
Yes, sir.
I'm off. My apologies.
But if I may, I think which is referring to are the allegations in the notice of hearing.
right.
And I think she's trying to speak to the merits of the
case.
case as opposed to the notice issue.
Yeah. And again, if you want to discuss if you want to retry the case, you can't do it here. You can only tell us because this case has already been decided. What this procedure allows you to do is to tell us how we made a wrong decision, if there were facts that we didn't take into consideration that were actually on record, or if we did something wrong or sent something to you that
Right.
was a totally wrong address and all
The
that type of
process and the notification was
So we're
fine.
okay there.
But the documents which I received from y'all, the open records, is what shows that the way number 6 is cited is actually opposite, and it's not correct. So, you know, when I approached and called about what it says we didn't have here is in fact exactly what is pictured here. So it's not correct.
So
So
there was
whether or not I'm allowed to
So
speak
there
on
was
that
a-
at this point?
There was an error in
Yes.
the
It
fact.
contradicts what the inspector wrote on 2 different sign violations is not what was actually entered into this.
Into the PFD?
It's a default order, I thought.
Is it a default?
Yes, sir.
Okay, so
Yes, ma'am.
we have the information that was a default that came before us. Did you ever present this information prior to? when you
I
received
did not
notification?
respond to the first notification that was given to us in time, if that answers your question. So this is the first time I've done anything with it.
So there wasn't, so there was no response back from you?
Not in time. So, when we got the second notification, it was noted there that I could file a motion for a rehearing. And when I called and said, how do I do this? Do I need to have a lawyer, like, actually file it, e-file it? You know, they said basically just, even if you just send us an email saying specifically, the most important part is only the things that you mentioned in your motion are the ones that we can discuss. We can't go back and revisit things that you don't include now, but you don't have to provide any evidence or proof of the details right now. Just let us know what you want to come back and address. So it's really not something that I'm trying to present now, but it is something that is in error that we will end up being filed for. And it is, my concern is it's being noted as a second violation, which hopefully we won't have this problem again, but if it's not corrected now, it would be listed as a third. So if nothing else, if it could be maybe better defined for me, because
So you wanted, you want to go back, do you want to talk to the staff about it? Is that what you're trying to do, to try to rectify the issue? Or do you actually want to take it to a SOA hearing? Or do
I-
you actually know what we're trying to do here?
I just
And
know
and it
that
can
the
be
way, you know,
confusing.
I requested all the documents, and the way the guy wrote it up, he wrote up, you know, it was an email address, and then it was this other separate issue, but what was actually in this finding order, whatever you call it, is not correct. It's flipped on what items were not there and which were. And, you know, the motion that I filed was that he didn't photograph all of the signs, but actually in what he presented, it's there, but it says it's not here. So it's just flipped by accident, I think. So, you tell me.
Back to the staff.
Go back to staff.
That's what I'm wondering, if we
Yeah.
just need to remand
Yeah.
it back to the staff and let them work on it.
You live, where do you live? Or what's your-
Beaumont.
Beaumont.
So I guess, basically what we probably need to do, if that's the, kind of the will of the commission, is go ahead and grant the motion for hearing and remand it back and let staff take care of it. Is that correct, Brad?
If that's the desire of the commission to have it addressed at the
So
staff
why don't
level,
we go
then
ahead
that
and,
would have, that would be
if
the.
someone would make a motion to go ahead and grant the motion for hearing, let them kind of hash it out.
So moved.
A motion second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Someone from staff will get with you and y'all can work this out and try to figure out what the deal is. All right?
Alrighty.
Thank you.
Mr. Chairman, who was the second on that last one?
That's what happens when you go
Second by
last before
Commissioner
lunch.
Butler.
Okay, thank you very much.
Okay, let's go on to item G6, which is the RAL Group. And I have Roderick Lewis. Have a seat. Who's going to be presenting this?
Which number are we just now, for sure?
We are now on number 6.
Okay.
Now I'm on board.
Mr. Chairman.
Bowman, go right ahead.
Commissioners, Brad Bowman, General Counsel. This was a default order that was entered by the Executive Director. It assessed a total of $2,200 in administrative penalties for 2 separate violations of the TOW and VSF statutes. The motion for rehearing doesn't allege any, in our view, any error or any lack of notice. Again, this is a default case, so the issue is whether the respondent was given proper notice. In our review of the file. It appeared that all the notices were sent to proper address. I believe the notice of alleged violation was unclaimed, but there did not appear to be any error on the department's part in notifying the respondent. So we would recommend denying the motion for a hearing on that basis.
So notifications were sent properly, but never claimed?
Unclaimed, and under the commission's rules in Chapter 60, there is a specific reference to failure to claim certified mail does not negate notice. So the commission's rules specifically address that.
Okay. Any questions for Mr. Bowman before we move on? Mr. Lewis, I'm sure you probably heard my statement that you can only confine statements as to where we erred or there was a default order that erred coming to the decision that was rendered. So,
yes, sir.
Mind state your name for the record?
Roderick Lewis.
Proceed.
I am vehemently denying the fact that I did not accept notice because I received notice, and upon doing so, I had several email correspondence back and forth with Grace Hernandez. Also, starting out as early as June 20th of 2015, which is almost a year before the notice that it said I did not receive on February 22nd, 2016. So I spoke to, and then I had several emails, as I can gladly show you here because I brought this packet for you all the way through July 21st, all the way through October, on every request that she ever asked for anything pertaining to this case, whether it being the tow tickets, the payout forms, the credit card bills. She even made corrections or made notice of corrections that we needed to make to our tow tickets to further describe some things that she pointed out were small errors. So in addition to the case, we had several correspondence back and forth regarding this case within this same email thread. So we did acknowledge that there was a case out there and provided every documentation that she asked for.
Any questions for Mr. Lewis? Brad, do we show any of that information?
Yes, there was email correspondence in the summer of 2015 with the investigator in the case, as the respondent is saying. This was, as best we can tell, this was during the investigation stage of the case. So this was prior to the NOAV, the notices being sent out. So at that point, yes, he was being responsive and providing information to the investigator. It was those later notices, the NOAV, the notice of default, that were not responded to.
Did you receive the NOAVs?
Every response we get, and we respond promptly, and that can be documented by past, people when people complain and everything. But as far as this concern is notices, I haven't. If there was another one pertaining to the same case, I have not gotten anything.
A certified letter sent to you.
Yes, and I would not have gotten this because
is your address P.O. Box 1401, DeSoto, Texas?
Check it daily. That's a part of my daily routine.
Rural Route Box 320, Oakwood, Texas?
Yes, sir. That is
also a date?
That's a farm property that we use, but we don't frequent.
That's a correct address also.
It's there's no house there, sir. No,
right,
no,
but that's
anymore.
a correct address.
It is, yes, sir.
Is that where we sent the NOAVs?
That is the notice of default was sent to both of those addresses. Let me see if I have a copy of the NOAV
you check it daily,
here.
but you didn't get this.
No, I checked my P.O. box daily,
Right,
but I did not
you
get
didn't
this.
get this NOAV.
And like I said, any time she's ever contacted me by email, phone, whatever, I promptly respond and give her.
I'm asking about the letter. Did you
Yes, sir.
receive a certified letter?
Not pertaining, not the one that's in 2016. No, sir. We received the one that we got something in 2015, and we promptly gave every request she ever had.
And where was the one mail that you received in 2015? Was that the P.O. Box? Or
Yes,
the
ma'am.
farm?
Yes, ma'am. I've had that P.O. box for almost 15 years now.
And I don't have a copy of the NOAV in front of me, but we can get that and
But you're saying, Brad, it was sent
confirm
to both
the
addresses, or?
The notice of default, which is the last notice that's sent before the default order is entered, that was sent to both addresses, and we're double checking the NOAV.
With all due respect, I'm still not understanding how I defaulted when I've been corresponding with regarding this case from the beginning, because again,
Well, the default took place whenever there was a notice of alleged violation sent to you and there was no response back. That's what we're asking, if you received a certified letter. That's the reason we're focusing on that letter.
with the alleged violation, I found that out back in 2015. That's
So-
when she started telling me, she said, well, you did these things. So I said, well, no, here are the, what documents do you need to show differently? And I gave her those documents. She further asked for pictures, and then on into the deal, she went on, and she even asked why I'm not trying to get into the facts of the case, but she asked for, well, where the authorization to tow came from. I even provided the officer who called us out at a particular time. I presented their telephone number. I found out later that she had spoken with that person, so there has been several back and forth where I gave them everything that they asked for.
Okay.
So I don't want to put words in your mouth, but you're saying that if you would have given, you thought that if there would have been a hearing, they would have contacted you by email, and you would have shown up? Is that what you're saying?
Oh, no, that's not what I'm saying, sir. What I'm saying is every request that's been given that I saw, that I received, and I try to answer very promptly, I respond to them, and it just, with any, and not only respond to them, but promptly, with any and everything that they may ask for.
Okay.
So what are we being asked for a rehearing? What are we being asked?
Yeah, I think that the request is for a motion for rehearing to go back. I think Mr. Lewis has stated that he was communicating with Peter Law the whole time. We're saying that there was an NOAV sent to Mr. Lewis saying that there was a notice of violation that he never responded to. Our documentation shows that the letter was never picked up by Mr. Lewis. So there was obviously another letter sent out sometime or another that we say we sent. Mr. Lewis says he never found, but we never had it returned back to us.
Well, Mr. Chairman, we pulled up the NOAV. It was dated June 3rd, and it was returned unclaimed to the department. So that means it wasn't signed for or picked up.
What's the address on it?
They're both addresses that you mentioned earlier, the Oakwood, Texas address and a DeSoto, Texas address. And
May I? I'm scared. I didn't mean to interrupt you, sir.
let me just, in terms of the legal standard here, it looks like we sent good legal notice. That creates a presumption that the respondent was notified of the proceedings. The respondent can rebut that presumption by presenting credible evidence of not receiving notice. So I guess the question is are is the commission convinced that that standard has been met?
Commission, what's your will or wish on this item?
May I make one other statement before we move? In addition to the emails correspondence back and forth, we've had several telephone conversations where she may have said, well, I need this specifically in addition to this, that would have preceded any letter, and all of those have been followed. So in other words, the communication.
You're stating that you communicated with TDO Laura constantly.
Okay.
And whatever they ask, yes.
I make a motion that we grant his motion for rehearing.
Right, and I'll second that.
We have a motion and a second to grant the motion for hearing. All in favor signify by saying aye.
Aye.
Those opposed? No. Motion passes 6-1. So you got your motion for hearing, okay?
Thank you.
Staff will be in touch with you, and we'll kind of tell you what our next step is.
Thank you.
Okay? All right, let's go on to item G7, which is the last one. Peter Clark? Yes, sir. Come forward, I'm sorry. Brad, proceed.
Mr. Chairman, Commissioners, again, Brad Bowman, General Counsel. This was a case that was heard by the Commission. This was a PFD that came before the Commission. It was a result of a hearing before an administrative law judge at SOA. The Commission heard the case at your October 5th meeting and adopted the PFD without modification. And the Commission's order in adopting the PFD was to assess a $3,000 administrative penalty against the respondent for acting as an air conditioning and refrigeration contractor without holding a license. And this case basically revolves around whether the respondent the advertisement that was placed by the respondent amounted to offering to perform air conditioning and refrigeration contracting. The ALJ concluded that it was. The Commission, in adopting the PFD, agreed with that, concluded that this was a violation, and the advertisement, it was an advertisement for professional AC and heating repair and installation. The word installation was later changed to service in response to contact from the department. The definition in the statute also includes the term service, so I don't know that really changes anything in terms of the legal conclusion here. We've evaluated the motion for rehearing. It doesn't look, to me, it looks like this is essentially the same argument that has been before the ALJ and before the commission, and that it's already been addressed, and so we see no error and recommend denying the motion for rehearing. And I'll take any questions.
Any questions for Mr. Bowen? Mr. Clark, I can repeat everything I've just said, but again, only where we erred and come into the decision is what we can take into consideration. If you don't mind, state your name for the record.
Yes, Peter J. Clark.
Please proceed.
Commissioner, the two errors that I pointed out in my motion for rehearing were the findings of fact number 2 and conclusions of law number 5. Your findings of facts as adopted by the commission stated on March 27th, respondent posted or approved the posting of the following advertisement on the About Us page of his website. Barnett AC Home Repair and Commercial Services, LLC. Give us a call today, 281-647-0083. Services provided to residential and commercial clients, professional AC and heating, repair, and installation. That was an inaccurate depiction of the actual advertisement, and that's why we believe the commission erred in adopting that finding of fact from ALJ Arnold. In particular, the advertisement, which was State's Exhibit number 25 and admitted into evidence, lists 17 services, of which one is professional AC and heating repair and service. Also, Mr. Barnett included the words general contractor in addition to some other words, which clearly reflected his title as a general contractor. And I want to point out to the commission, Mr. Barnett has been licensed as an AC technician for approximately 10 years. However, he's been a general contractor for over 20 years. He's always held himself out as a general contractor. He's never tried to hold himself out as anything but a general contractor. And his website, in fact, explains and shows all the various services. He never highlighted anything regarding AC. He never had anything that would indicate that that's solely what he did. He never even put anything that made it appear that he was anything but a general contractor. That's first. Now, the conclusions of law, and I'll get into the law as far as what we feel was applicable here, which is defined as a fact, conclusions of law number 5, which said basically Mr. Barnett violated Texas Occupational Code 13.02.251A, which states, and the commission is aware, a person may not engage in air conditioning and refrigeration contract unless the person holds an AC air conditioning and refrigeration contract is licensed under the subchapter or subchapter G. Now, in the hearing that was held by ALJ Arnold, which his analysis was adopted in his findings of conclusions of law by this commission, he noted that Mr. Barnett relied upon the administrative code 75.30B. And the important thing about 75.30B is that under the Act, which is 13.02, they list under subchapter B of the Act various exemptions. They're listed from 13.02.052 to 13.02.064. Various exemptions of that code. Well, 75.30 of the administrative code refers back to that, which clearly shows its intent and says, and I quote, the Act, which is 13.02, and this chapter, which is referring to Chapter 75 of the Administrative Code, do not apply to those persons exempt under Occupations Code, Chapter 13.02, with the following clarifications. So they're acknowledging 13.02, meaning they're aware of 13.02's application. Now, under 1 through 4, it lists various persons who would be exempt in addition to what already listed under subchapter B. In particular, though, under 75.30B, it says, and I quote, unlicensed general contractors may bid or contract for a job that includes air conditioning or refrigeration if the job does not consist solely of work requiring a license under the Act.
But
Now-
you're not trying to retry this case, are you?
No, I'm merely pointing out,
Okay.
the conclusions of the law simply says he violated it. I must be allowed to elaborate how the commission erred in adopting the ALJ's proposed decision, and I'm basically fleshing it out. It's a one-liner, and we believe it's erroneous.
It's been more than one line that you've given us, though.
Oh, I'm a lawyer, so that's what we do. Unfortunately, brevity is not something that we're good at.
You getting paid by the word today?
Well, I'm very passionate about this because I think that at the end of the day, Commission, my client relied to his detriment on a provision which he believed governed him as a general contractor, not as an AC technician, because he doesn't hold himself out as simply as an A. That's almost like saying, as a lawyer, you have to be this or that. He's a general contractor. A lot of people like to say, what do you specialize in? He doesn't specialize in anything. He's a general practitioner, much like a general practitioner would be as a lawyer. And therefore, his reliance on that was in good faith. Now, whether you believe he violated or not, he never had the requisite intent to violate it, and it was unrebutted that he was not a general contractor. He stated it. No one did, there's no cross-examination that indicated he wasn't. In fact, there was no testimony whatsoever that concluded he wasn't a general contractor. This is merely about whether this advertising violated 13.02.251A. We hold that it does not by its very language, but more importantly, 13.02 does not prohibit an AC technician. If we just say, okay, he's an AC technician, it doesn't prevent you from advertising. It's silent on that. So we have 75.30B, which says a general contractor may contract or bid, which we believe this advertising is that. And then we have, there's no prohibition, it doesn't prevent. 13.02 does not prevent an AC technician from advertising in the first place. Now, if the commission so finds that he did a technical violation, because again, we don't feel he had the requisite intent, well, clearly, if he relied on the provision of 75.30B, whether he was correct or not, it is as it states. If he incorrectly relied on that, it was not done so with the intent to violate the act. And therefore, he shouldn't be assessed no penalty under this because it was stated, it's unrebutted, it says what it says, it means what it means. And therefore, as if the commission so finds that he did violate it, we believe that there should be no penalty assessed. And my brief says everything else, but for the most part, we don't believe that his advertising met the definition of offering to perform, and we also believe that he relied on 75.30B to be able to, as a general contractor, bid or contract. Now, I do want to point this out because I think that's something that needs to be said. There is no definition for bid, and there is no definition for contract under the Act. So, when you have no definition, you can go to what they do have. And what they do have, and I want to point this out, is that under 75.1019 defines offering to perform. And it says making a written or oral proposal, that's a bid. Contracting in writing, well, that's contracting, or orally, in writing or orally to perform air conditioning and AC and refrigeration work. Webster's Dictionary says a bid is offered to do work at a particular price. Webster's Dictionary says the contractor, and I'm not getting into the legal aspect, I would have cited to Black's Law Dictionary, we're talking about basic everyday terms because my client is not a lawyer. A business arranged for the supply of services at a fixed price. So when we factor that in, because there's no definition of bid or contract, we go to 75.1019 of the Administrative Code to look to see what definition would best fit, and that's the definition that best fits here. So I believe ALJ Arnold was incorrect, and I believe the commission was incorrect in adopting his finding when he acknowledged that that was, in fact, what 75.30B says, but he still said what they could not do is advertise that he performs. I don't know, that to me it's incongruent. If you're acknowledging that 75.30B says what it says, then how could you say that a person cannot advertise if they're a general contractor? How else is anybody supposed to know he exists? And with that, we ask that the commission rescind the penalty and find that Mr. Barnett is owed nothing to the state.
You are passionate, that's for sure.
Well, this is the first time it's come up, the GC and AC, so what's the legal on that?
Well, and I just want to say that we are really, relitigating the same issues that have already been determined by the ALJ and by the commission. But very quickly, and also I wanted to point out the prosecutor is available. Mr. Thielen is here, and he's very familiar with the case if the commission has any specific questions for him. The definition of offering to perform in the air conditioning refrigeration statute includes advertising in any form through any medium that a person or business entity is an air conditioning refrigeration contractor, or that implies in any way that a person or business entity is available to contract for or perform air conditioning and refrigeration work. That is what the respondent did by placing this advertisement. The exemption in Chapter 75 that council has mentioned is for it allows an unlicensed general contractor to bid or contract for work that includes air conditioning services as a part of that if there are other services included. Does not mention advertising. The difference here is that the respondent was holding himself out as available to perform these specific air conditioning services, and that's what violates the statute.
I think that was a discussion that we had during the case.
Yes, and the ALJ went through that analysis, also addressed the same argument in doing that. It's the plain language of the statute and the rule, I think, control here. So.
If I may, the problem here we have, Commission, is there's no direction on what a person should do to advertise where it doesn't violate that. And so what happened originally when Mr. Barnett was contacted, he changed it to what he thought would satisfy. But since then, there's been no instruction, and we've inquired what wouldn't violate it if that's the case. We talked about with an asterisk, and then you put the definition of the asterisk, but only by a licensed AC. There's been no direction. So if you penalize a person, but without instruction, all you're doing is kicking the can down the road, and we'll be back here again. Maybe not with my client, but with somebody else. Because there has to be some direction as to how you can advertise, which is the fabric of a capitalistic society, to be able to contract and offer your services or goods for persons to purchase, to how you can adequately do so and not violate the law. So if you merely say, okay, yeah, he violated, and slap him on the wrist and you charge him without instruction, well then how is he supposed, we still have no direction about how he will not violate it. Because if you say, well, take it out, well then that means somebody may think that if he's doing an addition to a home, which is the example ALJ Arnold gave, that, well, what could he not do AC? And ALJ Arnold even said, well, it necessarily would require AC work. So he has a right to advertise all the things that he can do, especially when he testified, unrebutted, that he always uses a licensed AC person to do any AC work. He never, and there's no evidence to the contrary. So how is he supposed to be able to have a livelihood and advertise without any instruction?
And while I understand your argument, that's not a decision for this commission to make at this point in time. So while again, sympathetic to what you're saying, but the direction of the commission is not going to be telling you how to do it. We can only base it on what was presented to us from the ALJ, what the law states, and kind of go from there. So any questions for Mr. Clark? Anything else that we haven't considered?
Well, I wasn't trying to suggest that the commission, I was merely making a point that there is no direction, and to take that into consideration from a mitigation standpoint, because 75.30B says what it says, and if you reasonably rely on it, which is what he did, then he shouldn't be penalized for a technical violation. And as this commission has shown itself earlier, common sense should dictate that if a person has a rule that is stated, this is not him conjuring up something. He's stated in the regs, and he relies on it. He shouldn't be penalized for that. And I believe common sense should dictate that in this instance, an admonishment would be sufficient, but not a penalty.
Thank
And
you.
I ask that the commission rescind its
Well, the only consideration we have right now is whether we want to remand it
Well,
back in for consideration.
yes,
of the commission's
I
PFD,
apologize,
so.
yes.
And what was the penalty amount? I can't recall.
It was $3,000. That's, and the range, I believe, is $1,000 to $5,000 for, for this class of violation. Unlicensed activity is considered one of the more serious violations, and so that's that's in the middle of the penalty range.
Commissioners, motion to be in order? Or unless you have a statement.
Well, I concur. I think that it's something we probably need to look at. I mean, I'd like to hear, not maybe not now, but something to consider. The ambiguity of it, I think, is poignant, that we want to make sure that in the future that GCs understand what we need to do, and making sure that that's stated. There may be some ambiguity we need to address as a commission just down the road. So
I mean, that would pose, how much of an issue are we seeing in this scenario?
Right. I would like to do some more investigation, not today, but I think that's something to consider, because if it is a convoluted issue, which I don't think it's like I said, maybe there may be more evidence that this is a bigger issue than just this one case.
It actually is a bigger issue.
Okay.
This is a repeated issue for years.
Well, then I think
That would be a
we'll-
statutory change.
Yeah, and I'm not sure where we sit on whether, I know the commission has repeatedly raised that concern and issue, because it's kind of vague to us. I mean, it's confusing.
In an effort to try to speed this along, this may be a discussion we can have during the executive director's report if we need to, so you may make note of that, of what you're doing, so. Commissioners, a motion to be in order at this time?
And forgive me, what was being requested again?
It's to grant or deny
To
the
grant
motion
or
for rehearing.
deny the motion for rehearing.
I move to allow the motion for rehearing.
And I'll second that.
We have a motion to grant the motion for rehearing, and a second. All in favor signify by saying aye.
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 Those opposed? No.
I mean,
Ivy
I was
Grant.
I was with them.
Can you do a real quick roll call, please?
Tom Butler,
No.
Helen Hellier,
Aye.
Rick Figueroa,
Yes.
Deborah Yurko,
Yes.
Mike Hernandez.
No. Motion is granted. You'll get a motion for rehearing. I'm sorry, your motion for rehearing was granted, which means it will go back down to the PFD. We'll hear this case again. And it's been done. Commissioners understand that there's still a law that we have to follow. So whether we agree with it or not, there's still a statute in place that we have to follow, so. But the motion for rehearing has been granted to you, so. It is now 2:20. I think we've gotten all the cases out of the way of people that want to be heard. There's nobody out there that want to be heard that we haven't talked to yet, have we? Okay, I want to make sure we got those out of the way. Let's go ahead and go back into executive session pursuant to 5510711 of the Government Code to receive a briefing from legal counsel concerning pending contemplated litigation and/or settlement offers. So, we'll go into executive session now.
hardware. When the hardware was discovered by the police, it was already installed on the respondent's kitchen cabinets. This case is about Chapter 53, Commissioners. It's about dishonesty, it's about untrustworthiness, and it is about the importance of a sanction that fits the crime. A probated suspension will not protect the public. The department strongly urges the commission to revoke the license.
Any questions for Mr. Renner?
No questions. I'm sorry, was it iguana, did you say?
He said there was an iguana that was being kept by county personnel that needed specialty lighting, and that was part of what he used the proceeds of the scrap metal sale on.
Entertain a motion?
I move to go with the suspension, or suspension, but the,
PFD?
yes.
Okay. Do I have a second?
Well, your PFD is.
The PFD calls for a suspension with a probated.
Okay, then I don't want,
Yeah,
your
you wanna-
recommendation.
We're recommending
Revocation.
that you reject the
Revocation.
PFD.
Right.
and-
No,
I
I
recommend
sec-
we reject PFD and go with revocation.
Okay, so the motion is that we reject the PFD
I second
and, and revoke the license of Mr. Dillingham, correct?
And Mr. Chairman, it's Brad Bowman. I would recommend, based on that, amending conclusion of law number 13.
And findings of fact 16 and 19.
Like to amend your motion?
To include, yes.
reflect that, okay. So moved, and we have a second. All those in favor, please signify by saying aye.
Aye.
Those no, the ayes have it. Continuing on, Mr. Rennick, item 10, Benito Hernandez.
All right, Commissioners, this applicant seeks an apprentice electrician license. In 2005, he pled guilty to and was convicted of the felony offenses of indecency with a child and aggravated sexual assault of a child, and sentenced to 9 years in prison in each. The applicant's daughter was the victim of both crimes. I was going to go into some of the detail on this, but I don't think it's necessary, and the detail is a little bit of, it's quite offensive. The victim was the respondent's daughter. He assaulted her twice, once for indecency with a child and the other one for aggravated sexual assault of a child. Applicant was approximately 37 years old when he committed the first crime and approximately 39 when he committed the second. He was released from prison in July of 2013. The ALJ recommends that the commission deny the application because of the seriousness of these crimes and insufficient evidence of rehabilitation. The department recommends that the commission adopt the PFD.
Any questions for Mr. Rennick? Entertain a motion?
I move that we adopt the PFD.
Second.
So moved, all those in favor signify by saying aye.
Aye.
The ayes have it. Continuing on, Mr. Rennick, item 11, Mr. Andrew Espinoza.
Commissioner, this applicant also seeks he seeks an apprentice electrician license. In 1999, he was placed on deferred adjudication for misdemeanor assault after he headbutted a woman. In 2005, he was placed on deferred for possession of a controlled substance, a felony, which he committed in 2004. In 2007, that community supervision was revoked, and he was sentenced to 6 months in prison. His probation was revoked because in April of 2006, he committed another felony offense, the offense of unauthorized absence from a community corrections facility. And in October of 2006, he committed the felony offense of indecency with a child. He was convicted of both crimes in 2007. He was convicted of the indecency of with a child in March of 2007, and he was sentenced to 8 years in prison in the indecency case and 1 year in the unauthorized absence case. The victim was the 14-year-old daughter of the applicant's ex-wife. The applicant was born in 1976. He was approximately 23 when he committed his first crime. He was approximately 30 when he sexually abused his stepdaughter. The applicant falsified his application by saying he had never been convicted of a crime. At his hearing, he stated that he falsified the application because he was embarrassed by his crimes. The ALJ recommended that the commission deny the application. The department recommends that the commission adopt the PFD.
Are there any questions for Mr. Rennick? Chair, entertain a motion.
I move that we adopt the PFD.
We have a motion. Is there a second?
Second.
All those in favor, please signify by saying aye.
Aye.
Those opposed say no. The ayes have it. Moving on. Robin Glazner.
Glasner?
We have one more, Chad Ross.
Jed Ross.
Okay, thank you,
All right.
thank you, I'm so
Sure.
sorry. It was already marked, but let's go ahead and,
All
let's
right.
talk about Mr. Ross.
Okay. The applicant seeks a consent tow truck operator license. This applicant committed 17 crimes in 17 years. I was going to list all the crimes, but I don't think I'll do that. I'll just go to his most recent convictions, which were in 2009 for theft of a firearm and theft of property, including a computer and jewelry. All of his pre-2011 crimes were guideline crimes for tow truck operators. By 2011, the applicant had been to prison at least 3 times, with his most recent release being in April of 2011. Nevertheless, in November of 2011, the department took a chance on the applicant and issued him a consent tow truck operator license. Approximately 2 years later, while still licensed by the department, the applicant committed another guideline felony, possession of methamphetamine with intent to deliver. He was convicted in March of 2014 and sentenced to 6 years in prison. His license expired prior to that conviction. The applicant was released from prison to parole on December 8th of 2015. Only 7 days after being released, he filed the application that's before you today. He was approximately 18 when he was convicted of his first crime. He was approximately 37 when he was convicted, and by 2011, he had been to prison at least 3 times, with his most recent release being in 2011. The ALJ recommends denial of this application. The department recommends that you adopt the PFD.
Okay, any questions for Mr. Rennick? No, I'll entertain a motion.
So moved.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
The ayes have it, and the motion carries. Moving on to item 13, Michael Terry, Terry Wrecker Services.
Mr. Chairman, this is Brad Bowman. I believe we have a continuance request on this one. That should be one of your, that should be one of the, should have that in front of you. It's a,
Got a blue tag on it, right?
yes,
Okay.
with F-13 on it, and then it's handwritten. The second page of that is a handwritten motion for continuance to research. And I believe the prosecutor was, or enforcement was opposed to that, so.
I'll withdraw that. I'll agree to the motion to continue.
Okay.
Since respondent's not here.
Do we have to have a motion for that, Brad? Or is there any discussion? Does anybody? No?
So moved to grant continuance.
Second?
Second.
All those in favor say aye.
Aye.
The ayes have it, motion carries. So we'll roll that over. Do we have a date? Did they, it's just the next meeting?
Next meeting typically is what
Next
we'll-
commission meeting? Okay,
We'll put it on the next meeting.
thank you.
Chairman, we got a lot done while you were gone.
See that? That's excellent. Man, he'd be gone more often. So we've got all the cases taken care of. We'll now move on to the motions for rehearing that are remaining. Let's move on to item G2, Cowboy Acres. Who'll be presenting that?
Do you want to address that one while you're?
Oh, yeah, while Charles is coming up, Commissioners, let's go back to item D, action taken out of executive session. We did have some conversation concerning a settlement offer that was brought before this commission. So if the commission would like to make a motion
I move we
concerning
decline
that.
the offer.
I'll second that.
We have a motion and a second to decline. Brad, I'm assuming we probably need to define exactly what it is, or is it sufficient to be able to do that?
We could refer to the case. I wouldn't necessarily, we don't need to talk about the particular
No,
details at this point, I don't think, but.
But we need to refer to the case, which is?
It is on the executive session item, it's the Merlin matter. C on the agenda.
Oh, I'm sorry, here it is. This is regarding the Merlin Transport DBA, Merlin Transport Corporation, DBA Excalibur Towing, cause number, that's the other cause, but we're not talking about the cause, we're talking about, is that the one we're referring to? D1GN 16005371. We have a motion and a second to decline the offer for settlement. All in favor signify by saying aye.
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 Those opposed, motion carries 5-0.
Do we have any orders to sign from earlier?
I'm sure we do. The orders will be coming up to us. It's for us to sign.
Okay.
So we'll get that going. Charles, let's move on now to G2, which is Cowboy Acres.
Question G2 is a motion to rehearing, filed by respondent based on a default order issued by the executive director, assessing a penalty of $3,600 against respondent for, unlicensed person at a, licensed storage facility, for, postal signs that do not meet the requirements of the rules of the statute. And there have been previous violations, which come to penalty up to $3,500. In the rehearing motion, the respondent does not allege any error. He merely explains to say that he is coming to compliance and that the penalty cannot be taken. And based upon the failure to,
You want to just swap them?
I didn't really need that. Based upon the failure to pay the inability to pay the penalty, he has requested a case be reheard. We recommend that it be denied.
While I recognize everybody that's in here, I'm assuming there's no one here representing Cowboy Acres. So, we have a motion, I'm sorry, we have a recommendation by GC to deny the motion for rehearing. A motion will be in order at this time.
Move to deny.
We have a motion
Yes.
and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on now to item G5. G5, I'm sorry.
Mr. Chairman, Commissioners, item G5 is another motion for rehearing filed based upon a decision, a default order issued by the Executive Director, assessing a penalty of $2,800 against the respondent for failure to maintain a manufacturer's data plate on a tow truck. That data plate is what's used to identify the capacity of the vehicle to tow various automobiles. And so in the rehearing motion, there is no allegation that he did not receive the notices. He alleges simply that he's requested rehearing based upon the statute, based upon the APA and the Commission's rules. And so based upon the failure to allege any error, we recommend that the rehearing be denied and that the Commission's order stand.
Any questions for Mr. Johnson? Motion be in order?
I'll move
To deny?
to deny. Motion for rehearing.
A motion to deny. All in favor signify by saying aye.
Aye.
I'm sorry. I guess we need a second too, don't we? I'm getting ahead of myself. We have a motion. Can I get a second?
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. My apologies.
Thank you. Thank you,
I-
Commissioners.
Thank you. Thanks, Charles, or Mr. Johnson. My apologies. Mr. Bowman, item number G8, which is Ronald B. Clark.
Mr. Chairman and Commissioners, this was a default order against the respondent for revoking the license for failing to pay a prior penalty of $800. The respondent has now entered into a payment agreement with the General Counsel's office, and as of yesterday is in good standing on that, on paying I believe has paid the first two installments of that. And based on that, we would recommend, what the Commission has done in these prior situations is to deny the motion for rehearing, but to probate the revocation of the license for 1 year contingent on being in good standing on the payment agreement, and that's what we'd recommend
Compliance with the
here,
laws. Okay.
and the standard terms of being in compliance.
So moved.
We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number G9, Tasco Storage Lot.
This was also a default order assessing a $4,700 administrative penalty against the respondent for failing to adhere to the employee drug testing policy, and also for charging an unauthorized fee. Because this is a default, the issue is, of course, notice, and in researching this, we found that The notices were mailed to the correct address. Apparently, the corporate status of the company was forfeited at some point, and so there may have been an issue with the address for the registered agent because of that, but we also mailed the notices to the address of record that we have at the department. So in our review of it, it looks like notices were sent properly and were properly addressed and sent. So there does not appear to be any error, and we'd recommend denying the motion for rehearing.
So moved.
We have a motion to deny.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank
Thank
you,
you.
sir. I believe that takes care of our motions for rehearing also. Is that correct? Did I miss anything? I'm sorry? Yes, that was taken care of before we left. Or I say before we went to executive session, my apologies. Okay, let's move on to item H, which is the state auditor's report. Commissioners, you have the state auditor's report before you that you've had an opportunity to be able to read and process. Are there any questions? This is simply a discussion item only. So if you have any questions, feel free to ask at this point in time. And I'm sure that somebody out there in their infinite wisdom has an answer for us. Nothing at all? Anything we need to know about it, Brad? Brian, I'm sorry.
I will just say, Mr. Chairman, that it's been really, it's been a good process. We've had a lot more dialogue on audits than we've had previously. And I do appreciate the feedback. Chairman Yurko has a way of letting things sit in your head a little bit. But I think she'll agree that just earlier in our discussion, I've been responsive to some of the concerns she raised, and part of that goes back to the training we've had. It's dissonance. You want to think that things are going well, and you just kind of hear it and let it sit a little while, and you come up with some ideas that can allow you to be better. So I'm grateful for the conversations that we've had, and I look forward to more.
All right, let's move on to item I, which is review and discussion of the internal audit report. Commissioners, you've received that information. We do have our IT department with us in the event that you have any questions. I'll be more than happy to answer it. We did receive a briefing from our internal auditors concerning, no, we did J.
No, we did I.
We did I.
Did we do it I?
We did I
We
and
did
J.
it earlier, there was really no discussion.
Yeah.
It was right after
Okay,
the first
moving on to item K. I'm way off base here.
I mean, if you
I
want to
will
review, it
catch
could be
up.
like Groundhog's Day, and we can do it again.
The problem is, I'm gonna catch up tomorrow. Item K, discussion and possible action, readoption of the water well drillers rules. We have the infamous Colleen with us.
Yes, good afternoon, Mr. Chairman, Commissioners. I'm Colleen Tran, Assistant General Counsel. I'm standing in for Della. She's out this week, so this is actually her program. So I'm going to read. So this is agenda item K, discussion and possible action on the readoption of 16 Texas Administrative Code, Chapter 76, water well drillers and water well pump installers as a result of the 4-year rule review. So the Texas Government Code, Section 2001.039 requires state agencies to review their rules every 4 years to determine whether or not they're still necessary. The rules implemented, these rules implement water well drillers and water well pump installers under the Occupations Code, Chapter 1901 and 1902, and they're scheduled for their 4-year review. The department has reviewed these rules, and we've determined that the rules are still essential in implementing the statutory provisions of Occupation Code, Chapter 1901 and 1902, regulation of water well drillers and water well pump installers. The rules provide details that are not found in the program statute but are necessary for implementation in the operation of this program. The notice of intent to review the administrative rule of 16 Texas Administrative Code Chapter 76 was published in the Texas Register on September 2nd, 2016. The comment period closed on October 3rd, 2016. We did receive 2 comments. One commenter expressed concern about the length of time it takes to get licensed, but he offered no specific solutions. And then another commenter suggested that fast baler operations should be under this program. Please don't ask me what that is. These comments will be provided to the advisory board for further discussion and consideration. And today we recommend that the commission readopt the rules at 16 Texas Administrative Code, Chapter 76, in their current form as a result of the 4-year review.
Any questions for Ms. Tran? I would make note that the 2 comments that we received really had nothing to do with the rules as it was laid out. I think that's probably stuff that we can consider or maybe talk about internally, but there's really nothing that, it didn't relate, actually it did not relate to the rules itself as it was presented. So, but we did receive the information, so if they're listening, they'll know that we did receive them, it just didn't, it was not pertinent to this particular agenda item. So, any questions for Ms. Tran? If not, I think they're looking at.
And there's a recommended effective date of December 1, 2016.
December 1 of 2016. A motion be in order?
Move that we adopt the rules. Number 16, Texas Administrative Code, water well drillers.
Effective December 1 of 2016. We have a motion?
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed? Motion carries. Thank you, Colleen. Let's move on to item L.
Why can't we make everybody that happy?
Item L, this is the discussion possible action of revised penalty matrices for the combative sports. And it kind of goes on from there, but it's considering combative sports, so.
Hello, my name is Charlotte Melder, and I will be addressing you on this issue today. And we have Chris Rusty standing by to bring things up on the board if you would like to see them. I believe you have everything in your materials, and there's nobody non-staff here to show it to you. But the combative sports matrix, the penalty matrix, has not been updated since 2007. As you know, there have been plenty of legislative sessions since then. The rules have been revised 6 times. On top of major changes such as the timekeepers and the ringside physicians no longer being licensed, there were a lot of things that needed to be changed just to get it up to speed. I worked with the board starting back in 2013 to make changes that didn't have to do with that. Mainly what it was I noticed that we were actually not testing for the drugs, all of the drugs that they were couldn't have in their system. And so we needed to get everything on par, made a lot of phone calls, figured things out, the rules were changed as a result. And now what we decided was there are some drugs that are in your system, and the work group, not we, the work group decided that there are some drugs in your system that don't necessarily benefit you so much, and some that really, really do. And there is a scale of how bad it is. And in the matrix that's currently in place from 2007 has it all in one location on the matrix. So what the proposition was and all the meetings and stuff were is to move it into 3 different classes so that you have, you know, marijuana and stuff in a lower class, but then your steroids and other things in the higher class. And so those are the major changes that you will see from this. I'm sure you've gone through it. But what we're asking today is that you please adopt this very outdated but to the new penalty matrix for the combative sports program.
I do have a question.
Yes.
Has the Combative Sports Advisory Board reviewed this penalty matrix?
They have.
When did they review it?
They reviewed it at their last meeting, which Mark will say is going to be September 30th, 2016. So the work group,
Newly comprised.
yes, with the new name.
Right, it's no longer the medical advisory,
Right.
it's now the combative sports.
Right, so it was that work group that was meeting, developing this for the last couple of years, and then once it was newly comprised, it went in front of the new ones. They adopted it and brought it to you today.
So they were simply updating the penalty matrix as it relates to the rules that have been changed and adopted.
Mostly. There were bills that were passed, there were rules that were updated, and then there was the change that I was telling you about with the regard to the separating out the drug violations into 3 separate categories.
Okay. Well, the reason I ask is it was my understanding that the Combative Sports Advisory Board had not reviewed these penalty matrix, but they have.
They have.
We're good to go then. So, effective date of when?
Immediately.
December 1.
No, this would be immediate.
Oh, immediate. Oh, wow, okay. A motion would be in order? Or not?
Make a motion that we accept the revised penalty matrix for combative sports.
I second that.
We have a motion to second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carries.
Thank you.
Thank you, ma'am. Staff reports. Well, let's do this before I start losing anybody. Let's move on to O, which is the advisory board. Sorry, not O. M? N. Move on to item N, which is approval of the appointments of the advisory board members. Commissioners, you had in your documentation appointments that I'm looking at making to the auctioneer advisory board and the dyslexia therapist and practitioners advisory board. You can take a moment to review that. I would also make note at this point in time that in our last meeting, we had just gotten word that Mr. Sample had passed away. Pretty apropos.
That's right.
And he had passed away. So if you don't mind, he was such a huge instrument and a huge part of the auctioneering world. And if you would join me real quickly, I'd like to have a moment of silence for Mr. Sample, as he was a pillar, not only for us and helping us, but also in the auctioneer world. So.
And a true gentleman.
And a true gentleman. I agree. So if you'd join me right quick for just a moment of silence for Mr. Sample. Thank you. Mr. Sample, you're being thought of. I just want you to know. In light of that, he was a presiding officer for the auctioneer board. I come before you now to recommend that John Swafford now be appointed as the presiding officer. And we do also have Joe Limley from Blackwell, Texas, Norman Seaton from Dallas, Texas, and Shelley Widener from Belvedere, Texas, to be appointed to the advisory board, auctioneer advisory board. I would make note that Ms. Widener will be the public member. So I would ask for your approval. Actually, let me go on to the other. Is the Dyslexia Therapist and Practitioner Advisory Committee is to appoint Beatrice Daniels, who's from Brownsville, Texas, as a practitioner. I would seek your approval in the appointments.
I move that,
Yes.
yeah. I move that we accept the appointments as presented.
We have a motion?
Second.
Second. All in favor signify by saying aye. Aye. Those opposed, motion carries. Commissioners, thank you very much. Now let's move back to our staff reports. Our esteemed executive director.
Mr. Chairman, thank you. I did not ask any of the directors to do a report, just particularly in respect for time. And I'll go through very quickly on some of the items I want to identify. Number one, on the phase one transition for Department of State Health Services, we're still continuing to have great success in that area. We are serving those new licensees well. We're getting the phones answered. We're issuing the licenses on time. But more importantly, the thing that I want to keep in mind, and the staff has done a great job, is that we have not lowered the quality of services to the other licensees. And there wasn't a dip in the time to issue a license for those groups. So we're able to provide that level of service for both groups. That moves me into phase two. So 6 more programs. Target date is November 1, 2017. Brad's staff did a great job of taking one of the things that's typically on my plate, which is to develop the very detailed timeline going all the way through the very last second of when things have to happen. And so phase 2 timeline, I just want to highlight a few of the dates that we have included on there. We will have a summit. We'll have multiple summits. So the first one's going to take place around January 5th, and we're going to have it in Austin, Dallas, and Houston at the same time. And our plan is to get out there where the people are and let these new licensees that will be coming to us know that we are accessible and available. It's going to look very much like the new commercial orientation, where we tell them who TDLR is, how we work, how the advisory boards plug into the process. We'll give an update on the phase 1 transition so they can understand that other people have gone through this dark tunnel called TDLR and came out on the other side with light shining on them. And then the last part of the day is going to look very much like a strategic planning session, where we're asking them, what do we do well? What can we do better? If you can make a change in a rule or a statute or a process that's currently done by the Department of State Health Services, help us figure out how we can do it better when you come to TDLR. So that'll be January 5th. March 6th, and we'll also solicit, obviously, rule changes. March 6th through the 10th, the general counsel staff will have already developed the reformatted rules for all 6 of those programs. And at the next series of summits, which will be on the 6th through the 10th, we will then say, hey, remember us? We're the nice people that talked to you in January, and here's what we're proposing based on the conversations we had in TLR's business model. What do you guys think about these rule changes that we're talking about? Get their feedback, then we'll publish the rules to get their the public comment on it, and then we'll have those rules in a public hearing on May 8th through the 12th, and then the rules will finally come to the commission on July 12th for their adoption, so you can kind of see the process running over the course of the spring and through the summer, and they'll be effective November 1, 2017, so we have that handoff date. But we're going to treat those folks the same that we did with Phase 1, which is reach out to them, get them involved, help them understand how we do business here and how we can provide services to them and really, really serve them well. That's a perfect segue into, in the last 13 days, we've received TLR has been the focus of 2 sunset staff reports. No good deed, as Chairman Ravi was butchering, or Commissioner Ravi was butchering several times, and then the chairman picked it up as well. The Sunset Commission on November 2nd issued a report that said, TLR, we think that you can do a job of helping the social workers, the marriage and family, and the professional counselors in taking all those programs from the Department of State Health Services. Just imagine that those are the programs that are still left over that they want to move from that organization. And so we are in the process of responding to that, and we'll respond to it this week. Just last night, and Kay will hand out this for you, just last night there was a report issued by the Sunset Commission staff that says, oh, by the way, TLR, those 3 that were in the report on November 2nd, here's 7 more that we think you can do as well. And again, I think that's just a compliment and a statement to how hard our staff works. But we are going to, and we're already looking at it, we're going to give it our best thought, we're going to give it our best look at it, and we're going to look at the resources we need. But I will give you a little bit of foreshadowing. We can't do 10. Not in the time period that's outlined there. We can't do that, and we can't do it successfully. So we're going to come back and provide them with a response that lets them know what we need and the time frame it would need to be successful. We're going to be mindful of the challenges that they're facing, but we're also going to be mindful of TLR's reputation and our ability to absorb, but most importantly, to execute. And the staff is, we'll have a town meeting and going over these on Friday of this week to talk about and just let folks know, as Bill would say, wait to worry. But I just wanted to bring the commissioners in the loop on that, and we are doing what we do at TLR. We're putting our best minds and our best thoughts on it, and we're looking at our organization, and we're rubbing the crystal ball and saying what can we do and how can it fit in our system and what changes do we need to make, and I'm already excited. The staff is rolling up their sleeves, and we're going to be successful as we always have been.
I would make note for the commissioners, if you go to page 13 of this report, that's actually the ones that is suggesting in phases, so.
And there'll be a test afterwards if you can say them all backwards.
So, I'm sorry, go ahead.
Mr. Chairman, on the 14th was pre-filing for legislation, so the session's already kicking in.
So we're already playing defense.
Already in there. And just a couple of notes, and on the first day of filing this year, there were 525 bills filed. And I just did a quick skim, and last session there were 371. I don't know what that means except for it's more. I don't know if the trend will continue.
Greater than last session?
Thank you very much, but it's definitely more. But we're ready for it. And not only are we ready for it, I want to introduce one of our new pieces in our government relations office, and I'd like Eric Beverly to stand up back there. Eric? Really happy to have Eric on board. Eric is a strong addition to our team. He's a fantastic writer. He's got the right personality. He's a creative and analytical type. He also wrote that first report that recommended the 3 programs coming to us. And we haven't figured out how we want to treat them based on that yet. But Eric's a great find for our organization. We've got a great team. he and Michael are gelling already. They're like swapping ties. It's just fantastic to watch them just take care of each other. So we're geared up for that, and we're real ready to move forward.
If you haven't had a chance to meet him, you probably need to. If you have a chance to meet the commissioners, I can tell you that I think it was probably an omen. I've kind of put the pixie dust on him that I met him. He was coming in for the interview. So I'm sure it's probably something I did. I'll take credit for it.
It had to be. It had to be. I'd also like to introduce what is my first hire in my administration. The first person that I brought on board as the executive director, and it's a fantastic hire. She is super talented. She's very smart, laid back, and she's a great leader. And we are so fortunate to have her on our team. I'd like to introduce Jody Ashlock. She's our new IT director, and you guys have seen the updates that I've given you on her. But what an amazing addition to our squad. She's turning red. Oh, Jody.
Well, she is now.
I'm sorry about that.
I'll take credit for this one also.
Pixie dust. Pixie dust.
Throwing a lot of stuff around, but it ain't pixie dust.
It's a little heavier.
I met her in the elevator.
Mr. Chairman, I'm going to move through swiftly and finish this up. A couple of more things I want to highlight is the licensed breeder advisory board work group met on October 31st. You know that there was a meeting that was scheduled for the board on November 14th, which would have been 2 days ago, or Monday. That meeting was canceled, and it was canceled as a result of the discussions from the work group. The work group decided that it would be better to gather more information through a survey. So we are developing and working on a survey that will go out to the folks out there in the industry, talking about the size of cages and just getting enough data to make some information on. That information will then go back to the work group for them to digest, and then it'll go back to the full advisory board. So we're looking at probably a late January meeting for the advisory board. But I think you can't go wrong with having more information and better information. And that's what this process is going to allow us to do. So we're moving forward with that. I want to thank Commissioner Yurko and the chairman for being involved in that. Well, she pointed, so I had to say them. So, yeah, I wasn't going to say them, but
I was involved in that one also.
Pixie does. And then the last thing, commissioners, I'll continue to update you along with Kay on where we are as we move forward with the workshop. I know that Brad and I are going to have some conversations with Commissioner Figueroa and the chairman about location, but we will give you as much information as we possibly can. We appreciate the response that we've had so far and the participation on the needs assessment portion of it. Mr. Chairman, that's all I have in my notes.
I have one question. Brian, I'm imagining there's got to be somebody in the organization that keeps up with the news around the state that pertain to our licensees. And I was wondering, who is that person? Who's in?
It's OSC, so as a group, you have Terry Western, who is monitoring all of the
OSC is?
Office of, I'm sorry about the acronym. Office of Strategic Communications.
Right.
So that group has a responsibility. Terry Western is monitoring all social media platforms. So if the word TDLR or auctioneer and those things come up, he's able to share that information.
Okay, and I'm guessing they give you a summary rather than inundating you with copy and copy and copy.
They only give me the snippets that I need. If there's something that needs to be actionable,
You can go back and
for
look at it.
example, just last week, and I won't go in detail because it was an entity that was before the board, but there was an article involving a towing company. And it came to me, I read it, and we did what we need to do internally. I made a choice not to provide that to the commission because I didn't want the commission to have that information in front of them because of the contested matters and that sort of thing.
I guess what I was getting at is, like, I was thinking back on it when TDLR did a big sting in Dallas on towing, and I would say probably 4/5 of the board had no clue about it because we don't live in Dallas. And so I just wondered if we might be able to have, even if it's under the umbrella, something that gives us a little update if there are things going on around the state. Like, for example, there was, during public comment, there was a person who came regularly, and then there was an arrest in Austin, and I'd say probably three-fourths of the board didn't know about that one either. So I just thought it was kind of nice especially when you live in different areas of the state, to be able
Be
to,
notified?
yeah, just kind of get up to speed of what's going on in other areas. I don't take the Dallas Morning News and the Houston Chronicle and whatever's down in the
Right.
valley, and it just would be nice to know what's going on if it pertains to our agency.
I'll coordinate with Jeff and see what we can do on some in the news. I would just tell you that, and you know this better than anyone, with the speed and the velocity of news today, it's Twitter, and it's in and out, and just, even when we get it to you, it's already old, if that makes sense.
Well, yeah, but it's not that we're trying to get it cutting news. It's just to kind of
Things
keep
that
up
are
to speed
curious.
so we know what's going on
Sure.
around the state. Because I'm assuming they're keeping you up to speed, so it's not like we're asking for additional work, just maybe kind of be included
They do a
in that
fantastic
loop.
job, but some of it's informal.
Yeah.
They'll come up and say, Brian, here's an article, what do you think? I'm like, okay, good, don't need to do anything, and I'm moving on to the next issue.
Yeah.
There are some that I will bring Christina Kaiser in and say, hey, Kaiser, what's going on here? Do we have a case open up on this situation? But the velocity of it is so quickly that I'm not asking them to give me a weekly report. They're in tune with what I want enough that they're bringing up informally. It's in my inbox. Rhonda will bring them up to my attention. But I'm processing it probably in a minute or 2 minutes and moving on to the next thing.
And see, Brian, and that'll tie into the communication plan that, we've talked about before. So, I mean, just like last night, received a text from Susan on the Regency scenario being highlighted on Fox News. So that was a positive story there.
Absolutely.
Yeah. And I don't know if anybody had a chance to see it last night. Fox News had a story real quickly, Regency Beauty College
Correct.
closed its doors, and the enrollees of the college were left high and dry.
Right.
Fox picked up the story, one particular individual that they kind of concentrated on, contacted Susan, who contacted Ray, who contacted the individual and got that person enrolled in another college so they could finish, because she was only like 17 hours short.
Right.
So she finished, she took her test yesterday at PSI, passed.
We were grateful as the
Right.
cameras were rolling when she looked at the
Exactly.
page.
Yeah, it would have been bad had she not.
She
She
was-
did, she passed. And we found out also is that another college has given her a scholarship to complete her instructor license.
Wow.
So it was a feel-good story.
Very good
Fox
story.
News here at Austin carried it yesterday. You probably go out maybe on their website and find it.
Well, Mr.
Uh,
Chairman, if you're kind of cutting into my update number 6.
I've
which
already
will be
covered
the
it.
Regency update with the link to the article.
I've already covered it. So
But anyways,
anyway,
that's kind of what I'm talking about.
Right.
It's not necessarily what bad things are happening, it's just
The
more
feel-good.
like just to know what's going on in the state.
Absolutely.
When something happens.
Yeah.
and I would also,
You guys are gonna
if you
get that.
can, I attended, I'm gonna do it again. I attended a tow truck,
Roundup.
a roundup. And if there's one in somebody like in Houston or in Dallas or in Austin or something like that, notify the commissioners, because it's a great, I went out there on a Saturday. I was actually happened to be in Houston, and they were doing a roundup there, and I was contacted by Susan. She said, hey, if you want, we're gonna be out here. I showed up. It was great to see how they do it. I directed them, telling them what to do. No, I'm just kidding. I wouldn't know. I wouldn't even know where to start. So, yeah, the Pixie does again. Yeah, I conducted a tow operation. So, but anyway, I think it'd be good for the commissioners just to go out and see what they do. So, just pass that information on as we get to it.
We'll try to coordinate as much as we can as we get closer to session.
But we can't, of course, all show up at one location without having a
Well,
meeting.
exactly.
So Brad kind of frowns on that one.
And Brad all nervous here.
Oh, no. What else?
Mr. Chairman, that's all.
Did I take away
have
all
on
your
this
thunder?
end. That's all I have.
Okay. No more thunder
Wait a
for
second,
you then, right?
Janae, do we have anything else? We good? All right, we're good.
Okay. Move on to the advisory board reports. Do we have Mr. Kopus? Don't leave. He's got something to tell you.
We have Google Alerts set up
Uh-huh.
for all of our programs, the commission, Brian's name. So at any time any of that is mentioned in print, online, we get Google Alerts about that.
Oh, cool.
And it's kind of like a summary you get every day, you get an email. It's can vary from 3 to 5 to
It
about
just
6
relates
mentions.
to the TDLR, doesn't relate to anything else that we're doing?
Just to the programs. Like I said, the commission programs and Brian. So A lot of times it'll be repeats of the same thing. You'll see one story and it'll be repeated in several different newspapers. But I send those to the strategic communication team, and if you'd like, we could copy you on those.
Oh,
and
I think that'd be wonderful.
yeah,
'cause I'd love to
because
do
it is
this.
things like that where it's, you know,
That'd
news
be
stories,
great.
both good and bad.
Just blind
So,
copy everybody.
Right.
Yeah, sure.
Cool.
Glad to do it. Okay, so the advisory board report, driver training and traffic safety advisory committee met on October 20th. There was a education summit that was moderated by the driver education and safety program staff. They focused on the next phase of the driver education and safety rules and curriculum, also known as Program of Organized Instruction. They discussed the current state of the Program of Organized Instruction and what could be added, changed, deleted to be made better. And October 25th was Air Conditioning and Refrigeration Contractors Advisory Board. That was an open meetings training conducted by Assistant General Counsel Doug Jennings, and public comment received supporting the rule adoption of the Uniform Code. Architectural Barriers Advisory Board Committee met on November 9th. They received APA training by Colleen Tran. Public comment from the Carol Pruitt of the Accessibility Professionals Association. An introduction of Commissioner Helen Collier. And rules discussion led also by Colleen Tran and for 16 Texas Administrative Code, Chapter 68. And they set up work groups as well.
Colleen's becoming a superstar.
Her name's mentioned a few times here. And then, as you heard, the Licensed Breeders Advisory Board for November 14th was canceled. And that's all we have for advisory boards.
Well,
Okay.
Vice Chair, you have any questions? Thanks, appreciate it.
Thank you.
I would make note that we had discussed having HIPAA training for the commissioners. Didn't get it our last meeting, didn't get it this meeting, but we're currently trying to figure out how we can do it online.
Correct.
For the commissioners to go in, and of course, there'll be a test at the end also. Anyway, for us to do that, because I think it's still imperative and important that we understand HIPAA and how it applies to us now, that we have a lot more health-related programs to us. So kind of expect that coming your way.
And Mr. Chairman, I think, you know, the train that we're trying to work on, we definitely want to make it convenient for the commissioners to access it. You know, one of the things to keep in mind is it's not necessarily that you have to be trained on it. It's just the conversation and the disclosure of it. Quite often, it's just not talking about the details or soliciting the details from the folks that are in front of you. That's going to be the biggest challenge, because if you don't say it or you don't ask them to say it, then you're fine. But if you get those disclosures out in public, even for that, and it's tough because that point of curiosity is there. So tell me a little bit more and how that turned out for you. Then all of a sudden, that's when it trickles out. So I think the training you're going to get is realize that there are federal and state provisions that say don't do it and don't talk about it. And then the compliance really is don't talk about it or submit it. So it's I think the training is going to be very straightforward. It's not going to be anything new or enlightening. It's just going to make you a little bit more aware and cautious about when to stop asking a question or stop gathering information.
All right, moving on to public comments. Is there anyone present for a public comment? Okay, moving on. Item Q, which is discussion and date and time of meetings. Right now, we are set for a January 18th meeting. Right now, I think that we've got a March 1st meeting and a April 5th meeting. So kind of put that into your calendar, and we'll go ahead and work on the next meeting after that. But of course,
January 18th, I'm sorry, March 1st?
January 18th, March 1, April 5. And then the next meeting after that, you can assume it's probably going to be somewhere about early to mid-May.
Correct.
And then, of course, we'll have a post-legislative meeting after that, kind of let us know. Again, I would just advise the commission, we are embarking into legislative session. So kind of be prepared for that. We should be getting some information and tracking from bills that have been filed that affect TDLR directly. Jeff and his group do a great job of providing that information, so we'll continue to do that. I would also make note to put on your calendars, January 27th and 28th will be our commission retreat, or workshop, or gathering, or however we want to term it. But we'll be meeting then to kind of talk about the future of TDLR and how we see it, kind of as we've termed it, a TDLR 2.0. So under the new regime of Brian Francis. So if you have any questions, comments, recommendations, please get them to Brian. I'm sure he'll be able to pass it on to us as we kind of take a look from a 50,000-foot level. So that being the case, I think we've taken care of everything, haven't we? We can't take any action, that's for sure. So,
I'm actioned out.
so am I.
Is this the perpetual meeting, so we can't even adjourn, we just have to
No.
just stay here forever?
No, I'm not even gonna ask for people if they want to adjourn. I'll just do it if I want to. But you know, it may be a great time just to hear from staff.
Let's do it.
What do you think?
Let's do it.
We're adjourned.